We are live. We are live. Welcome to PATC Breakfast, Leon County, Tallahassee, Florida, Florida State versus the ACC. Welcome in to college football's Peek Around the Corner with your host, Greg Pflugar. We cover everything in college football because we love everything in college football, and if you do as well, please subscribe to our channel. Smash the like button. If you like our content, smash it right now if you are happy to be here. If not, well, I do apologize. This is what we're covering today, Leon County, April 9th, 2024. If you want to support this channel to help us keep the lights on through a donation, please put down a comment, hit the $, and I'll get to you super chat as quick as I can. Welcome into the studio that sits on the corner, the very corner of Keith Jackson Parkway and Kurt Gowdy Avenue. Do not be afraid. Do not be afraid to be a legend in the chat room or with the phone calls later in the show. Now, we're going to do the best we can here. I am going to lean, like I always do, the fat guy from Minnesota. Unfortunately for everybody in the chat, everybody in the PATC community, the Peek Around the Corner college football's Peek Around the Corner community, unfortunately, the fat guy from Minnesota leans on all of you pretty heavily. As you feel the weight, I need you. I need you to keep your head on a swivel. Put it in the chat or send me a DM. Reports throughout this morning on the court case in Leon County, Florida State versus the ACC. I'm going to be keeping my eye on the updates from Florida State 247, from Matt Baker, Tampa Bay Times. Let me know on X, formerly known as Twitter. It's starting right now, so let me know. I want to thank everybody who's come on in. At the beginning of our live show, Clemson alumnus is here. Jay Go Blue. Dave Capusta is here. Matthew Carlson. Suzanne. Carrie Go Nose. Gator Hater. Mr. Buckeye. Jared Jones. Matt Neeson. Kirk Bender. Mr. Terrapin. D5 Terps. Chief Fan. Let's Go Mountaineers. Jan is here. Jeff Olson, the evil badger. Holy smokes. JD Turtle. John Till is here. Tumasta is having breakfast here with PATC. Chad Deese. Okay, yeah, you're right. I gotta follow here. Denise, I gotta do that. Let me write that down. I don't have that set up. I do not have that set up. Thank you so much, Chad Deese. I'm going to get to that right now. I appreciate it, Chad. Jim Reese is in the house. Randy Taylor. Stephen McNeely. Young Seminoles. Gold Nose. Bob Swager. The Architect is in the house. Do not be afraid, ACC, to get worked. Wow. DP is in the house. Purple Freak, let's get it on. Okay, let's hold on, everybody. Hold on. Okay, we're following Danielle. Come on, baby. Come on, have this work for me. What's going on? What is going on? Here we go. There is an in-house feed, but people in the courtroom don't know if there's a general live feed. People are settling inside the courtroom now. That was 30 minutes ago. Alan Lawson, the ACC top rep. David Ashburn, Florida State's top rep, are both seated, both sides with deep legal teams, around 8 to 9 seated. For the ACC, 4 currently seated. For Florida State, it's 9 versus 4 when it comes to the lawyers. The courtroom has a decent crowd. Set to begin momentarily. Carolyn Egan, among those on the Florida State side. She's the general counsel for Florida State. Okay. Hold on here. Okay, we got that set up. Bear with me, everybody. Bear with me here. This is not. We're trying to find people in the courtroom. We're going to take that one off. A couple people thus far that we believed was going to make comments have not done so yet. So we are going to go back here. I'm going to do this a little bit differently. Going to do this a little bit differently here. Here we go. Okay, this is better. Okay. Judge Cooper has arrived. Judge Cooper has arrived. Ladies and gentlemen. Ladies and gentlemen, Judge Cooper is in the house. Not in this studio, but in the courtroom. Okay, so we know that Judge Cooper has shown up. This we do know. So we haven't missed anything, ladies and gentlemen. We haven't missed anything yet. Okay, we are going to monitor everybody that we know. Brace for impact. This is great content. Well, you know, it hasn't started yet, so we haven't missed anything. Judge Cooper just arrived. Look, we are at the mercy here. We are at the mercy of people reporting into the courthouse. We're going to give you the information as quick as we can, and we're going to give the reporting of people's analysis about it. If you find somebody on X or somebody somewhere out there putting out good information, let me know in the chat or DM me on Twitter. DM me on Twitter. Direct message me. PATC court now is in session. I don't know. If you don't, if you want to waste it somewhere else, be my guest. The court case has just begun. Holy smokes. West Virginia getting hit with tornadoes. Young Seminole, ACC riding deep because they caused the stare. Here we go. Now, Rock and Rant. Rock and Rant. Are you in the chat? Are you in the chat, Rock and Rant? Is that going to go right to the live stream? After the, oh, it is. It is going to go right there.
Case, motion to stay discovery, and 3 notice motions for or requests for judicial notice, 2 from defendant, 1 from plaintiff. Anything else?
This is a live stream.
The plaintiff has requested in his, I think, response to the motion to stay discovery, judicial notice of some documents from the North Carolina case. Is there any objection to that from the defense side?
No objection, Your Honor.
Okay, I'm going to grant that motion with the understanding that I'm granting it as representative of documents that have been filed in that case. I'm not taking judicial notice of a fact that doesn't have to be proved, and I'm not finding that these documents, some of which are voluminous as we get further on, are relevant or admissible or persuasive, but they're just documents from another court case, in this case, to be used by the lawyers as they deem fit, and if they refer me to those documents, I will then review them and consider those. So, same thing as to the other two. To the plaintiff on the motion by the defense, I'll call it the large motion for, I'd say it's about like that. Any objection to that?
No, Your Honor.
Okay. I've looked through it. Again, Mr. Lawson, they appear to be primarily, if not exclusively, pleadings from the North Carolina case.
That's correct, Your Honor.
Okay. Also, the second motion appears to be the opinion from the trial judge in the North Carolina case, and I'm guessing it's in the 70s page length.
76 pages, Your Honor.
76. So is there any objection to that?
No, Your Honor.
Okay. So while I've reviewed these materials sufficiently to determine if there was any problem with taking judicial notice, I've read some in detail, some I've not read. The opinion from the judge in North Carolina I've not read at this point because I felt it would be better that I did not try to consciously or subconsciously try to move myself for or away of any reasoning he did or didn't make. So I have read some of the affidavits attached to the plaintiff's response to motion to stay, and if you'll give me a minute, I'm going to have to change the setting of this computer from another judge to me. Judge Everett now. It says restarting. I don't know what that means. Well, I'll go without the computer for the time being. It's on another judge and it says it's restarting. I'm not sure why, but it is. So let me make a note. Here we go. Okay, all three requests for for judicial notice. Granted with comments on the record. Comments by me on record.
Thank you, KS Bear
All right,
Fan, for becoming
It
an
might help
early
if
peak
we just
member,
go down the
Cloak and
line
Dagger
of
member.
starting
I
with
do
plaintiff and everybody
appreciate
announce
KS Bear
themselves.
Fan.
So I'm going to try to write down,
When you have a
I
chance, you can go
know
watch
many
our
of you, but
early
I'm going to
peak
try to write
members
down your names so
episodes.
I don't
Appreciate it, sir.
get it wrong or
You will
misstate
be
it in the heat of
officially
the argument.
knighted
Yes,
once
sir.
we get through this court case,
Good
and
morning,
I can
Judge
go
Cooper.
through
I'm
the
David
super
Ashburn of
chats
the law firm of
and
Greenberg
memberships.
Traurig.
Thank you,
And I have
KS
with me here my
Bear Fan.
colleagues,
Appreciate it,
Pete
sir.
Rush to my left, John Londot just behind me, also of the law firm of Greenberg Traurig.
Okay,
And then also we have with us Carolyn Egan, who's Vice President for Legal Affairs and General Counsel for Florida State University.
Carol Egan.
Carolyn. And Judge, we'll make it easy on you.
Let me know in the chat if the volume is okay.
Okay.
I'm not sure there's anything I can do more about it. Is the volume okay for you guys? Yes or no? Y or N? Let me know in the chat.
I'm normally not a big note taker, but I've decided to take a few more than normally based on the volume. Mr. Lawson.
Alan Lawson with Lawson Hutt Gonzalez.
Okay,
With
good.
the Atlantic
Good.
Coast
I'm glad
Office
it's
with me is
okay
my partner,
because
Amber Nunnally.
Mhm.
I don't know if
Well,
I could have done anything. I don't think I can boost it anymore.
Donnelly,
You know Miss Nunnally.
Hauk.
Pearl House.
Thanks, guys. Thanks,
He's the general
guys and
counsel
gals.
for the Atlantic
Appreciate
Coast
it.
Conference.
Okay.
And then Jim Cooney,
Hello.
who is North Carolina counsel. He's been admitted pro hac vice in this court and is counsel in the case as pending in the Mecklenburg court.
All right. The one thing I did notice, Mr. Lawson, is the judge up there apparently has a law clerk who works for him.
Yes, Your Honor.
As you know, I don't have any court staff that works for me.
The North Carolina courts have a business court division that is staffed with law clerks, and that's a privilege that we don't enjoy in Florida, as you know.
All right, so don't expect a 76-page order out of me because I don't have a clerk.
I'll take a one-page order, Your Honor.
Well, my goal is to try to get through everything today and rule. I like to rule the same day. I spent a lot of time reading
Holy smokes!
what you presented. I've looked over everything.
Holy smokes! He
I've
wants
read
to
your key-
rule
your
today.
key memos multiple times. I've read the cases. And on a couple of points, I did some of my own research.
Holy smokes!
So, let me see if I can.
He
Get
wants
this
to
computer.
rule today. He wants to get through this.
Well,
He's prepared.
yeah.
He's read.
It's on except for Judge Everett right now.
And it's
I
not
don't
going to
think
be a
he would want me to put notes
76-page
on his
ruling.
stuff,
He
so
doesn't have his own
Let's
staff.
see how we do.
Holy smokes.
I'm ready to hit that button.
Wow. Wow.
Thank you.
They can't get the computer working. He doesn't have a staff, but he is prepared, ladies and gentlemen.
I know this computer has
Holy
stuff in
smokes.
it. I've used it before.
Now, we don't know. Look,
I think it'll be fine. I think it's updating some software.
I'm
It's
not going to
doing
talk
this.
much. I'm not going to
So,
talk, but they're trying to
I
get the
have
computer
in
to work. So
Paper,
let's talk about what just
in
happened
addition to
here.
your notebooks,
The
thank
Judge
you.
Cooper said
I
there's not
tend to
going to be a
prepare my own
76-page
notebooks,
ruling. He doesn't
too,
have
so
a staff like the
computer
business
issue,
courts in
it
North
doesn't really slow me
Carolina.
down.
He's prepared,
We're
he's read
set for an hour and
everybody,
a
he
half.
knows what's happening here. He wants to make a
I'm a
ruling
little
today if
skeptical
possible.
that we can
If
finish an
possible.
hour and a half, in
Ruling
an hour
today.
and a half.
That is your breaking news.
I have the day open, so I don't want to feel that either side is constrained and can't make an argument within an hour and a half. I'm not suggesting that we have to go past an hour and a half, but I have the whole day.
Holy smokes.
So it says please wait, so I think we're in good shape. Okay. So, Mr. Lawson, these are your motions, so, oh, here we go. Tell Mike, never mind. All right, it recognizes me. So as it goes, I'd like us to go in general with where you want to generally go. What I'd like to do to the material here, I'd like to go, if possible, in segments and hear the parties argue as to that segment instead of going through every argument you have and then asking the plaintiff to go through its response. And I think I know, it depends on where you want to go. I know we're going to need some time on the motion to stay, I guess motions to stay the case and stay discovery, but they seem to have the same legal principles.
May I approach the well?
Yes.
This looks like a very complicated case, and in many ways it is. It raises many...
Well, the briefs are long.
They are long, that's right. I'm going to try to simplify it and suggest that the decision that you have to make today is very simple. May I approach the bench, Your Honor?
Sure.
Provided this to opposing counsel.
All right. This is the shortest thing I've gotten from your firm so far.
And it's that first page that...
Oh, this is your stay motion.
That's the stay
Principles of
motion. I'd
priority.
like to start with the stay motion under Florida's principle of priority.
Okay, that's the one area that I did some of my own research in
Okay, very
addition to
good.
what I got from everyone else. I received, hold on a second. I received, here's the FSU's response. Here's let me get your motion to stay. This is my notebook. And I have it in your notebook too, but I have your motion to stay. The motion to stay portion of your motion to dismiss or stay.
Yes.
And that's my research on motion to stay.
Very good.
So, all right, I'm ready.
In Byrne versus Brown, the first case in our hearing notebook at tab 9, the Florida Supreme Court long ago said the rule of law is that where two courts have concurrent jurisdiction, the right to maintain it attaches to that court which first exercises it. And we've talked this morning already about the two different cases. And the way the case law treats it really is one case. It is one case, one dispute. It involves the same set of facts and will involve, once the FSU responds in North Carolina, the same legal issues, and all should be considered. And so what we have is one case with courts that have concurrent jurisdiction. When that happens under well-established Florida law, the test for jurisdiction is who exercised that jurisdiction first, and it's a service of process test in Florida.
Oh, okay, time out.
Yes, sir.
The Siegel decision,
Yes.
which I'm sure you're going to quote to me, 575 Southern 2nd, 1267, I think about 91. I didn't write that down in my notes. States the general rule, but says there are exceptions.
Exceptional circumstances.
Exceptional circumstances. Every case I found indicates that forum shopping and anticipatory suit constitute exceptional circumstances. Now, I looked all over the country, in addition to ones the plaintiff stated, and I found another case, it's 3rd or 4th DCA, I can give you the site, it's here, that, it might be right here. Oh, it's in my research book, I think. There's the Siegel opinion. The problem with all the stuff that I had been provided is finding it. Let's see if my
Hey,
notes
Rock
are
and
good
Rant,
enough for me.
Rock and Rant, thank you so much. Thank you so much for your help this morning. I do appreciate it, Mr. Hurricane Rock and Rant. Thank you so much.
I think it's the Sanchez case. 306 Southern 3rd,
Good morning,
1098,
Jen Knoll.
2020.
Good morning, Jen Knoll.
Where did I
Judge
put
Cooper has already
Sanchez?
stated he wants to rule today. He's come prepared.
It's possible it was cited to me, but I don't remember it being cited.
Even though he can't find his notes and his computer doesn't
My
work,
memory of that
Judge
case
Cooper has come prepared, ladies and gentlemen, to possibly
is
rule today.
this. There is a set of rules that when there are two suits in the same state,
Correct.
and that's where the court that first exercises jurisdiction, that standard is used. But it says when it's a suit between two states, that standard is not used. And then they look at what I call the priority or the first to file standard with whatever exception. Under any standard you have, the exceptions apply throughout the country. It's not just, and that's true in North Carolina. There are cases cited by plaintiff. That's true in Florida. And
Benjamin
it's
Hawks is
true
Cooper
throughout
is
the
keeping the
country,
case.
state and federal court. I have those cases.
Space Ghost prepared, quote unquote.
And I think other than the Sanchez case, if you shepherdize that case, you're going to find one or two other cases that say the same thing. And you give me enough time, I'll find it. But when you say it's the court that exercises the first jurisdiction,
That's
I
correct.
have to stop, because when I read that, I said, oh, this is easy. But it's not that easy, because this is a case between two sovereign states, in two sovereign states, so the rule of comity applies, right?
That is correct.
And didn't Sanchez, or at least several Florida cases, which are district court cases at least, which I'm bound by, they have expressly declined to extend the first exercise of jurisdiction rule to those type cases.
Your Honor, I do not believe that to be correct. Our research suggests that it's uniform, whether it's a federal court and a state court, another state court and a state court, or two different state courts. The rule of comity applies and provides the principal priority dictates that the first court to exercise jurisdiction retains the exclusive right to hear the questions and issues arising from the case.
All right. Well, we're going to have to stop and let me get that case so
Okay.
you and I can discuss it. Just a second.
And I'd like to discuss another case that we have
This
cited.
is set for 90
now,
minutes.
you are
Ladies-
assuming
ladies
I
and
can
gentlemen,
do
this
two
is
things
supposed
at
to go
once,
on for
aren't
90
we?
minutes. But the judge says
Okay,
it
Sanj-
could go
let me see if
longer.
I'm
It
right.
probably
Here's
is
the
going to go
Sanchez
longer.
case.
And the judge says he has all day. He has all day, and he wants to make a ruling today. So we're off to a slow start. We're definitely going to go over 90 minutes. But the judge has all day. And ladies and gentlemen, PATC's not going anywhere. We're going to be covering as long as Judge Cooper is sitting in that chair. And then when this case is over, we're going to be taking phone calls, your comments. We'll get to you super chats. I do appreciate it. The new memberships,
have
we'll
that
get
many
to it
cases in
after
here,
all
so I
this
should
is
be able to
done.
find it.
That will be our first priority. Then your phone calls. You are with us. PATC breakfast. Judge Cooper, Leon County. Cooper has already said he wants to rule today, and he's pushing back. He's pushing back a little bit on the
So
idea.
I'm looking at the case.
that the
In general, reports
jurisdiction
within one
has already
sovereignty
been
have
decided.
concurrent jurisdiction over substantially
And this
similar
is my
parties and
take on
claims.
it.
The court which first
This is my
exercises
take
it
on it.
requires
He's
exclusive
pushing
jurisdiction
back
to proceed
on
with the
Lawyer
case.
Lawson,
It's known as the
representing
principle
the
of priority,
ACC. Let me
And
know
it
if
is
you've got a
not
different take
applicable
in the
between
chat.
sovereign jurisdictions as a matter of duty. That may be the language you're talking about.
Yeah, but that's not the explicit case that I found. This is like a football game where we have to take an injury timeout. Sports
It's like a
metaphor.
football game, injury
Because
timeout.
the case is here. And I will find it.
All right.
Let me see if it's in my notes.
Off to a slow start. We've already had some breaking news. Judge Cooper wants to rule today. He says it's not going to be a 76-page ruling. He doesn't have his own staff. He's well prepared, although he can't find what he needs to find in his notes. His computer in front of him doesn't work.
This is my research file.
Charlie Gagan says more like a needle in the haystack.
And I would say that, of course, we looked at every Florida principle of priority case that we could find. And I
Road
believe that
132F and
Okay.
it's not only exhausted, but
Someone tell the
complete.
judge
And
not to be
This
afraid
is the
to be a
Perelman
legend. And get his
case,
papers
124
in
Southern
order.
3rd, 983.
124, so
124 Southern 3rd, 983.
Okay, here we go. Here we
4th
go.
DCAF, Florida, 2013. And if you go to head notes 2, 3, and 4, you have to read that plus head note 5 and 6.
Okay.
Let me find it.
I'm with you.
It states the principle of priority. You see head note 2, it states the principle of priority, and then it says, admittedly, this principle is not applicable between sovereign jurisdictions as a matter of duty. As a matter of comity, however, a court of one state may in its discretion stay a proceeding before it on the grounds of the case involving the same subject matter, etc.
Okay.
And then it goes into some more detail.
And with respect to that statement, it's very interesting. I've thought about this. The courts say it's a matter of discretion, but then routinely say Florida crushed stone is one of the examples at tab 11 of our hearing notebook that says it is an abuse of discretion to fail to follow that rule of comity. unless there's a finding of exceptional circumstances. So that's the law. It says it's
Okay.
discretionary, but there's really not a lot of
I
discretion.
get it. It's discretionary unless I disagree with you. So let me go on just above head notes 7 and 8 in Carrollman. And I want everybody to understand, I at least take seriously the requirement that I follow precedent
Yes, sir.
of Florida courts. Maybe I'm old-fashioned, but this is an unreversed district court case, and unless you can cite to me a first DCA case that's different, I have to follow it. So it's not up to whether I agree with it or not. So here's where it says. It starts about, in case of conflicts between courts of concurrent jurisdiction, the one first exercising jurisdiction acquires control to the exclusion of the other, and that jurisdiction attaches when summons is served. I'm going to try to translate that into plain English. I think that means courts of the same state, concurrent jurisdiction. It says, quote, however, these cases address priority as between, I didn't just pull this out of the air because I read the next line. However, these cases address priority as between, and it italicized it, it's italics, between two Florida courts with concurrent jurisdiction. We decline to extend their reasoning to priority contests between two states. Accordingly, we must look to Pennsylvania law to determine when Pennsylvania first exercised jurisdiction. And if you read the case, you'll see that I think it was like a couple of different states. But the point is, the first exercise said, I went for a day. Mr. Lawson saying, first exercise test. Then I read your memo and I said, he says, they exercise. He said, they have jurisdiction. And I thought to myself, he didn't say they exercise jurisdiction. I read, and then I read the Perelman case. I said, well, everything I was thinking about what the test is gone because I have to follow Perelman.
Judge Cooper says he has to follow the case in Florida.
Someone may have cited that to me.
Shows it has been reversed previously.
But I think I found it by shepherdizing other cases that were in the briefs. And this is not.
In almost every case that I looked
But
at,
here's the crunch.
Tell me where I'm wrong.
Whether you
Judge
adopt
Cooper
the first exercise
seems
of
to be pushing
jurisdiction
back
or
on
the first
lawyer
to
lawsuit
file or
from the ACC.
whatever descriptions. You
My
know there are lots
description
of
what's going on
descriptions
here
for
is
the
Judge
first
Cooper,
to file situation.
right out the bat is saying
In
jurisdiction
every instance,
has
there's an
not
exception
been decided.
for certain
I
circumstances.
got to follow the laws of the state of Florida.
Almost every case
Let
I
me
looked
know
at
in the chat
talked about
what you're thinking.
forum shopping. So tell me where I'm wrong, because in oral argument, I'm here to be shown stuff I don't know, because there's no way I can know what you know about this case or plaintiff's counsel. So, sorry to interrupt you, but that's what I meant. We're going to do this in pieces.
Absolutely. Reliable Restoration LLC, which...
That's the first district case.
That's the first district case from 2021, and it was between Florida and Georgia.
But it cited the Siegel case.
Judge Cooper
That's correct.
already knows.
And the Siegel case says there are circumstances, and it didn't enumerate them,
Shopping, which
Right.
the
in which
ACC
you can
did.
deviate from the rule.
So we had two issues. One is you've raised the issue of whether the comity principle of priority in Florida is mandatory and has to be applied when we're talking about jurisdictions other than local Florida jurisdictions. And that's what I was looking at reliable resources for. And there are other cases that apply Siegel when we're talking about comedy between a state court in Florida and a federal court inside or outside of Florida, or another state court, or even
This is the
the
ACC
Sanchez
attorney,
case
Attorney
that you
Lawson.
just cited, expressly says that that applies not only to other states, but to foreign jurisdictions. In Sanchez that you cited to us, it was Spain, and the principle of priority was applied. So that's issue number one, and then when we finish that, we could talk about exceptional circumstances.
But Siegel itself, which the first district cited, and Siegel's the law for me on this issue, because it's the Supreme Court, and I follow Supreme Court decisions.
Yes, sir.
This quote, this is right at the end, quote, "This does not mean that a trial court must always stay proceedings," and it's talking about priority. And then it says, a failure to grant a stay could be justified upon a showing of the prospects of undue delay, and there may be additional factors or circumstances which also warrant a denial of the stay. As you probably know, a lot of courts and a lot of, like, at least a couple of law review writers are trying to figure out exactly what they mean. I think what they mean is all the innumerable reasons that are in the case law throughout the country.
Judge Cooper is citing the Siegel case that went to the
I had
Supreme
one
Court,
that I
where
wanted
the
to
court
read to
made
you.
rulings pertaining to jurisdiction.
Sorry.
Judge Cooper
As
says
you
he
said, we have all
follows the
the-
Supreme Court decisions with
It's
regard to the
surprising what,
decisions they make.
when I started as a lawyer, and I'm probably the only one in here, we did not have computer research. So I used to go to the law school and look into Decennial Digest and research the ALR indexes. I don't do that now physically, but online, I still look for resources such as that. That's the wrong one, that's your book. Where is it? It might be right here. No, that's not it. This is it. It's not as big as the other one, but it's still big. Let me look at my note. I want to read you a case.
I know we're not supposed to overreact on the comments that the judge makes during discussing all these pleadings, but everybody's having the same reaction who was following this case on X, on message boards, on 247. Judge Cooper, right off the bat, is pushing back on the
So,
ACC.
I have a
claim
number
that
of
the
cases
jurisdiction-
tabbed
This
here.
has already been,
And
it's already been resolved.
interestingly,
Judge Cooper
these are patent
saying,
cases.
Nope. Nope.
and you might think, why is he quoting a patent case? Well, in patent cases, you have two entities fighting over a patent, and they're trying to get the best position. They're trying to settle with each other if possible, and if not, they want to get their suit filed in the best jurisdiction. That's where the rub comes in patent cases. So let me read to you, this isn't the best, but it'll start us off. Communications Test Design Inc. versus Contact Tech, 952 Fed 3rd, 1356, Fed Circuit 2020. Affirming as a proper exercise of discretion the dismissal of a first filed declaratory judgment action in favor of the patentee's second filed infringement suit,
He doesn't pay enough to
where
get
the
clerks.
declaratory judgment
Judge
suit was
Cooper
filed
says
as an
he doesn't have the
anticipatory
staff
suit,
like they do in
where during the
Mecklenburg County
pre-suit
Business Court.
negotiations,
Don't have the
the
staff.
declaratory
He's not
judgment
gonna put out
plaintiff
his
told the
76
patentee on a
page ruling.
Friday that
It's
it would
gonna
make a
be-
counter-proposal within a few
It's
days,
going to be probably a few pages.
but instead
and
filed
he
a
says he wants
lawsuit.
to rule
The
today.
Federal Circuit finding that the district court did not abuse its discretion
Judge
in
Cooper
not
wants
applying
to
the
rule
first to
today.
file rule, as the district court found that the declaratory judgment action was filed in anticipation of the patentee suit, that the preemptive filing interfered with the ongoing negotiations between the parties and did not serve the objectives of the Declaratory Judgment Act. I think I've got that case in fuller form that I wanted to read to you. No, that's EEOC case, let's see. Here's another one, Third Circuit, 850 Fed Second, 969, EEOC, Equal Employment, it's an employment case versus University of Pennsylvania. And it says Sirica, but I don't think that's the Judge Sirica, because I don't think he was ever on an appellate court, and this is 1988. I guess theoretically he might have been sitting by designation. So it says, the first filed rule, and I see that a lot, first filed rule, priority, etc., encourages sound judicial administration and promotes comity among federal courts of equal rank. It gives the court the power to enjoin subsequent prosecution of proceedings involving the same parties and same issues already before another district court. That authority, however, is not a mandate directing wooden application of the rule without regard to rare or extraordinary circumstances. That's almost verbatim the Siegel finding.
The judge is quoting patent
And then I read on
cases.
inequitable conduct, bad faith, or forum shopping. District courts have always had the direction to retain jurisdiction
Citing
given
two
appropriate
parties going for the
circumstances
best
justifying departure from the first
negotiations on
filed
items.
rule.
And the rub, the word that Judge Cooper used earlier, the
We hold
rub
that the
comes
district
on
court did not
jurisdiction
abuse its discretion by
possible
declining
suits
to invoke the
moving
first filed rule to
similar
dismiss the EEOC's enforcement action. When the university filed the first suit in the District of Columbia Circuit, it knew the EEOC's
Chris
enforcement
Lee
action
of
in the
247
Eastern
Florida State,
District of Pennsylvania was
the first
imminent.
file
I hope
rule
this
is what
sounds
is being
familiar to you.
discussed.
And that precedent in this court might favor resolution of the dispute in favor of the
Rare or
EEOC.
extraordinary
Under these circumstances and in the light of
Forum
the purposes
shopping,
of
that
Title
term,
VII of
once
the Civil
again,
Rights
is
Act of
used again
1964,
by the
the
judge.
first filed rule does not govern this case.
Pennsylvania case
And-
is being discussed.
I will cite you more, but there's one case in here that if you took the name of the people's name out and you put FSU and ACC, you'd think it was this case. But they all say, when you know somebody's going to file suit against you, and you wait and you file in your jurisdiction immediately before that filing, that is at least an inference of forum shopping is appropriate. You take the affidavit of, is it University of Virginia president, who was the one who gave the go-ahead? That's essentially what ACC did. According to this affidavit, they started waiting from about August of 23. They knew FSU was making rumbles, they weren't going to file suit until they heard FSU was, and then FSU under its public meeting, which you're well aware of, public meeting notice requirements, said we're going to have a meeting tomorrow to talk about filing suit. And then this case gets filed, what, about 12 hours before?
That's correct, Your Honor.
Why is that not an anticipatory suit which are disfavored by these courts I've read, and I'm going to give you more, is disfavored by the North Carolina courts that are cited by the plaintiff. I've read all those cases. And the Mission Insurance, the Fifth Circuit, that's where I used to argue my arguments. That's a sign of my longevity as a lawyer. 706 Fed Second 599, 1983. Anticipatory suits are disfavored because they are an aspect of forum shopping. The wholesome purposes of declaratory acts would be aborted by its use of an instrument of procedural fencing, either to secure delay or to choose a forum. There are indications that forum shopping was an element in this case. So why isn't this an anticipatory suit which shows an aspect of forum shopping? And how do you get around the affidavit?
That's a very good question, Your Honor. I'm going to directly answer that question, and then I'm going to also answer a question that you haven't asked next, which is why that's not a proper consideration as an exceptional circumstance under Florida law.
Okay.
As to North Carolina law is similar to the law in the federal circuits, where they consider a multitude of factors and where they do consider the anticipatory filing and forum shopping as a way not to exercise priority. And what that doctrine says is that when you have a natural defendant that does an anticipatory filing in order to get a forum that's more favorable, that is disfavored conduct. And of course, North Carolina is one of those jurisdictions, like the federal jurisdictions. They, by statute, have a 10-factor test to determine where an action should be held when there's concurrent jurisdiction in multiple locations. And so they do, unlike Florida, consider whether something is an anticipatory filing. And so that was thoroughly argued in Florida State's motion to stay, which cited the North Carolina law and many of the other federal cases similar to the ones that you've looked at. Judge Bledsoe looked at that, and I'll just tell you what he found. And he found, so that he said that the FSU board's argument hinges on its erroneous view that it is the only natural plaintiff in the dispute. In other words, this improper forum shopping idea comes about when you have a natural defendant that's trying to get a favorable forum because of the law or something
Sorry,
like that.
natural plaintiff, natural defendant?
Yes.
Tell me what that means.
Okay. So a natural defendant is someone that doesn't have their own claims. And as Judge Bledsoe recognized, in the grant of rights agreement that Florida State is a party to with the Atlantic Coast Conference, they not only pledged and gave their media rights away for the term of the agreement, they also pledged that they would not take any action that would put that document and that contract under question. So it's a covenant not to sue. And so by suing Florida State, by suing the Atlantic Coast Conference and challenging those documents, they violated the contract. And so when the Atlantic Coast Conference filed its action in North Carolina, it was an action to protect its rights
Okay, we're going to see if that comes back up. I'm going to try to get it up for you again. That was an issue in Leon County, the court. That wasn't us. It still had, the live feed still hasn't come up yet. I'm going to keep trying. Judge Cooper, how does a contract that governs Florida State, how do contractual agreements that deal with the activities of a state-funded institution in Florida become secret? So Judge Cooper has already started pushing back on that. Attorney Nicole, at Attorney Nicole on X. Judge Cooper paraphrasing, forum shopping and no known litigation is when party A knows party B is about to sue them. So party A files suit immediately before to get the case into a friendlier jurisdiction. Judge Cooper, that's essentially what the ACC did. So far, very little talking from Attorney Lawson from the ACC. Instead, Judge Cooper is reciting his interpretation of the relevant case law, asking Lawson to respond. MGS Sooner, might the threat of ruling today move the settlement talks to the court breaks? Ray Com at it again. Jen Knoll. Oh boy. I'm gonna keep trying on that live stream. So many folks watch it on the court feed, it crashed. Maybe that's the case. The ACC cut the cord because they didn't want to look embarrassed. I'm going to give it a try again here. Let's see what happens. Again, we did have a live feed, but something happened. Something not good happened here. All right, well, we don't have it up yet, but we might get it. We might get it here. We're seeing something different. Hold on. We might get it back up. Come on, baby. Come on. No. It's still down. It is still down. So, again, we'll keep checking. But in the meantime, we're going to keep giving you the reports from the people who are inside the courtroom. And Matt Baker, who's reporting what we just reported. How do contractual agreements that deal with activities of a state-funded university in Florida become secret? So he's pushing back on that ESPN ACC agreement from being completely not in public view. Now, there was a ruling in the Mecklenburg County Court. Judge Bledsoe did say that the ACC, they were going to have to unredact some of those documents in the 160-plus page document, the ACC ESPN agreement. They were going to have to take off the redaction on some of those pages, and that has to be released in public view by April 15th. By April 15th. From 247, Judge has another case that he can cite where if you took the names out and put Florida State and ACC in, you would think this was his case. Judge is clearly taking issue with the ACC rushing to the courthouse to ultimately forum shop. Judge also brings up Florida State's scheduling meeting. ACC filing beforehand. Cooper asked Lawyer Lawson, who's representing the ACC, what state has the most vital interest in this case? Cooper asked if that tilts it from North Carolina to Florida. What state has the most vital interest in the case? And then Cooper asked, does that tilt it jurisdiction from North Carolina to Florida? Lawson says, no, it wouldn't. It would not tilt it to Florida. By the way, the live stream is still down. It has nothing to do with Peek Around the Corner. It is down for people who are watching it outside of Peek Around the Corner. Cooper asked if North Carolina has the same public record laws equal to Florida. Lawson doesn't answer. He's not sure. Judge Cooper brings up the flaw pertaining to NCAA secret contract. And it says it's extremely similar to this case. That turned out to be a public record. Judge Cooper, if you have a preemptive suit that smells of forum shopping, well, Judge Cooper is now talking about the Coca-Cola case versus Durham. So if anybody in the chat room knows the Coca-Cola case versus Durham, let me know. There is a report out there that they're trying to get the live stream back up. Judge Cooper says the ACC suit was a declaratory action, right? And then Judge Cooper went back to talk about how President Ryan of Virginia cited that it was declaratory. And then the ACC lawyer pushed back and said, it's not declaratory. The amended complaint has breach of contract, but the original was declaratory action. Judge Cooper said that President Ryan said the word only a declaratory statement. The amended complaint revised these things, but Judge Cooper seems to be saying what you said first is what was said. And according to Judge Cooper, according to 247, the affidavit seemed to be misleading. Judge Cooper then asks about that January, you remember that January 12th meeting? The ACC, they got together, they voted on giving, Commissioner Phillips the ability, the legitimacy to go ahead and file the amended complaint. Remember that? Judge Cooper is asking for the minutes of that meeting because they're not in any of the documents that Judge Cooper has received. He wants to see the minutes of that January meeting. I believe it was January 12th. And I believe, I might have the dates mixed up. I believe they officially voted and filed the amended complaint on January 17th. I might have those dates wrong. But supposedly, hold on everybody, hold on. We might get the live stream back. Hold on. Come on, baby. Come on. One time. We're working on getting the live stream. Hold on.
All right, let's see. FSU response to motion to stay.
That's where it is.
Okay. And that's tab 4 in their book.
4A, Your Honor, yes. And then,
Okay, I'm there. I see it. Affidavit of Brad Hostetter.
yes, Your Honor.
Okay.
And he recites the action that was taken at the meeting on
Okay, they had a special meeting of the Board of Directors attended by the quorum from the current member institutions. Prior to 3 days' notice of this meeting, the voting directors in attendance approved the amended complaint. Okay, well, yeah, I read that. But the president still submitted an affidavit after this was signed, saying he agreed only to deck action.
Well, Your Honor, if you read farther in the president's declaration, I believe he also says he presided over a meeting,
Okay,
January 12th.
let me get that. I had that highlighted somewhere.
And I apologize, I'm making you push that.
That's okay. I think it was attached to
It's Exhibit 4C, tab 4C.
tab 4C.
Exhibit to the response to
Okay.
the
Yeah, I have it in another place where it's underlined, but this works also.
They're discussing the January
should I
12th
read,
meeting.
counsel?
Ladies and gentlemen, if you just come, they're talking about the January 12th meeting where they made the vote in the ACC
And this is
for the amended
President
complaint
Ryan,
filed
who used to
by the
work
ACC.
at Harvard.
Correct, Your Honor, and a graduate of the University of Virginia. I'm required to say that.
That would mean you're a graduate of the University of
That's
Virginia.
correct, Your Honor.
Well, it's a great university. I had a law partner that went there.
Do we have it? It's paragraph 10, Your Honor.
Okay. Meeting of the board. I presided over a meeting of the board. Did he vote?
The University of Virginia voted.
Let's see. University of Virginia, is that Virginia Polytechnic Institute?
No, that's the different. Virginia Polytechnic is Virginia Tech.
Okay. I should have known that, sorry. Where does it say, it says during the course, oh, it says ACC management consulted with. That's not who was at the meeting. Does it say who was at the meeting?
No, Mr. Hostetter's affidavit addresses that by saying that there was the necessary 3/4 were at the meeting to waive notice.
Why wouldn't you say who was there?
We could. We can tell the court exactly who was there. I mean, there were 12 members of the conference there,
It's not that hard to put their names in, right?
Your Honor, and that would be my error.
Was Clemson there?
Clemson received notice but did not attend.
Okay. All right, let me go to my other version of the documents. Hold on. ACC's hearing notebook. Just a second. Okay. So let me ask you this. I had his affidavit marked up. I'm going to have to go without the marked versions. So Hofstetter, President Ryan is also a lawyer.
Yes, Your Honor.
So he said, paragraph 3, beginning in August 23 and continuing into December 23, he was aware FSU appeared to be either considering a withdrawal from ACC or a challenge to the grant of right agreements. 4, he conferred with ACC's management, and they made a decision not to sue unless and only if, not to sue FSU, until and only if breach of an agreement with the conference was believed to be imminent.
Yes, Your Honor.
That means suit was believed to be imminent, right?
Well, that would be a breach because of the covenant not to sue.
Okay, I want to see that too. Discussions with the management occurred on whether the conference should bring in motion an action for a deck action or make affirmative claims, such as damages or injunctive relief if breach by FSU was imminent. In other words, a suit was imminent. Paragraph 5, on December 21, 23, I was notified that FSU had scheduled an emergency meeting on 24 hours notice. That's because FSU told everybody that, because it's a public institution governed by the public meetings laws of Florida, which don't exist in many other states. Do we know if those laws exist in South Carolina? Because I don't, how did Clemson get a suit filed without y'all knowing about it?
I don't know.
I'm just off target, I know, but
No, Florida has robust public records laws and public meetings laws.
which makes it an exception to many other states, if not all other states.
The one caveat I would add to that is while your public records law is very broad, you also have a very broad trade secrets protection provision in that, much broader than North Carolina's trade secrets protection.
I've handled a lot of trade secret cases. I've never seen one where a contract with a public institution or state agency was was not discoverable by parties in an action. Sometimes you do a protective order. For example, here's what we see a lot. Department of Insurance is in Tallahassee, as all state agencies are based here. Sometimes they have to request from insurance companies rating information and other information which they consider to be a trade secret. They get that information, but it's protected because of its trade secret status, but the department still gets it.
And Your Honor, we offered to do that with Florida State back in January, to provide them with the ESPN agreements, which are different than the grant of rights agreements.
Did you offer to provide the grant of rights agreements?
They have the grant of rights. Those are public
Where
records.
they go into the locked room and they have
That's
the
not the grant-
password
that's not the
and
grant
the
of rights.
fingerprint test and all that?
That's not the grant of rights, Your Honor.
Judge
What's
Cooper
the
has
locked
been
room? What's
watching
in there?
Those are the
PATC.
ESPN agreements.
That's the locked room. Is there any other passwords you have to have?
No, you don't need any other passwords. And Florida.
You have to have an ACC official with you to make sure you don't take your camera phone in there. Right?
Well, I'm not sure if we actually, every time they looked at it, we actually had somebody sitting there, might have.
They can't take,
They can take notes.
they can take a legal pad in and write it down?
Yes, Your Honor. And we offered to make those, they're clearly entitled to them in discovery, subject to the protective order that Your Honor has described. And we offered to do that very early in January.
So
Not here, Your Honor.
if you're in North Carolina and the judge up there orders that they be produced to FSU and says they're trade secret, he might not have to give those to the press because North Carolina doesn't have the same public records laws
That's correct,
we
Your Honor.
do. In Florida, press is going to have a right to that.
Well, not if it's a trade secret.
Depends on what you're talking about, trade secret.
It would be up to a Florida court to determine that. So the press would then, in the ordinary course, file their demand with a court for Florida State to release it. The ACC,
which one
probably
of you
ESPN,
are-
would
which
intervene,
one of
argue it's a
you-
trade secret. then
Which
a
one of the
Florida
handles
court
in
would
the
decide that.
PATC chat room?
Even though I handled the
Through
case,
all these
I
months
must
was
confess
Judge
I've handled
Cooper.
thousands since. But I think the NCAA case, I gotta be honest with you, I can't remember who filed it, but, and I don't recall if trade secret issues came in, but I think the position taken in that case is that it was a confidential contract and not a trade secret.
Because as I recall that case, that was involving the review of a transcript of the disciplinary proceeding.
This was the education situation, the
Correct.
test situation.
And so that, and I understand that case, but Your Honor is exactly correct. There was not a trade secret involved because it wasn't, pricing or the other innumerable things that are dealt with.
Well, one would have to make a determination as to trade secret, whether pricing issues and all those things are trade secrets and have been kept confidential. From me reading the records here, doesn't look like people are fanatical about keeping this pricing information secret.
Well, Your Honor,
Because
just,
there's allegations in the lawsuits that I've read about.
right,
Yes.
very, very broad allegations, but in
Right.
terms of the specific, what gets
Is
paid, what
my
year,
audio
applicable to
good?
what percentage, and how.
Give me a why
how,
if my audio
your
is
costs
okay.
are
Mine mic,
allocated
is
and,
my mic okay?
the other
Give me a why.
covenants
Or an
and
N,
obligations
but you're not
under
going to
the
hear me if
agreements
it's an
that are
N.
non-pricing
So give me a
terms that
why
are
if my
sensitive.
audio's okay.
All of that
All right,
comes
thanks,
into
guys.
effect. And as I
Appreciate it.
read Florida's trade secret statute, it says if there's any information that could be used by somebody else for economic benefit, then it constitutes a trade secret.
Who else would use it? Fox News? I'm not Fox News, Fox Sports?
Fox Sports, CBS Sports, NBC Universal, which follows the Notre Dame agreement, Apple, which bids on things. There are a lot of provisions in there that, and I'm channeling ESPN a little bit. We would want them to come in and explain that to
Right.
you, but would certainly affect ESPN's competitive ability to negotiate other agreements.
Okay,
So, and we've gotten far afield, and I apologize, Your Honor.
that's my fault, that's not your fault. So, Dr. Ryan, or...
He's not a doctor.
Mr.
Just a
Ryan.
lawyer.
I think technically, back in the day, you could call someone with a J degree doctor. I've never had anybody call me that, but
I'll just stay with Your Honor, if that's all right.
anything that works for you works for me.
Thank you, Your Honor.
So, anyway, I stopped reading this North Carolina case to read Mr. Ryan's affidavit. And it says, priority should not necessarily be given to a deck suit, I'm going to abbreviate it a little bit, simply because it was filed earlier. Rather, the plaintiff in the declaratory suit was on notice, rather, if the plaintiff in a declaratory suit was on notice at the time of filing, well, we know ACC was on notice. We have Ryan's affidavit. At the time of filing, that the defendant was planning to file suit, we know that. That's two. A court should look beyond the filing dates to determine whether the declaratory suit is merely a strategic maneuver to achieve a preferable forum. There was no intent to file suit until FSU was about to.
Until breach was imminent, whatever that breach looked like. Now, and I want to...
What other reason would there be to file suit than to get a better forum than the state of Florida?
Well, because, and I don't mean this other than to say, I don't think North Carolina is a better forum or this court is a better forum. I think North Carolina is the more appropriate forum because in Judge Bledsoe's decision, he dealt with precisely that issue. In North Carolina courts, as Mr. Lawson said, use kind of this qualitative test. First to file is really not even considered that strongly. They try to consider who's the party being damaged, and that's what they mean by true plaintiff. Who's the party that has suffered damage. And if there was a covenant not to sue that was breached, then the ACC is, as the party receiving that promise, suffered damage and was the proper plaintiff. And Your Honor asked about covenants not to sue in public policy. You know, we enter into covenants not to sue all the time when you have settlement agreements. That's the nature of a settlement agreement. It's a covenant not to sue.
So the documents with FSU are in the nature of settlement agreement?
No, but I'm saying covenants not to sue
Yeah.
are consistently enforced. And
But there has to be a means of enforcing that. It can be mediation, it can be
private mediation,
a
private
motion for
arbitration.
contempt with the original court, et cetera.
So,
I understand.
and when President Ryan says the conference waited until it believed a breach was imminent, I do want to distinguish Florida State has a contractual right to withdraw from the ACC.
After they pay, they say, I'm not saying I agree or disagree with them. After they pay ACC $500 million?
No, Your Honor. There's a withdrawal.
How much would they owe the ACC if they went outside to the front door of the courthouse and said FSU withdraws?
They would owe us roughly a year's notice because we've got scheduling concerns.
A year? Okay, so we're going to withdraw in a year.
Yes. It would be roughly between $130 and $140 million. That's the withdrawal payment specified in the ACC Constitution. It's a multiple of what the conference's budget is. I believe it's 4
All right,
times.
so the max FSU would owe if they announced they were withdrawing would be between 130 to 140 million?
Correct. And what Florida State's complaining about is the grant of rights says even if they withdraw, the ACC retains the media rights.
So you would have a right to broadcast the choke and doke forever?
No, Your Honor, just for the term of
You
the
know, that's a game that's played all the time. You know what the choke and doke is?
I do not, and I apologize.
All right. I don't think it was covered by the ACC. Mr. Lawson, I'm sure, knows it, but FSU was playing Florida. They were behind, 28 to
31 to 3.
31 to 3 at the beginning of the fourth quarter, and they came back and they tied the game.
Wow.
And that in the media has been referred to as
The choke and
the choke and doke.
Gotcha.
But it's played on ESPN in like the old games segment.
Well, the ACC owns the copyright on that, and would continue to own the copyright. That's provided for in the grant of rights. What Florida State is complaining about, I don't want to put words in Mr. Rush's mouth, but what they're saying is because the ACC, under the grant of rights, would retain the media rights, effectively that would act as a forfeiture for Florida State of those media rights for the term. We disagree with that reading of the grant of rights.
So let me get this. FSU, if they said we withdraw a year from now, they would owe between 130 and 140 million. You keep the media rights, but if they wanted to buy the media rights, then you'd have to negotiate that price.
Right. Or we could sell the media rights to somebody else. They would receive portions of that just the same way they do now.
This is like when Michael Jackson sold his song rights. I'm sorry, Paul McCartney sold his song rights to Michael Jackson. Michael Jackson quoted a price so high he never got them back, I think. Y'all would have to check on that, I'm not sure. So you would have the media rights
For a specified term.
for a specified term, and I assume over a period of time, like most items that are broadcast, they would be reduced in value over time, except the Celtics games from the 1980s are still being played every night on YouTube. So with modern day forms of broadcasting, media can have a life for a long time, but you have a definite term.
Yes, and we're really talking about kind of the new content, so the new football games, the
So if I were mediating this case, I was a mediator for 10 years when I was a lawyer. If I were mediating this, I would tell FSU, say, it's not $500 million. It's 130 to 40 million plus media rights. And you can decide whether you want to buy those or not, or maybe you can go out and play some great games and build up some new media rights.
precisely, Your Honor.
And then FSU would come back with you with whatever their counteroffer would be, and I wouldn't suggest it because I don't want to get in that thing here. So, okay.
But I did want to emphasize when President Ryan said the conference was listening to see if there's going to be a breach, he did not mean withdrawal, because withdrawal is not a breach. They're entitled to withdraw. They could have.
Suing for a deck action is a breach?
Well, yes, their challenge of the grant, of the validity of the grant of rights is a breach, because there's a specific provision in the grant of rights that says they'll take no action to challenge the validity of the grant of rights.
The grant of rights, is that the assignment of certain game rights to ESPN? Is that the grant of rights?
Those are the ESPN agreements.
Okay.
The grant of rights is between Florida State and the ACC.
Okay, do you have that, is that in the record somewhere?
Yes, Your Honor.
Can you tell me what page that's on or where that's located?
The grant of rights. It was attached to both our complaint and the first amended complaint.
Okay, I've got that in my book here pretty easily. Complaint, amended complaint, okay. Let's see.
I have it.
I'm not sure that I copied the exhibits to your complaint.
They are public records, Your Honor. Nobody argues about the grant of rights not being in the public space.
Let me look here. This is your complaint.
Yes.
Okay.
Complaint in North Carolina and
That would be
PATC.
here
If
probably.
you're new to the channel, please subscribe.
In the,
Smash that like button if you like our content.
When he finds it.
exhibits 2 and 7 to our first amended complaint.
All right, let me
It's the same
find,
Here, do you
this
have a hard copy?
is ACC's hearing book. It would be most easily found probably in your, here's judicial notice, okay.
Your Honor, if I might, I have a hard copy. I can hand it up so the court can know what it's looking at.
Okay, all right, and I'll give it back to you. I think I found it. So where is it in here?
So this is the amendment, I'm showing the amendment to the grant of rights. So this is the one that extended the term. And you can see the signatures on the back for each of the member institutions.
I remember seeing this.
Okay. And then there's an earlier one that lays out the term rights.
So this particular one is not the one that has the don't sue clause?
Yes, that's got the do not challenge the validity clause.
Okay,
Yes, sir.
do you need to look at it?
If I can look at it, I'll show you exactly what that
Okay.
is.
I remember seeing that too. We're going to take a break in a minute. I guess I was right that we're not going to do this in 90 minutes. Why don't we do this? Why don't we take a 15-minute break and then give you a chance to look at that without me.
With the court's permission, I'll highlight it.
That's fine. So we'll be back, give everybody a break until, let's see, until 25 after. And then we're gonna probably go to about noon, we'll take a lunch break, and then we'll come back at 1.
Thank you.
All right, thank you.
Thank you. Thank you, Ron.
Okay, so wow. There's so much to talk about. First of all, they're going to be taking a break. They're going to be coming 25 back at. Oh, they're coming back in about 15 minutes. I want to thank Mike Smith for becoming an early peak member. Thank you so very much. I do appreciate it. You are hereby Cloak and Dagger Knighted. KS Bear fan, you became an early peak member early this morning, but I was not able to officially knight you Cloak and Dagger. Thank you so very much. Gavin Heckman, holy smokes. Thank you for your incredible generosity. Gifted 5 memberships to the PATC community. Gavin Heckman, you are officially hereby Cloak and Dagger Knighted. Again, all members to the show gets to go on to the YouTube channel and watch our membership only Cloak and Dagger early peak episodes. Tomorrow morning, we're going to be putting something down there in regards to the latest Board of Governors, North Carolina Board of Governors information, and a little bit about Conference USA. So become a member. And if you are a member, make sure you watch our early peak episode tomorrow morning. Right now, thank you so much. Right now, by the way, Clemson alumnus, Dad, Mac, Terry, Kane, awesome clips. Mr. Louisville Cardinal, no nonsense. Thank you all for being an early peak member. Again, you are all hereby knighted Cloak and Dagger. I'm going to take a little break. I'm going to be back in about 5 minutes. I'm just saying. I ain't saying, but I'm saying. I know it's dangerous to say this, but Judge Cooper so far has been a nightmare for the ACC. Says he's going to rule today. If he might rule today. It's not going to be a 76-page ruling, he said. Judge Cooper doesn't have the staff like the business court in Mecklenburg County that Judge Bledsoe enjoyed. He doesn't have that staff, but he's pushed back on a number of things. One, when it comes to jurisdiction, the venue where this case should preside, and he's also pushed back on this trade secret that the ACC and ESPN not unveiling their ESPN agreement in public view in the state of Florida. But he also seems a little bit weak. Judge Cooper seems a little bit weak on his understanding here of the grant of rights. So hopefully during this break he can read up on it and everything. So anyways, buckle up, brace for impact. I'm going to put it back on the this live stream, and I'll be back here in just a moment. I'm going to be taking a couple minutes break. But so far, from my non-expert opinion, so far I think this is a route for the Florida State Seminoles. Judge Cooper, I think, is a nightmare for the ACC. I'm going to put it back up on the screen here. And I will be back shortly. Stick with us here at Peek Around the Corner. Okay, we've only just begun. We've only just begun. PATC. The judge will be back in 4 minutes. The judge will be back in 4 minutes. And so far, very tough day for the ACC. Judge Cooper's looking at the grant of rights. He's looking at the contracts. I think he was a little bit weak in that. But when it comes to jurisdiction, when it comes to the so-called trade secrets between ESPN and the ACC, so far not a good day for the ACC. Judge Cooper does not agree that jurisdiction, that the venue has been settled on. He's not buying what the ACC is selling. And when it comes to the state of Florida, the sunshine laws, and he keeps talking about how the Florida state is a public university in the state of Florida with a contractual relationship with the ACC. He doesn't know of any contract like that is not out in the open in the state of Florida. And he's also referred to, look, there should be a settlement, maybe, He goes, I don't want to get into it, but, $130, $140 million exit fee, whatever is the grant of rights, mediate on that. He says, I used to mediate. The judge says he used to mediate, but I don't want to get involved in this. Basically, he's saying, anyways, I am at the very beginning of the case in Leon County, Judge Cooper said, I'm not going to have a 76-page ruling. I don't have a staff. But, I've been reading up on all this. I get the pleadings back and forth. I've read it all. I've been doing my homework. And I expect I will have a ruling today. And if it doesn't happen today, it's going to happen soon afterwards. This isn't going to be, we're not going to be waiting for very long. Either it's going to happen today or tomorrow. I mean, let's be honest. So we're going to find out here real soon how Judge Cooper rules in Leon County. I want to thank everybody who's joined us so far. PATC breakfast. It's going to go into PATC lunch. This is going to last a while, and we are going to be here for the whole thing today. And then afterwards, we're going to open up the phone lines and let you all talk about it. Right now, we'll get to you super chats and memberships, but we're going to wait on the phone calls later in the show. We're going to go back to the live stream. I want to thank everybody who's come on in. If you're new to the channel, this is College Football's Peek Around the Corner, talking everything college football. If you're new to the channel, please hit the subscribe button, smash the like button if you like our content. If you don't like our content, give us a thumbs down and let me know how better we can serve you, the college football fanatic. So, let's see. We're going to go live here pretty soon, I believe. We're going live here real soon. Here we go. The volume isn't quite all the way for some reason. There we go. And here we go. The camera's shaking around. We're coming back live. Thank you all for joining us. College football, Peek Around the Corner. Florida State versus ACC, Leon County. Again, we're waiting for Judge Cooper, I believe. I do not believe we have an issue with the live stream. I think we're okay. The Florida State defendant, Florida State University Board of Trustees have hereby given notice of appeal to the Supreme Court of North Carolina of the findings and ruling by Chief Business Court Judge Louis A. Bledsoe. Florida State has appealed the ruling in the state of North Carolina Business Court by Judge Bledsoe to the North Carolina Supreme Court. That happened earlier today. Thank you, Michael Monk, for your super chat, for your generosity. Thank you so very much. Settlements and options are what the schools are looking at. I think, if it goes the way I think most of us think it's going to go here in Leon County, I think the incentive to possibly start those negotiations, if they haven't done so already, I think the incentive only grows for the ACC to settle with Florida State. Okay, I just want to take a quick look here. Want to make sure that we're not missing something on this live stream. Want to make sure we're not missing something. I'm going to go Big Dog Daddy, thank you so much. The only patent the ACC has is its logo. Holy smokes. Thank you so much for your continued generosity to this channel. Thank you, Big Dog Daddy, Mr. Husky. Holy smokes. And again, thank you, Michael Monk. Thank you, Michael Monk, for your donation. Helping us keep the lights on here. A lot of great comments in the comments section. Again, I do not see I don't believe it has started back up again. Again, we're waiting on Judge Cooper. They're supposed to be back at 11:25 Eastern time. So right now, 8 minutes over the time that Judge Cooper, he was going to read about the grant of rights and everything during the break time. Let's see here. Nobody thus far that I can see that is in the courtroom has mentioned that Judge Cooper has come back. Florida State 247 is reporting that they're going to be resuming here momentarily. That's going to be going on for 30 more minutes, and then we're going to have a lunch break. So during lunch, we're going to open up the phones. The phones are going to be open here in 30 minutes, a little bit after 12 o'clock Eastern time. We're going to open up the phone lines. Let us know what you think so far. Florida State versus the ACC. Again, I don't know if they forgot to turn this live stream back on, but the people in the courthouse are not reporting anything. So, again, keep your head on a swivel. We're going to get you the live stream once everything is going again. Are they doing this settlement right now? No, they're not. No, they're not. Sweet Lou, courts won't decide this case. All this is a prelude to a settlement. I agree. This is about leverage. And so far today has been a very difficult day for the ACC, in my opinion. And I'm not reading anybody's opinion out there that is different to that. It seems to me that Judge Cooper believes that the venue should be in the state of Florida.
Where she's at.
Here we go. Here we go. Welcome, PATC. Here we go.
Yes, sir, that's a supply room.
All right.
We don't need to get you lost in there.
think I'm supposed to get her at the bailiff's office. Y'all hold on, let me round her up. I didn't go by the bailiff's office, I came the other way. My fault. All right, well, we're going to look at that provision.
Yes, Your Honor, and for the record, I'm handing to the court the grant of rights agreement highlighted in paragraph 6.
Okay, great. I'm going to give this right back to you. I'm going to read out loud for the plaintiffs. It's page 3 at the bottom. Each of the member institutions covenants and agrees that X, it will not enter into any agreement that is inconsistent with the provisions of this agreement, and Y, it will not take any action or permit any action to be taken by others subject to its control, including licensees, or fail to take any action that would affect the validity and enforcement of the rights granted to the conference under this agreement. Okay, that's not exactly a not to sue thing, but it's, I guess it was enough for ACC to file their lawsuit when it did.
Yes, Your Honor, because while Your Honor, it's exactly correct, Florida State is alleging particularized breaches under the grant of rights. It's also challenging the validity of the grant of rights agreement as a whole.
Isn't the main effect of their suit, I'm like Mr. Lawson, I like to try to simplify it. Isn't the main focus of their suit is they're having to pay too much if they leave?
Yes, Your Honor. The main focus is if we want to leave, and we've got 3 different documents flying around, and I think that's part of the confusion. So we've got the grant of rights. And the grant...
That's ACC to FSU?
Yes, Your Honor.
Okay.
And what happens in the grant of rights is FSU gives to the ACC the rights to its home sporting events. Then the ACC...
That's generous.
Well, they didn't do it for free.
Okay.
And the ACC takes those rights from all of the members.
Okay, they took the members' rights and they said to Raycom, you get these games, ESPN, you get these games.
Well, they actually gave them all to ESPN, and then ESPN sublicensed Raycom, and they're called regional sports networks.
At your request.
That's what they allege.
So ESPN's going to come in and testify and say they preferred Raycom to handle these games instead of ESPN?
Well, ESPN did handle the games. There are a subset of games. They're broadcast on regional sports networks. So you see them on, if you turn on your cable.
Oh, I've seen Raycom stuff before.
Sure. Well, you see Bally's, for example, broadcast games.
So ESPN thought it was good. They do all the work, handle all the games, and they have to pay Raycom a commission?
Well, no, what Raycom sells its own stuff. What ESPN does is once they take the media rights, they then make grant of rights payments to the
but
conference.
ESPN had no similar arrangements with any other sub-licensee, like at any other conference like they do Raycom, as far as we know.
Yeah, I mean, there are, my guess is they do have some agreements with some of these regional sports, because Raycom doesn't do it anymore. There's another regional sports network who does it.
Okay, the ACC network?
No, the ACC network, and I apologize for this confusion, that's a separate agreement. And that's between the ACC and ESPN, and what they do is they've entered into a joint venture to set up the ACC network, and for lack of just to simplify, they basically split the profits. And the ACC network is funded largely through subscriber fees. When you sign up for your cable, $6 goes to ESPN, and they pay $2 on behalf of the ACC network, and those are the revenues that are split.
Okay.
So we have the grant of rights to the ACC. The ACC then gives the rights to ESPN, who then pays the ACC, and the ACC then distributes the monies to the members and takes out a percentage at the top to operate the conference, pay for referees, do those kinds of things. And then we have the ACC Constitution and bylaws, which is a separate agreement. So the withdrawal payment that Florida State complains about is in the ACC Constitution and bylaws. And then Florida State says, because the grant of rights gives the conference the rights, even if Florida State withdraws from the conference, that in effect gets added to the withdrawal payment, because Florida State would have to repurchase them back to get control of it.
Okay, so when do the media, if FSU left in a year,
Yes.
how long do the media rights are they retained by ACC?
They're retained no longer than the end of 2036. That's when the term ends.
End of 20,
And it's into 2036 or mid-2037, but it's in that.
36 to 37, okay. And if FSU this is not a negotiation, I'm just trying to get an idea of what the stakes are.
Yes, Your Honor.
If FSU pays 130 to 140 million and just says, well, we don't want to buy back the media rights, we'll let them run out.
Yep.
That they can get out of ACC and not owe any other money?
That's correct, Your Honor.
Okay. So do you happen to have this one other document I've seen discussed, and you probably can find it, is the provision, I guess it's in the ACC bylaws, that says what has to be done before ACC can sue a member?
Yes.
This
Your
is the vote of the board situation?
Yes, for the initiation of any material litigation. And that's the phrasing, before the conference may initiate any material litigation.
Any material litigation?
There has to be a 2/3 vote.
Do you have that somewhere, or can tell me where it is? I can either, it might be easier if you just let me look at it.
Yes, I'll
Give it back to you. I'm sure the plaintiff has this already. Is material defined in there?
It is not, Your Honor.
Oh. Who drafted that without defining material?
I did not.
You did not? That's good. I'm not being critical. All right, what I'm reading is on the board voting requirements, 1.6, and I'm reading under 1.6.2, required vote. It says the absolute 2/3 matters. They talk about 2/3 of directors present have to vote to do certain things. And then you say, the absolute 2/3 matters are as follows. 1, any amendment to Article 2.5 of the bylaws, finances. We don't need to worry about that for now. 2, selecting or changing the location of the conference office. So if they wanted to move it to Tallahassee, you'd have to have a 2/3 vote.
That's correct.
Okay. 3, entering into or amending any media rights agreement. That's something between ACC and ESPN or something like that?
Yes, sir.
Okay. The appointment, extension of term, or removal of a commissioner or other matters set forth in 1.5.2.1.1, which I don't think is a point here.
That's correct,
In 5, the initiation of any material litigation involving the conference. And material's not defined.
That's correct, Your Honor.
So if it's a deck action, it's not material, but if you add on a breach of contract, it is material?
Yes, if we sought affirmative relief. So, for example, if the deck action had just stayed there and the ACC had won, nothing changes. The agreement is in place. The same agreement that they've been operating under for 11 years continues to operate. But once the conference then sued Florida State for injunctive relief and for breach of contract and for damages from those, then that was viewed by the conference as the initiation of material litigation. Now, I will say in Judge Bledsoe's order, he didn't address that issue because he found there had been ratification of the earlier action in Mr. Hostetter's declaration.
I read that online. I didn't read it in the order. And when I see stuff online, I try not to go. I'm not saying it's not true, but that's not what I don't rely upon that sort of information. Let's assume he said, or it was ratified in January, whenever that meeting was.
Yes, Your Honor.
I'll give you the example. In Florida, we have a provision under the sovereign immunity law where you can sue the state of Florida under 768-28 so long as you give notice to the agency within 3 years of the act. That may have been changed in the recent legislation, I don't know. You give notice to the agency of the suit. You give notice. It used to be Department of Insurance. I think it's a different agency now. And then you wait 6 months after the notice. The conditions precede it to filing a suit. There's case authority that if you file suit and you haven't complied with that, then you can dismiss the case. And some judges do that, and others abate the case until conditions precedent have been complied with. This sounds sort of like a condition precedent in which the judge found that now that you've done it, the action, whatever was done when it was filed, it can go forward. It's not I guess it's voidable, but not void, not void ab initio.
And I think the only nuances I would add to that are the court didn't take up whether a vote was required to begin with. It simply said, I don't need to decide that issue because we've got ratification. And ratification under Florida law or under North Carolina law is the same as under Florida law. A board can meet to ratify a previously filed lawsuit, and it's effective as of the time the lawsuit is filed.
So I don't know if anybody, I didn't see any cases or dictionaries defining material to me in the papers. If there is, that's a page I missed. But so in defining material, we have a summary judgment rule in Florida that if there's a disputed issue, I think, of material facts, I may be getting the words reversed, that you can't grant summary judgment. And I think facts, material, I think, and relevant are sort of synonyms. Material here may be what would happen if ACC did not file the suit and lost the suit in Florida, would that make a difference in determining whether this was if you're filing suit, you're seeking to protect the covenants.
Correct.
If you lose the suit, here's a better way of stating it. If you lose the North Carolina suit in front of the judge in North Carolina, and the covenants are deemed non-enforceable, I suppose theoretically you could lose up to $130 to $140 million.
Well, no, the only covenants that we challenged were the covenants under the grant of rights, had nothing to do with the withdrawal payment. So the only thing that would have been lost if a North Carolina court were to have declared the grant of rights not valid, then Florida State would have received its rights back when it left the conference.
So the media rights, the right to broadcast old games.
Yes, Your Honor.
Okay, and I don't know how much that's worth, but I'm assuming $1 million.
Oh, Florida State, it believes it's worth between $300 million and $400 million over the course of the term. That's the value that they have placed on the media rights.
Again, I don't know.
It's worth what somebody will pay for it.
Yeah. So isn't it material in the sense that if you file suit, you stand to protect against losing $1 million or more dollars?
But no, because the way the conference viewed it is it wasn't material because all it did was seek to preserve a status quo that had been in operation for 11 years. And that merely seeking to continue what had been done doesn't change anything. It's only when the relationship, if we sue to change something, if we sue to alter something, that would be material litigation.
Okay, hold on a second.
And I will say, Your Honor, under North Carolina law, under the Internal Affairs Doctrine, because it's not a defined term, the conference in the first instance is permitted to arrive at its definition subject to an abuse of discretion standard.
All right, let's see if I can get this computer working again. No, I don't need to do that. Confirm and continue. Okay. I'm making progress here.
But, and while Your Honor is doing that, you are correct, there wasn't a lot of briefing done on that because it was really a matter for the North Carolina court on whether it was a valid lawsuit, and it was briefed extensively before the North Carolina court. The North Carolina court found this was a valid lawsuit and therefore valid jurisdiction and therefore a valid summons that was served on Florida State under North Carolina law.
All right, let's see if, I was going to look up material. I can do that in the lunch break. But here's my question.
Yes, Your Honor.
Let's assume that I find it's material that you needed to get the assent of the certain percentage, 3/4 or 2/3 percentage of the members present, and that you did that in January. What does that do from December 21 to January something when you haven't done that?
That is an excellent question.
Great
Your Honor,
question.
because that was precisely the issue that was presented to Judge Bledsoe. Under North Carolina law, he found that the ratification on January 12th was retroactive and therefore effective as of December 21st because, and that's the law in Florida as well. You can retroactively approve that, assuming it was invalid to begin with. And
So it was non-pro-tunc?
Precisely. And
21st.
so this, in North Carolina, it's similar to Florida. When a complaint is, the first document that's that is issued by the court is a summons, and the summons is the jurisdictional document. And so the summons that was served on December 22nd on Florida State, they were arguing for Judge Bledsoe was not valid because it was not authorized. And Judge Bledsoe said, no, that's not correct because it was ratified. Therefore, that summons was valid when served, and there was subject matter jurisdiction when this case was filed, even assuming it required a vote because of the ratification.
Did he, again, it's not that I'm not interested, but I'm not bound by him, and I'm not being disrespectful at all to him. It's just like if another circuit judge here said something about a case, I would listen to them, but I'm not bound by what they say, and I may or may not agree with them. But was the issue of whether filing suit, assuming that it was material and that you needed the assent of the board members, is another fact that supports a conclusion of forum shopping?
He considered that because, as you're aware, North Carolina has this ultimately where Judge Bledsoe came down was this is a North Carolina organization. This was a contract governed by North Carolina law because the last act executed was in North Carolina, seeking to enforce its rights, and therefore that did not smack of forum shopping. They weren't trying to avoid the law of Florida. They weren't, we weren't trying to avoid unfavorable law someplace else. And that's what the North Carolina courts look to. Did you file in North Carolina and you're a Pennsylvania company because you don't like Pennsylvania law? Or is there a natural connection to North Carolina? And I think Your Honor is right that when it comes to your decision under the priority principle, obviously you're not bound by anything Judge Bledsoe says. But I do think on issues of North Carolina law, such as the governance of this North Carolina association, that his, I don't know if you're bound by it, but it ought to be persuasive authority in terms of the way in which North Carolina law works to permit the organization to function.
Well, ACC is an association that has a certain number, less than 20 members.
Yes.
Powered by WCTV.tv. Your news starts now.
Right now at noon, FSU.
Okay, I've got to take that off. I don't want that music. Don't want that music being played. We're going to keep checking back on the live stream. We're going to keep checking back on the live stream. Let me know in the chat when it comes up again. When it comes up again. Again, the Florida State lawyers have not pleaded their case in front of the judge yet. It's just been the ACC lawyers. And Judge Cooper, in my estimation, has been pretty, he has not been convinced of the arguments put forth about jurisdiction and about the so-called trade secrets. He believes, I think he gave great indication earlier on that the so-called trade secrets where a public university in the state of Florida has a contractual agreement with the ACC ESPN, he gave great indication that he did not think that those should be kept under wraps. He thinks that probably should be out in public view. That was my take on it. I'm gonna keep checking in. To see if the live stream is back up. Like Rohan said, the noon news kick us off the live broadcast. Is there any backup links? If there is, if anybody knows of a live broadcast, let me know. Let me know. Rohan Law has been all over this here lately. Doug Rohan, if you don't follow him, he's a must follow at Rohan Law PC. In the meantime, I am following a couple people who are in the courthouse. So let me yeah, it looks like the local news took over. But let me there is a couple people that I have been paying attention to. Let me get caught up real quick. Ryan Willie, thank you so much. The Evil Badger, peek around the corner. Greg Flugar, I have to disagree that North Carolina State will go to the SEC and the Miami will end up in the Big Ten. The SEC won't take North Carolina's little brother. They may have to. And Miami could end up like Nebraska. Miami's research is growing. They just got their AAU. They're not in the same situation as Nebraska. But thank you for the comment, Ryan Willie. It may not go down the way I thought it. If you missed our live show last night, go check it out. On any given Saturday sportsbook, which is 2 miles away from the Holy Smokes Theater on Keith Jackson Parkway, we put it up on the board on how we think eventually this is all going to go down. So check out that live show. Thank you, Ryan Willie, for your incredible generosity. JJ75, thank you so very much for your super chat. I do appreciate it. Let's get to your comments, and then I'm going to check out. They moved the stream over to the live events stream. Okay, let me check that out. Hopefully I can find it. Hopefully I can find it. Hold on. If somebody has a link, oh, we got it. We got it. Thank you, Immaculate. Thank you, Mr. Hawkeye. We're going to have your live stream back here in a moment. Stay tuned. Stay tuned. Give me another 10 seconds.
So,
thank you,
ACC
Mr.
has
Immaculate.
damages.
Appreciate it.
FSU contends it has damages.
FSU is not sued for damages, Your Honor. FSU has sued for declaratory relief to have a declaration that the withdrawal payment is a penalty and that the grant of rights is not valid. They've not sought monetary damages.
Okay, so that's less of a damage to ACC than FSU is just seeking a reading of these covenants as it relates to FSU.
North Carolina contracts that would invalidate them.
How about the aspect of the penalty? Would that be under North Carolina law or under Florida law?
It would be under North Carolina law because the ACC Constitution bylaws are subject to North Carolina law.
Since FSU is a Florida university, do you think Florida does or does not have a special interest in enforcement of its penalty laws as it relates to its universities?
As a broad question, of course Florida has an interest in it, but as a question under the ACC Constitution, that leads to, and this is why the internal affairs doctrine applies, that leads to different results in different states on the same contract. And Florida follows the internal affairs doctrine. I mean, North Carolina law is going to apply to that penalty provision.
Yeah, but in the ACC, I'm trying to remember, maybe it was in the ESPN, doctor and plaintiff made this point, that it will not be revealed unless required by the law of the state where the institution is located.
Yes.
And I don't want to try to pretend to read their mind, but I've got to tell you, I think they were thinking about the state of Florida because of its very strong public document laws.
Well, there are a number of states that, as you point out, there are public institutions in North Carolina and Virginia.
All right,
Well.
so that document requires different interpretation depending upon the state the school is in, right?
Correct, but that's not a document that's the subject of this lawsuit. In other words, that's not in the grant of rights, that's in the ESPN agreements, and that goes to the confidentiality of those agreements. It doesn't go to the validity of those agreements.
Doesn't the lawsuit that FSU filed, isn't it filled with references about the inequitable bargaining as to those contracts, and that was due to actions or negligence of the ACC?
Those are the allegations, but there's
Well-
nothing about the validity of those contracts per se. Because FSU is, as they point out repeatedly, they're not a party to those agreements. So they're not suing for breach of those agreements. They're saying that under the grant of rights and under the ACC Constitution, we didn't do what we were supposed to do to properly exploit their rights, and therefore they get their rights back.
What to show what those contracts, what was negotiated by the ACC, seems to me that FSU would need to know the terms of those ESPN contracts.
They're plainly relevant, Your Honor, and I'm not disagreeing they aren't relevant, but the court is not going to be required to interpret those contracts to determine the relief that they are seeking. So the only interpretive issue under those contracts is going to be how much protection you're going to give them in terms of a protective order.
So the issue is this, as a single uniform read on the law, all the other universities or members of the conference have expressed inferentially that they have no plans to leave. So all we have are FSU and Clemson.
But all the other members have a right to leave should they wish to do so in the future. And, you know, that I don't know that anyone would want to leave, but, you know, as I think it was Mr. Ashburn pointed out, if he's right on the penalty clause, then it costs you nothing to leave because the entire clause is stricken.
That's the 120 to 130 million?
Yes, Your Honor.
I'm sorry, the 130 to 140 million.
Yes, Your Honor.
Okay, and then witnesses down in Florida, how many witnesses are there?
Well,
I assume there's a slew of Raycom witnesses.
right, North Carolina, and commissioners and former commissioners, and as well as the tape recordings of board meetings that took place in North Carolina that are maintained by the ACC. There are, you know, minutes, there are emails, they're all on the ACC servers in North Carolina.
I may be old, but I do know you can get emails about that quick off a server.
Right, but the problem is, for instance, if in this lawsuit, if Florida State wants to subpoena the former commissioner, who they're accusing of doing terrible things, they can't.
They're probably going to have to get by the Apex doctrine first if they're in Florida. I don't know if there's an Apex doctrine.
We do have an
like that
Apex
in North
doctrine
Carolina.
in North Carolina, but
I'm not saying they can't do it. I'm just saying they might have to get by the
they'll have to work their way up to them anyway.
Right.
But in any event, they're not going to be able to subpoena him down into Florida, because Your Honor can't subpoena a North Carolina resident into a courtroom in Florida. The same with the present commissioner. I mean, so there are all sorts of witness location issues, and it goes to the documents as well.
When I was in my 30s, I handled litigation that required me to be on the plane constantly. and I was able to make it all over the country to take depositions. Other than the fact that my suitcase got lost once, it was not a real problem.
Well, and Your Honor's precisely right. That's why it's no hardship for them to come to North Carolina. They've been doing it since 1991 on a regular basis.
Well, I think the issue in forum let me get the right phrase here, hold on one. In forum shopping, what you say on its face sounds reasonable, except all these cases that use an exception to the priority rule talk about anticipatory suits are an aspect or a form of forum shopping. If what you say is true, you would never have a case in which priority is denied because of forum shopping, would you?
I think you would, Your Honor, and for this reason. Sometimes people will forum shop for what North Carolina courts certainly view as an improper reason. So if we filed in North Carolina, and the classic example is Ohio Corporation filing in North Carolina because it doesn't like the law of the state of Ohio and wants the law of the state of North Carolina to govern. That is improper forum shopping because you're trying to manipulate the forum to avoid the application of law.
How about I want to file in, where's the city in North Carolina?
Charlotte?
Charlotte. I want to file in Charlotte because of Wake Forest, Duke, NC State, Carolina. Have I missed one?
No, that's the only ones, just the four of them.
That's 4. That's not an aspect of forum shopping?
No, no different than Florida State wanting to file in Tallahassee. I mean,
There's a difference between an anticipatory lawsuit and the plaintiff's right to choose a proper, which we haven't gotten to that yet, but a proper venue.
And Your Honor is exactly correct, and Judge Bledsoe went through that and found that we did have a right to choose the venue because if we didn't have that covenant not to challenge the validity, it would be more of an anticipatory lawsuit. But here we believed that they were about to violate that covenant. And so we sued in North Carolina to enforce that covenant. And there's nothing improper about that. That's not forum shopping. That's forum selection. No different. I mean, Florida State could have come up to North Carolina and sued the ACC on December 22nd. They chose not to do that. They chose to have this on the last business day before the Christmas holidays. And those are their choices, and I'm not saying they're improper. But they're no less proper than our choices that we made.
What I'm dealing with, though, instead of having this argument, and I know we spent half a day on it, but the way I read this case, I think this is the argument everybody's most interested in.
Yes. Well, Your Honor, I think it's a critical argument. And,
Yeah.
And if I can, Mr. Lawson does have one case
I
I'd
know.
like to bring to the court's attention.
But I'm late for lunch, but anyway, I had a point, and it's coming back to me. Oh, you could have protected ACC rights by filing a counterclaim. You've got Justice Lawson, who's known throughout the state as a constitutional expert, who was on the Florida Supreme Court. He's in Tallahassee. You think you would be prejudiced by having him represent you in Tallahassee?
And
I don't.
I say the same thing about, they have excellent counsel in North Carolina. And I'll tell you, every day I go into work, and maybe I just notice it more, I'm looking at a Florida State University license plate on North Carolina vehicles.
Well, that's because half the state of Florida is moving essentially to North Carolina.
Or they live in the mountains.
Yeah.
But so the same argument can be made with Florida State. They can bring their counterclaims in North Carolina. There's nothing to prevent them. They have excellent counsel. I don't work magic in North Carolina. I'm just a lawyer.
What I'm going to do, I want to hear from Mr. Lawson, Justice Lawson, I'm not supposed to use justice, but Mr. Lawson, but I want to eat lunch first. So why don't we come back about 1:10?
Thank you, Your Honor.
Okay. The plaintiff's lawyers, don't worry, I haven't forgotten about you.
Thank you, Your Honor.
Okay.
We have some thoughts.
Okay, I tell you what we're going to do. We're going to open up the phone lines immediately. Immediately. Now, just a few things. One, if you just joining us, please subscribe to the channel. Smash the like button if you like our content. Please smash the like button. Look, right away the judge said, I got all day. I got all day. I expect this to go longer than 90 minutes. It's definitely going to go longer than 90 minutes because we haven't even heard from the Florida State lawyers yet. The plaintiff, as Judge Cooper just said. So they're going to go to lunch. They're going to come back. We got to keep our head on a swivel. Make sure when they come back live that we're on it. And Judge Cooper also said, well, I'm not going to do a 76-page ruling. I don't have a staff like the business court does in Mecklenburg County. Judge Cooper, in my estimation, has been real tough with the ACC in regards to jurisdiction. I don't think he's buying what they're selling. I don't think so. But you know what? You've heard enough from me. You've heard enough from the judge and the lawyers of the ACC. Now, let's hear from you. And how do you think, whoops, I screwed up. Hold on. Let's hear from you on how you think this case, how it's going so far this morning. The phone lines are open. 763-260-1333. Now, I'm going to have to possibly cut the phone calls at about 5 to 6 minutes each. Unless you're one of the lawyers that call this channel, then I'm going to give you more space to communicate with how you think this is going. But the phone lines are open. 763-260-1333. Chad Bracey says the judge is eating the ACC for lunch. Kerry Gold Knowles says it's ACC filet. Matthew Wallace, just imagine people are paid well to talk all morning.
Call from
Crab Cakes and Football.
Crab Cakes and Football, Mr. Terrapin. The floor is yours.
I don't know if they're going to get it all in today, Greg.
They might not.
Yeah, I mean, he may have wanted to, but he's taking a long time on that one subject, and they got 6 of them to go through, I think it is.
Yeah,
but,
I don't know. We haven't even got to the Florida State lawyers yet. I bet they get to them pretty quickly after lunch here.
Yeah. I mean, I'm not a lawyer, so I'm not going to even attempt to play one or anything, but it seems like he's bringing up a lot of case law that favors Florida State, and even got the ACC representative to admit that on one occasion that, it does pertain to that, but it also pertains to that in North Carolina. So I'm just thinking that, this is a slow roll death for the ACC in this lawsuit.
So far, it's most of it, all of it, basically, this morning has been about jurisdiction. And I'm not a lawyer, but it seems like at this point, the judge, who at the very beginning said, look, I've been reading up, I read all you guys' pleadings, I think this case is going to continue on in Leon County, just like it's continuing on in Mecklenburg County. That's my take. It sounds like you agree with me on that.
Definitely.
Yeah.
And so they're either going to have to settle or they're going to have to go to the federal court, and then you're going to have to find a federal court that can take both, because both states have different federal court systems.
Yeah.
So,
yep.
this is probably going to go to settlement beforehand, because it doesn't sound like the judge is going to block anything from being out in the open. I think he's, willing to lay it out there, because he pretty much said, wait a second, you make these contracts and you don't give these contracts out to other schools. They got to come to the secret vault in the bottom of your building. And it's, if I'm have a contract with you, I'm going to have my copy and you're going to have your copy.
Mm-hmm.
So I think that's where this is going. But like I said, I'm not a lawyer. I'm not even going to pretend to play one. I'm a truck driver.
Yeah.
So,
All right.
But, all right, man.
I appreciate the phone call.
Florida
Craig
State
Gates
wins
of
this one.
football.
Have a good one.
You too, sir. Now, Immaculate is cautioning everybody. We really need to see how the conversation goes between the judge and Florida State attorneys. Grillmaster saying the same thing. We'll see how the judge interacts with the Florida State lawyers later on. We haven't even heard Florida State side yet. Absolutely. I'm just saying, thus far, it doesn't seem to be going too well for the ACC. But again, we're going to have to listen in on the interactions. As Grillmaster and Immaculate said, going to have to wait on the interactions between Judge Cooper and the lawyers of Florida State. But, now most of this has been about venue, about jurisdiction. But when Judge Cooper, when he tipped his toes into the waters of the ESPN ACC media agreement, look, I don't know. I'm not a lawyer. I'm not a psychologist. But he really, he got up on his chair and he's like, Florida State, a public university in the state of Florida, sunshine laws, with a contractual agreement with the ACC and ESPN. He goes, I don't know if any. He put up his hand and says, I don't know any public institution, government agency, anything in the state of Florida that has to do with the public, with a contractual agreement somewhere, having those agreements not be public view. So when he tipped his toes in the water there, I don't know, maybe I'm reading it all wrong, but I think it's a very bad day for the ACC. And if Judge Cooper keeps, when we get back, boy, I cannot wait. I cannot wait until he interacts with the Florida State lawyers. Of course he's going to be tough with them at times, right? Hola Wapo, Mireya Hernandez, the moderator. Love your eyes. Well, what can I say? Hey, Mireya, now that you are listening to this program, you are at work. This is going to be going on all day. I know you get out of work at 2:45 Central Time. We might have somebody picking you up, because this is going to go on all day. This is a big news.
Call from
Immaculate.
Mr. Hawkeye, the floor is yours. Am I too far out over my skis on what I think what's happened so far this morning?
No, I mean, I made a comment. There's the easiest billable hours ever for Florida State. Like they don't even need to really be there right now at this point. But I do caution to say he might use some of the same tone with them, and that just might be his style. We don't really know yet. We don't have something to compare it to. But my thoughts are that the Florida State filing in North Carolina, the appeal going on at the exact same time as this, that feels a bit strategic. Not coincidental. Forcing them to focus on multiple fronts at the exact same time. You know, we're paying attention to this. They're watching the live stream too of this, of course.
Yep.
You know, and then they're getting news from their persons down at the court, whatever, that this was filed, that now the appeal to the Supreme Court, now they have to worry about that. Now, when that happens, if that goes to the Supreme Court, that might be where you start to see other parties start to get pulled in. I mean, that's pretty quick. You know, they haven't even gotten to the meat of that case. That was just on motions. They're appealing the judgment on motion.
Yes, sir.
It's
Yes,
not
sir.
even the actual case.
Yeah.
I don't know if that's out of norm, but I understand from just talking briefly, like the motions for dismissal, they get thrown in every case. You don't appeal though. So the fact that they're appealing that and just trying to go straight to the North Carolina Supreme Court, that is interesting. Don't know what that exactly means at this point. I'm sure you'll go more into that later.
Yeah.
But yeah. What you got?
I'm all fired up to see the interaction here with Florida State lawyers. You could tell that Judge Cooper, because, you know, he's not ruling on the validity of the grant of rights. You know, none of that has to do with these. He's not, you know, this is about dismiss or stay from the ACC, dismiss or stay in the court in Leon, you know, in Leon County. You could tell he wasn't really read up on that. But when it comes to jurisdiction, man, he seems, I know we can't read too much into it. I get it. But I'm still going to be guilty of it, Immaculate. He seemed to be really like, I don't know. Anyways, go ahead.
I would say what I said in chat several times, and I put this on X a while back, is a very real thing is you don't want to make a court feel insulted. And when I say that, I mean the judge. But when we say that as an entity, you don't want them to feel insulted. And that's kind of what people all seem to be doing, is I think that these courts are going to be wildly biased to one side or another. And, you know, they have their inherent biases, but they also, these two courts have different laws that they're ruled by as well. But when you basically infer that you think these courts in this state are going to be more fair to us than you're insulting a court. And that's what I'm seeing. I'm not seeing like a judge being biased, but he keeps going back to stuff. Like, I'm having a hard time following, like, okay, what exactly is actually being at hand here in this case? Like, I'm not quite sure what is going on, because it feels like the insulting the court part keeps coming up, where he's like, so why are you up there when we couldn't do it here? And that the court definitely feels insulted. And that's my take on this so far. So I need to see how he deals with the Florida State lawyers, because it's jumping all over the place, and he's doing a good job. But and I think that ACC lawyer is actually pretty good. I've seen comments that, you know, he's terrible. No, the first one, he seemed way out of sorts. But this guy, he sees what he's up against. He's trying, but he's going up a very steep hill right now.
Now, the second guy did make a mistake, and I caught it, and somebody in the chat caught it right at the time. I think the ACC counsel misheard the judge. I'm going to show you a tweet from Matt Baker, Tampa Bay Times. Everybody in the chat, take a look at this. This was said. I heard it, and so did somebody in the chat, and I made a comment about it. The ACC counsel says the league retains Florida TV rights no longer than the end of 2036. Then the judge asked if Florida State can pay a $130 million exit fee and not pay anything else. Mm-hmm. And the ACC counsel says, that's correct, Your Honor. Now, obviously, that's not the ACC's position. But the
Right.
ACC counsel, I don't think you heard the judge correctly on that. Go ahead.
Yeah, I mean, people are going to pick up on that and be like, "Oh, we got him," but
Yeah.
he doesn't speak for them in that regard.
Yeah.
I think he was just saying that's correct, that could be the case, or they could do that. But yeah, he can't. He's not negotiating for the ACC in that regard. So
and the judge has brought up a couple times. He goes, I don't want to go there. It's not my job. I don't want to go there. But he has brought up the phrase mediation between Florida State and the ACC. You guys could just mediate. You guys just could mediate. He's actually kind of throwing out some possibilities. What do you think of that? Does that mean anything? I know this is not a mediator, but he's thrown that out there a couple times.
The North Carolina judge said the same stuff, essentially. I mean, differently, because, this guy's got past in mediation, and so he's had a little more to say about it.
Yeah.
Because he has a little more experience in it, I think. But that's the one part where the two judges seem to be on the same page. Like, why is this even here?
Yeah.
Why are we doing this when you can just settle this thing and come to mediation? And I think the answer to that is that's where we're going, but both sides want to set the tone for those talks. They want to be the stronger party in those talks. And so they're using these cases to make points into what might be invisible to most people, largely myself as well, trying to have this perceived position of strength for those settlement talks. Yeah. And I would say, the ACC gained some strength from what happened in the North Carolina court. That's probably why FSU immediately appealed it, trying to mitigate that gain. And right now, so far from what we're seeing, the FSU is gaining on their side.
Yeah.
Especially because some of these little things, like that guy doesn't speak for the ACC in those negotiations.
Yeah.
But that's going to come up.
That's
going to come up, like those little comments. I mean, these things are going to come up in the talks. So we really need to see how he talks to FSU.
Sure.
That's my final.
And in regards to perceived strength when it comes to negotiations, leverage, right? And this is what I picked up on, even though it wasn't really part of what they were talking about. Here's Grillmaster in the chat. The truth of the situation is that they want broad discretion, the ACC, ESPN, to seal the documents. They don't feel like that they'll get that in Florida, right?
Mm-hmm.
And so I don't think this is just my opinion, I don't think there's any more potential for Florida State to gain perceived strength, to gain leverage when it comes to negotiations, more than the situation with ACC, ESPN media agreement being under lock and seal because of trade secrets. If that is in danger, and I think it is, if that's in danger here in Florida, I don't think there's any bigger potential leverage point that Florida State's going to have when it comes to getting the mediation started, getting it resolved, getting it as a number that Florida State would perceive to be in their favor. What do you think about that?
I'll try not to go too long. I know you're going to have others, but I think that this could push. I don't think ESPN is going to opt back in with the same deal with the ACC. I think that if they wanted to, they already would have. I think they've been holding off and pushing that for this to get dealt with. But I think at some point in time, like you're saying, when everything starts to get brought out, that goes into their deeper business. I think they're going to say, get this thing settled now. We need to get this wrapped up right now, or you're really not going to appreciate the renegotiation talks that happen with us, because you're not getting around those. That's happening. So settle this now. Do not put us at risk, or else. that would be my take from ESPN. At some point in time, they're just going to have to put their foot down and be like, enough's enough.
Yeah. All right, man. I do appreciate it, Immaculate. We're going to be on all day, so give us a call later on once we get more information.
Yeah, I'll stick around as long as I can. I have to work to get done. Eventually, I was like, it's only going to be an hour and a half. We're good. But this is looking like a marathon.
Yeah. Appreciate it, sir.
All right. Talk to you later.
Thank you. Now, keep your head on a swivel. Let me know when they come on live again. I don't know when that happens. I did not get a time on that. So let me know. The phone lines are open. 763-260-1333. 763-260-1333. Thank you all for joining us. I appreciate it. If you haven't done so, or if you're new to the channel, please subscribe. Hit the subscribe button and open up your notifications. We can come on at live anytime. We do PATC in the morning. We do it at lunch. We do it at nighttime. We're talking college football, spring football games. We did a watch party last Saturday. We're in the courts this Tuesday.
Call from
Steven.
Steven, thanks for calling, sir. The floor is yours.
Hey, Greg. I was just wondering if, after your nice sports book presentation last night, if you're going to have to change a few things after today's case.
I don't think I will. But I'm interested in what your how you might think that might happen.
I don't know. It's interesting that you put Virginia at the fourth spot, just because of the AG's and Attorney General's involvement in everything discussed previously. I guess that's beside the point of today. I feel like that might have a little bit of, there might be a little complicated issues there before anything's resolved. I felt like when I was listening to that, it doesn't take an expert to understand that I felt like that judge was getting progressively irritated at the individual representing the ACC, talking about how North Carolina law, North Carolina law, North Carolina law, North Carolina court ruling, and he's basically saying, yeah, I'm going to do what I want to do. I understand that this occurred. This is I'm not making a judgment about their stuff, but I'm going to do what I'm going to feel like is good right here. I don't know. I feel like a lot of states and their court systems, they like to mention their own statute, and I don't know. I'm just feeling the progressive irritation vibe from this individual, and I'm not sure if that's going to give the ACC what they want.
There are people in the chat that agree with you. Immaculate says, yep, the caller is correct. The judge was feeling more and more insulted. I agree with you, sir. I think things were going a little bit more pear-shaped for the ACC right before lunchtime.
Hopefully they mention maybe Florida law and try to speak their language on stuff, because otherwise I feel like Immaculate's right in his previous comments about insulting the judge is typically not a good way to go about things. Mm-hmm. Yeah. I'll see you though, and I'm not sure how things will go down. No one knows, but I feel like some of the everything but Virginia, I think, is pretty solid. Just Virginia, I'm not sure how that would go down. I'll see you.
All right. Duly noted. Thank you, Steve. I appreciate the phone call.
Bye.
All right, sir. Great call. Great call. Again, it's just a motion hearing. No question about it. Thank you, Elliot Cruz. Absolutely. Absolutely. Okay, I'm going to check out and see if there's any reporting on this. And then, hold on one second here.
Call from
Rock and Rant.
Rock and Rant, Mr. Hurricane. The floor is yours.
Well, that was at least entertaining, if nothing else, right?
Yeah, yes, it is. And I think it might get a little bit more entertaining once the Florida State lawyers get in front of the judge.
I wouldn't doubt it at all. I mean, I do think the judge was dunking or goofing on the ACC via their lawyer often. But, I mean, if you really take a pause outside of being in the moment now that we're in a break, I don't think any ruling we're going to get today or tomorrow is anything different than we probably would have expected before. Like, Florida's just not going to dismiss this case in Leon County because North Carolina got it first. Like, that's just not going to happen.
It seems like it.
So I think it's the same thing. But what I think is happening is, I don't know if people have seen the movie 13 Days about the whole Cuban Missile Crisis, is there are the words that are being spoken to get the proceeding going. Yeah. And there's the message that's trying to be delivered. Like, the blockade wasn't about, it was moved, right? It was signaling, it was talking to them. And I think the judge is basically trying to signal both directly from the illusion that every civil court judge does about mediating and settling outside of court. Like, that's a common thing in almost every one of these cases. Are you sure that you want to keep going? But I do think he's signaling through the questions, not so much about his ruling today, but, hey, ACC, just know I'm not a local country lawyer, even though my vernacular might be simple. This is not going to be the playing ground you want to be on to the degree you want to from what I've already read, and you can convince me otherwise, but you might really want to think about settling in terms of, adherence to Florida law, adherence into just the sunshine laws and that, and just maybe trying to give one last blast of where his head is to those lawyers before they proceed down the next step in this trial journey and trying to get them to maybe talk offline and come to a settlement. That's what I kind of think he's potentially doing, even more so than trying to figure out whether to let the case proceed at all.
Well, I don't, I mean, his duty is to rule on whether the case continues to go on.
That is his duty, but I don't. The odds of him dismissing the case were pretty slim to begin with, right? So it's just not a normal thing that happens, even with the first to file and the references to other cases. It just, if you had gone through all of your panel of legal experts of whether they thought Florida would dismiss the case today before we started the proceedings, I think that the chalk would have been it's going to keep going. And I think it's probably that or greater now still. So every time you have the lawyers together in a room, you're going to try to deal with the proceeding at hand, but you're also trying to give them a hint of what the future might lie so everybody understands where the judge's head is at.
He's definitely brought it up more than once. The word mediation.
For sure.
Yeah.
Now, on the flip side, like, two things I think that are important. If I were him, I would try to avoid, even though it was an awesome shot of like choke at Doak, because you just don't want to give any lawyers a hint of like, wow, he's really in the bag for Florida State. He's a hardcore fan for any appeal. Not that I think that would be the basis of an appeal. It's just those things you just, that's an appearance that you don't necessarily need, even though it was awesome. Because, I despise Florida, so that's actually even a great reference. So I would just avoid that. And then I would just, for everyone, I'm sure this judge is aware that there are way more eyeballs tuned in than what normally would be done in his case. So don't necessarily assume that the way he's phrasing things is the way he might do it on a normal case when no one's paying attention, because he knows there are eyeballs on there. If you just look at the Supreme Court as a completely different reference, Clarence Thomas was known for decades for almost never asking a question or never asking a question from the bench until key cases came up and they were letting audio recordings go out of the live sessions, and it suddenly changed. So, there's a little bit of showmanship, I'm sure, going on as well. It might not be at the forefront, but it's not out of his mind. So if he's simplifying things and people think that means he doesn't know what's going on, I wouldn't take it as that.
Yeah. All right, sir. Call again, Rocket Rant, when we get more stuff happening early this afternoon, okay?
Yeah,
if you have time. If you have time.
Now.
Appreciate it, sir.
All right.
You got it. Okay, so what I'm going to do, I'm going to be taking a quick break. Just a quick break. I'll be back here about 10 minutes. I'm going to just keep it all running here. Now, I got information that the judge is going to be back at 1:10 Eastern Time, 12:10 Central Time. 1:10 Eastern Time, 12:10 Central Time. I'll be back before then. I need a little break. I need to get a little substance in me. I'll eat real quick and I'll get back here. Let me put on, before I take my break. So if people come into the chat and they're asking what's going on, let them know. We'll be back shortly. Let me make sure. I'm going to just check out something real quick here. So I took the phone line off the hook. I'm going to be taking a quick break. It looks like the live event stream has gone black. So hopefully the live stream will be working when I get back. So for the moment, I'm going to be leaving just to take a little break. I'll be back. If people come in here, they don't know what's going on, let them know. We're going to be resuming here soon. 12:10 Central Time, 1:10 Eastern Time. Judge Cooper will be in his chair, and the fat guy from Minnesota, the Godfather, I'll be in my chair. So if you all need to leave to take a little bit break, go ahead, but then come back. PATC. If you're new to the channel, please subscribe, have your notifications on, smash that like button. I am glad you are all here to watch Leon County, Florida State versus ACC. And I think it's gone a little pear-shaped for the ACC. I will be right back. We are live. We are live. According to the clock, we are 6 minutes away from Judge Cooper going back in his chair, and proceedings will begin again. Thank you for your patience. I appreciate it. Thank you for sticking around. I appreciate it. Keep your head on a swivel. I think that's what we're doing, hopefully. It's going to be very interesting to see the interactions between Judge Cooper, the questions he asked towards the Florida State lawyers. This is a hearing about the motions, the motion to dismiss or stay, and I think it's looking good for Florida State, but we'll see what Judge Cooper says at the beginning of today's proceedings. Judge Cooper said his goal, he thought he would rule by the end of the day. He thought he could give a ruling by the end of the day. It wasn't going to be a 76-page ruling. We'll see, because this is going long. This on the docket at Leon County Court. On the docket, it was scheduled for 90 minutes. 90 minutes. 90. And it's gone way past 90 minutes. And we haven't even heard from the Florida State lawyers. But Judge Cooper did say that he thought it was going to go over 90 minutes. And then he has all day. All day. So, okay, keep your head on a swivel. Keep your head on a swivel. Keep your head on a swivel. Why is LFG saying no audio? Can people hear me? People having a hard time hearing me? Hopefully not. We do not have we're gonna open up the live stream once, right now this is what we're getting on the live stream. So hopefully when the judge gets back in his chair, we'll have the live stream ready for you. That's what we're hoping for. Okay, good. 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 Audio's fine. Okay, so if you're new to the channel, please subscribe. Open up your notifications. Smash the like button. Please smash the like button if you like the content. If you want to support our channel through a donation, just hit the $, make a comment, and we'll get to it as soon as possible. If you want to become an early peak cloak and dagger member of this college football channel, go to the link provided in the description box. Hit the link, hit the join button, and become a member. And there is a really good chance we're going to be dropping a new Cloak and Dagger early peak episode early tomorrow morning. It has to do with North Carolina Board of Governors. And we're going to be talking just a little bit about Conference USA. So if you want to become a member, go to the link. We're going to drop a little bit of Cloak and Dagger nuggets in there tomorrow morning. And then, of course, we have episodes open to everybody. We've made, 386 of them. Go to our YouTube channel and watch our episodes. But we also have membership-only episodes, Cloak and Dagger. So to become a member, go to the link in the description box. Hit the link, hit the join button. So let me check. We are at 12:10. We are at 12:10. I'm checking for any live streams. The judge supposed to be back at 1:10 Eastern, 12:10 Central, and that is where we are right now. I do not see a live stream that is working as of right now. Let me know in the chat or by a direct message on Twitter if you see one that's working. Stephen Vitt, is the court back from lunch? If they are, we cannot see it because the live stream is not up yet. We do not believe the live stream is up yet. At least I cannot, it's not working on my end here. So far they've been running late, coming back from their breaks and now lunch. So be patient. I think we're okay. Gay the Hater says it's 12:30. It was reported on X that it was 1:10 Eastern time. Moen says Greg crashed the live stream. Cooler for life. God. Get out of here. You're killing me. Mr. Buckeye's killing me. Yeah, 1:10 Eastern time. And we're at 1:13. We are at 1:13. So we should be coming up here soon. I will keep checking the link. I've got nothing. So far. Again, we did open up the phone lines during a break. We did open up the phone lines the first half of lunch, but then I needed to take a break. If this continues on, we'll open up the phone lines again. But I'm thinking this is going to start pretty quick here. Bear Alexander, possibly going to the portal. Man, I remember when he was getting recruited first out of high school, man. Woo! A lot of offers for Bear Alexander. Minnesota Seminoles, time is being kept by the ACC referees. Tyler Brown, Greg causes blizzards with his cooler sports picks. North had a warm winter because he had a hot streak. Tyler Brown, you are either on something or on to something. Okay, come on. Come on. Let's get something to work. Let's go. Okay, let me check if reporting from 247 Florida State, because they are in the courtroom. Um, 13 minutes ago, it was reported that they're set to resume in the next 10 to 15 minutes. So, so this should happen here. Again, this morning it's all been questions, Judge Cooper, to the ACC, a couple different lawyers from the ACC. One of them being Lawson, who was a former judge in the state of Florida. But we haven't had any questions. There's been no interaction between Judge Cooper and the Florida State lawyers. I think we're going to be seeing that real soon. After they get back from the lunch break. And if you missed it, breaking news earlier today, Florida State has appealed the ruling from Court Chief Business Court Judge Louis Bledsoe on the opinion of the defendant's motion to dismiss or in the alternative stay. Florida State is appealing that to the Supreme Court of the state of North Carolina. That happened earlier today. Now, let's see what is going on here. It has resumed. It has resumed according to people in the court. It has resumed according to people in the courtroom. I'm trying to get a live stream here. It has resumed. Sounds like Cooper is in the chair. But so far, I have not been able to get a live stream. This is my live stream. So let me know if anybody out there in the PATC community, if there is another alternative. But right now, that is the live stream that we're looking at. We're going to be working on getting you a live stream inside Leon County. Kurt has the same thing. Lawson is back at the podium. The lawyer for the ACC is at the podium and is citing a case in Florida. Anticipatory filing and impact on principle of priority. So the ACC lawyers are back up there on the podium. We have yet to hear from the Florida State. Lawson is providing the printed versions of the case to both parties and the judge. Another case is being cited. Again, this all has to do with jurisdiction. I'm going to do the best I can to give you the information on what is happening inside the court. And we'll keep checking the live stream. Right now, the live stream has gone PATC pear shape. Again, nothing on the live stream. I will keep checking.
it goes with the territory. Okay, I'm at 10.
Okay, so if you go again to the second page, you see where it says, upon reviewing the pre-filing history of the dispute, it's okay.
I'm there.
The court concludes that the first filed action was filed in anticipation of Cyrilnik's impending lawsuit. And then they looked at factors similar to what Your Honor looked at from cases from other jurisdictions that do not have Florida's principle of priority, and said that there were settlement discussions that tipped the party off, and so they rushed into court instead of utilizing the traditional choice of forum rules. They just went in anticipation to try to get a more favorable forum. And so when you slip back to tab 15, you'll see that the third DCA recognized that that was not an extraordinary circumstance requiring a stay, and that's the reason why they reversed. And that makes perfect sense, Your Honor, because the rule is that if the principle of priority applies, which means if we served first, the first court to exercise jurisdiction retains exclusive jurisdiction over every question and every issue arising in the case. Everything else that we've been talking about this morning, including whether the North Carolina action was anticipatorily filed, is a question that under our principle of priority in Florida is reserved to the court that has exclusive jurisdiction over the matter, and that is, in this instance, the North Carolina court. I'll cite one more case, and that's In re Guardian of Morrison, because, and that's at tab 13 of our hearing notebook. It's also, I quote from that as paragraph 6 on the one-pager that I gave you.
Paragraph 13, okay.
Tab 13.
I've read this case.
Yes. And in that case, what the second filed party or second served party attempted to do was avoid the rule of priority by saying, well, no, Judge, Your Honor, the out of jurisdiction court does not have jurisdiction. They don't have jurisdiction to hear this case, so you should go ahead and decide that they don't have jurisdiction and consider those arguments, and you should refuse to stay. And what In re Guardianship of Morrison says is that unresolved questions regarding the out-of-state court's jurisdiction do not bear on the local court's decision that the principle of priority applies. So all of those issues, all of those questions that might arise in the case, and again, we're talking about one case and two courts with concurrent jurisdiction, all of the questions that arise are properly, under Florida law, considered only in the North Carolina court, which has exclusive jurisdiction to decide those questions, because we served first. That's the law in Florida. It's clear, and I would suggest that it would be an abuse of discretion to refuse to stay the case under these circumstances.
Could I ask you a question?
Of course, sir.
What complicates this situation now is the third lawsuit, the Clemson suit. So we have Florida, South Carolina, and two in North Carolina, with the FSU North Carolina suit and the Clemson North Carolina suit. So you heard the 10-point analysis issue. How does, on the point of having a uniformity of result, how does the Clemson case affect that, in your opinion, if it does?
That's a very good question, and the answer is it doesn't affect it at all in terms of your decision whether or not to stay this case, because under uniform Florida precedent, there is no exception unless there is an exceptional circumstance. Again, which is not an issue in the case. It's not a question to be decided in the case. An exceptional circumstance is they're going to delay so long, or we have children here and they need a home, and it's those kind of things external to the issues of the case. Unless it's one of those issues, it doesn't bear on your decision as to whether to stay or not. The only thing that you consider is priority. That is Florida's unique rule, and it doesn't. So that's
that's the answer. The Clemson's lawsuit doesn't matter at all when it comes to your decision on the stay issue.
Okay.
Okay,
Thank you. So let's turn it over to the plaintiff. Okay.
Thank you, Your Honor. Peter Rush again on behalf of the plaintiffs, Florida State University Board of Trustees.
Okay.
Plaintiff, Florida
This
State.
is a motion to dismiss for failure to state a claim, and I have a bunch of arguments about the claims, but it doesn't seem like that's been the focus of the court this far.
It's not that we won't get to it. It seems that the stay sort of is driving the case at this point. It's not that those other issues aren't also very important.
All right, so I'm going to try to address several issues that you discussed with the defense counsel.
All right.
You are right. Siegel controls, and the language of Siegel is additional circumstances. They're trying to weave in extraordinary circumstances, but the Siegel case, which you recognized first, calls it additional circumstances. I'll get to that in a minute. There are a lot of them here. Most cases, including the ones they just cited to you, involve exactly what you pinpointed during your questioning, which was a federal case filed in front of a state court case. And that's when comedy came into play. And I'll get to another case shortly, and it's the United States Supreme Court decision in franchise tax. And in that case, they said when issues come down to sovereign immunity, comedy goes out the window. This case involves sovereign immunity, and it involves Florida sovereign immunity. It involves $700 million of Florida's, the state of Florida's money.
So let me ask you this.
Yes.
Maybe you can answer this. On the reservation of rights issue that we talked about, is that only in the past, or is that for future games until 2030?
No, I could tell you're a Boston Celtics fan, Your Honor, and you do like watching the dope choke. I can hear that.
Well, I won't say I like watching it. I'm just saying it's on all the time.
So the way the ESPN agreement works, and again, we're handicapped, and I'd like to address that first because during the break I spoke to the general counsel of Florida State University, a state entity. She said the circumstances under which they're allowed to look, just look, at the ESPN agreement, which is 160 pages long and dictates this entire case. They have someone sit in the room with them and they question them, are you writing that down verbatim? Are you writing those words down verbatim? Now, what Mr. Cooney said during his oral argument is we don't need to worry about the ESPN contract. Oh, yes, we do. We need to worry about it on commercial efforts, on confidentiality, but most importantly, Your Honor, for the paragraphs 142 and 143 in our amended complaint, which say the grant of rights extends only to the rights necessary for the ACC to service the ESPN contract. Well, we've sent our lawyers up there, including Miss Egan. She sat in that room. She was asked whether she can look at these and whether she's writing it down verbatim. And you know what that contract says? It only applies to games while the member is a conference institution. So when a member leaves, the ESPN agreement has nothing to do with it.
So there's a potential dispute, which not particularly dispositive here, but a potential dispute on what the retention of media rights covers.
Exactly. So when they tell you the North Carolina case is all about the status quo, it's not. What they're going after, Judge, is they want to take, in North Carolina, the next 12 years of every home game that Florida State plays. And if you'll bear with me, Your Honor, all I need to do to point you to the paragraphs is the paragraphs in their original complaint. That would be paragraph 121 and 127. For the record, I want to read it in.
Okay.
Because they say this was just the status quo. No, there was no harm, it wasn't material, nothing was happening up there. I'll find it in my outline.
Sign of all good litigators are ones who can't find what they know is in their.
Yes, in their pile.
That happens to me all the time.
I apologize, Your Honor. Well, let me just say this.
You can paraphrase it if you want.
I will paraphrase it. It is paragraph 125, which says, the property at issue here are the Florida State media rights to their home games. That is intellectual property. They are worth at least $1 million.
You mentioned this in your memorandum on response to the discovery stay, I know.
I did, Your Honor, and if I may approach the court,
Sure.
just hand there. And I'm only going to hand you the one page.
Okay. And
I worked for a federal judge and a trial judge, and he didn't like getting piles like this either.
right. And Mr. Lawson has a copy of what you're
He does.
handing me. Okay.
This is the original complaint, the one that didn't change the status quo, it left everything copacetic. What sure as hell did. It said the conference is entitled to a declaration by this court that the grant of rights and amended grant of rights are valid and binding contracts supported by good and adequate consideration, and that the conference will remain the owner of the rights transferred by Florida State under the grant of rights through 2036.
So is this where the $500 million total
That's exactly where the
damages comes from?
It's projecting out the loss to the state of Florida of 12 years of what should have been the national champions' home games. That's what it is.
Mm-hmm.
And that's what it means, and that's what it means to this community. This is not something that should be taken in North Carolina. If there's going to be taken, it should be taken in the state that has the sovereign protection.
So let me get your section on that. I think it's in this book. Hold on. I just want to response to motion to stay discovery, which overlaps, it seems to me, the stay the case discovery. Okay, this will allow me to follow along with you because you made this taking argument there.
I do, Your Honor.
Okay.
And so if you look at paragraph, so the question is, who owns the property? The property being the next 12 years of the national champions' home games. Who owns it? And what they asked for in North Carolina in an anticipatory filing, and you're 100% correct on that, no matter how long we talk about it, was they want all those games. They want every one of them. And you know what the real irony here is, Judge? ESPN's not going to pay them anything for them. They're not going to get any money from ESPN for those games. They're only just keeping them away from us.
Why would ESPN, let's say FSU leaves in a year and they play University of Georgia and they win. So that ESPN wouldn't pay somebody for that game?
No.
The right to play it or something like that?
Because at that moment, in that instance, under the language of the contract, Florida State is not a capital C,
ESPN
conference
would pay
capital I
ACC, though.
institution.
Mm-hmm.
ESPN would
So
pay ACC.
ESPN, as you understand it, would have no requirement to pay for games which, for FSU, games FSU participates in if it's no longer a member of the conference.
For example.
But the conference still has rights to that game until 2036?
They would own that game,
Yeah.
and they would not be paid for that game, and they certainly would not pay for Florida State. And the practical problem is Florida State would no longer maintain a production facility on its campus for the use and benefit of the ACC.
So
Because it's no longer a member.
how would one, if you're valuing the value of those media rights, how would one value games in the future if, as I understand, ACC would own them, but ESPN would not have the right to pay for them. Is that a value at that point?
It would be a value to Florida State, and that's the whole point. The objective, and if you look at the allegations of the complaint, and I know I'm jumping ahead, but a big part of our case is that this is an unconscionable penalty and that it's a punitive scheme intended to damage people. And that's what it is. And why do I say that? I say that because the highest ranking members within the ACC have said that we're supposed to stop barking and wait until our rights, we get them back in 2036. That same individual, just a week before the hearing in the Mecklenburg County Business Court, said the price tag for leaving the league is $600 to $700 million. So my number, the number in paragraph 161 of our amended complaint is too low. It needs to be $130 million higher. Now the valuation comes from what the current rate for those home games are being paid under the existing ESPN contract, which we maintain is not adequate.
So ACC would say, accepting on your face your argument, they would say it still is better determined in North Carolina. So what's your answer to that?
My answer to that, who's from North Carolina here? This is a two-party litigation, and the only property at issue are home games played in Leon County. That's where all the games, that's where all the product is made. That's where all the widgets are made.
That's the taking argument that the property is located in Leon County.
Correct.
Because that constitutes a home game.
It does.
If it was in Orlando and FSU was deemed home game, that would be covered too?
That would be covered too as well.
Okay.
And the added dimension here, Your Honor, is that this is an asset of the state of Florida, and a state-owned institution, and as you're well aware, the Florida State University Board of Trustees is a state agent. So when we're talking about that property, that is the sovereign property, and paragraph 121 of their complaint identifies it as property. That is the sovereign property of this state. And so when you talk about $700 million, you're talking about $700 million of the state taxpayers' money of Florida. My view, and every other Supreme Court case I've already read, if that kind of taking is going to occur, you have to go to the state from whom you're taking it to get it.
Is there anything of record in which the state of Florida has rendered any sort of opinion on sovereign immunity, public records, anything like that? If it's just in the news media, I'm not sure I can take advantage of that, but is there anything in the record dealing with that?
In the record stating what? That,
let's say, is there anything in the record where there's a position been taken by the state or some official of the state as to whether the ESPN agreement is a public record?
I think your case, quite frankly, is the most instructive and the most insightful on it.
Yeah, the NCAA case?
Exactly, Your Honor. Exactly, Your Honor. And then the question is, you hit the nail on the head. This is a commercial agreement. The terms of it, the essential terms of it, were negotiated 12 years ago. I challenge there to be any trade secret in there that anybody really wants. You have two members suing to get out of the contract. I can't believe there's something really valuable in there that needs to be hidden.
So you mentioned sovereign immunity. Tell me how sovereign immunity plays in this case from your viewpoint.
Okay, from my perspective first, this is the property of the Florida State University Board of Trustees. As you well know from the Public Records Act, that kind of property can't get transferred on a cocktail napkin. There has to be a hearing. There has to be notice. They have to do it in public, and they have to vote and ratify it. And if you look at, I won't be able to quote it, it is in our briefs, paragraphs 57 and maybe 78 of their original complaint, they don't allege that the Florida State Board of Trustees ever had a meeting, ever had a vote or ever considered the grant of rights.
So are you arguing that Florida State as a state, I don't know if agencies are right, or state entity, has sovereign immunity as it relates to any claim by ACC of breach of contract?
Correct.
And just for everybody here, I'm going to tell you what I think the sovereign immunity for contracts is. Sovereign immunity is not waived for implied contracts or quasi-contracts. It's waived only for explicit contracts, as I understand it, and I'm thinking is that airplane case?
Mm-hmm.
So you're, I think, expanding that a little bit to say you have to go through a certain public meetings and notice process to have a contract signed to be valid?
I'm saying for the Florida State Board of Trustees to transfer the media rights that are issued in this case, there needed to be a meeting. There needed to be a vote.
Okay.
It needed to come out a certain way. Now, with regard to your specific question about the waiver of sovereign immunity, yes, you waive sovereign immunity on contracts, but only in your home state. That's the law of sovereign immunity. And I know you haven't read the opinion from the business court in Mecklenburg County, and that is an honorable court, Your Honor. I know you haven't read it, but they waived the state of Florida sovereign immunity for that $700 million price tag. That was the effect of that order. It said it's waived, and it's been waived, and so the case goes forward in North Carolina, and the taking can occur, and there's no need to bring it to this county. As you know, under the state agency law, you're required to sue a state agency in the location that it is. No, this can all be done in the business court of Mecklenburg County.
So trying to transfer it to another area, as you can already tell, I like to transfer the facts
Move
of this
around
case
pretty fast,
to other things. Let's say, I don't know if any of you are property lawyers, but the U.S. Supreme Court had I think it was a regulatory takings case in South Carolina, some beach property, and at the time that came out, that was a major case. This would have been probably 25 years ago. Is Lucas versus South Carolina, is that the case name?
I don't know. I'm familiar with the case, but I do not know the case name.
I think that's the name. So sometimes I can't remember what I did yesterday, and then I can remember 25-year-old Supreme Court land use cases. But the point is that case came out of South Carolina. Is your argument is that if that case had been brought in Georgia instead of South Carolina, it would have been the improper venue, or would have had to have been transferred to South Carolina?
I don't know.
Might not be the best analogy I can come up with.
Let me just drive it specifically into this case and this contract. There is a waiver of sovereign immunity, but the Supreme Court is adamant that it's got to be a very express waiver of sovereign immunity.
So it's a combination of the public meetings law and sovereign immunity?
It's two different things, Your Honor. One, we're fighting over the property. And the question is, did it get transferred away from the sovereign entity? Part of our argument is it never has. Second part of it is they want to sue on it. And they have a right to make their claims. They have a right to claim anything they want under the grant of rights agreement. And Your Honor is right. That provision in there that they described as a covenant not to sue so many times, when you finally looked at it, it wasn't. And it is against public policy because it says you're forbidden from seeking the declaratory judgment to interpret the terms of the contract in any way that the internal affairs of the ACC disagrees with. That constitutes a breach of contract. Never seen anything like that, Judge. But be that as it may, if they want to sue on that contract, this courthouse is open. I've walked around in it today, and it seems like they could file that complaint today. And in that regard, there is a waiver of sovereign immunity for a contract claim, assuming it's legit, et cetera. But the waiver's not in North Korea, it's not in Canada, and it's not in North Carolina. The waiver's here in the state, which is putting up the money, which has the liability. And the Supreme Court couldn't be more clear. In Franchise Tax Board, they said this is exactly what it is when one state tries to sue another state. There's no waiver. It has to be an express and consent waiver. Now, I will say that the Honorable Court, Business Court of Mecklenburg County, found that there had been an express waiver. And it was because of a statute in North Carolina. So that, Your Honor, turns everything on its head to me. If you can enact a statute in State A and then succeed in waiving the sovereign immunity of State B, that's chaos. That's chaos. And I would point out, Your Honor, one of the passages that Mr. Lawson gave you in his summary as to why there was a waiver appears on the second page.
Okay, let me get to it. Can't do.
The interaction between this judge and the Florida State lawyer is a lot different than the interaction between Judge Cooper and ACC's lawyers earlier today. That's my first take on this.
All right, go ahead. I know it's here. I remember seeing it, but no, go ahead.
This is it. And this is what happened last week in North Carolina to the state of Florida.
Mm-hmm.
Because the FSU board knew that it was subject to North Carolina's Uniform Unincorporated Association Act and its sue and be sued clause when it chose to be a member of a North Carolina unincorporated nonprofit association, and because FSU engaged in extensive commercial activity in North Carolina, as described above, Farmer instructs that FSU explicitly waive sovereign immunity to sue. I've got some news for you, Your Honor. When the FSU board ratified the approval of FSU into the ACC, it was 1991. The Uniform Unincorporated Nonprofit Association Act was not enacted until 2006. So what you have is they say, because Florida State became a member of the ACC, and 15 years later, the state of North Carolina enacted what's called the Uniform Unincorporated Nonprofit Association Act. That's an express waiver of liability. That is express consent by the state of Florida to consent to a $700 million judgment in North Carolina. I don't think so. And I don't think it's for North Carolina. I don't think it's either for South Carolina. But I can tell you this, a $1.4 billion payday to a North Carolina nonprofit association is a very good day. A very, very good day, especially when it comes
combining FSU and Clemson.
I am.
Is that what you're
Yes,
saying? Okay.
FSU
Because Your Honor's
plans to
right,
combine
that this case is on
$1.4 billion.
rails
That's what
to
the
get the same
ACC
treatment.
thinks they need to pay
And-
out. Holy smokes.
Mecklenburg County Business Court is an honorable court, but it's on rails to get the same treatment. So, Your Honor, there is not a Supreme Court case that says that ex post facto law can retroactively waive the sovereign immunity of another state. And if it does, if they're right, well, in this political climate, Katie bar the door. But Your Honor, so you're asking whether under Siegel there are additional circumstances, and I would say $700 million of the state assets and its waiver of sovereign immunity is at least one. Now, I'd like to address some of the other things, and I'd like to get to the question of priority, because they've also agreed that priority attaches when service of process occurs.
Mm-hmm.
There is no dispute, and I can tell from your questions, you're onto it, that when they filed their complaint in North Carolina, it was an ultra-virus act. It was an ultra-virus act under the only thing we have that is the governing document of this organization. This is it. And it says you need a 2/3, and it's not just a 2/3 vote, it's an absolute 2/3 vote, which means when you keep out South Carolina and you keep out Clemson, you still need to get 2/3 of their votes too. Your Honor's also right that if you look at the Hostetter affidavit, he promised the minutes of that meeting on March 18th. Where are they? Who was there? What were they told? What did they vote on? But the Honorable Court in North Carolina found it all to be a ratification. And Your Honor, I'll ask you, I want you to take your time and read the affidavits of Mr. Ryan and Mr. Hostetter and look for the word ratification.
Oh, I've read them already.
Did you look for the word initiation?
I don't know that I specifically looked for the word initiation or ratification, but I read them all, and I will read them again.
So what we have is priority. And I would analogize this to the perfection of a security interest. So the question is, Your Honor, for priority in the state of Florida, who perfected their security interest first? This side did it the right way. They had a notice, they had a meeting, they had a vote, and they filed a complaint. This side did not. That was an ultra-virus act. And all the gymnastics you're seeing after the fact are a recognition of that. And the 12 pages of the good Judge Bledsoe's opinion from 20 to 32 are an extreme effort to circumvent that. But we have an agreement of facts. It was an ultra-virus act of the ACC under their own constitution, which at, I think it's page 15 of their motion to dismiss, they describe as the governing document for this organization. It was an ultra-virus act, and under both Florida and North Carolina law, it's void. So if you're talking about perfecting a security interest, they took a blank piece of paper and served it on Miss Egan there. That's not perfecting the security interest. That's not coming in first. That's taking a blank piece of paper and serving it. Why? Because it's void. And I would posit, based on the affidavits before you, they have never taken a vote that ratified the ultra-virus act taken by the ACC on December 21st, 2023. Because the votes are clear. It's clear in both affidavits, and I will have those for you as well, if you want me to bring them up, that the vote was with respect to filing the amended complaint.
I have those affidavits here. They're attached to your memo.
They are.
I've got your memo in front of me, and I'm also just flipping the page to your first memo in which you responded to the motion to dismiss, and I think there's some language with regard to the stay issue also. Hold on a minute. Yes, right here. Okay.
So the question is just naked priority. Who perfected their security interest first? The answer is Florida State. And to the extent there was any perfection of a security interest, which I posit there was none, but even assuming you give them the benefit of the doubt and say that there was, according to paragraph 51 of Judge Bledsoe's order, that didn't occur until 3 weeks later. I think Your Honor knows as well as anyone else, when you perfect a security interest 3 weeks behind the other guy, you lose.
Mike Lean.
You're not prior. You're second. And that's what this is. And the case law is crystal clear in all that. Now, they can't escape I'm going to give you a packet of documents that I would like to refer to as we go through this.
Okay.
The first one is the comment section to the Uniform Unincorporated Nonprofit Act from the state of North Carolina. This is the act, Judge, from 2006 that served to waive the state of Florida's sovereign immunity from 1991. This is it. Comment 2 says, this act contains no rules of governance. A court must, and I think Your Honor's been around long enough to know that must is a mandatory term, must resort to the rules of the nonprofit association, or if there are none applicable or not at all, to the common law. Well, Your Honor, we've got the governing document. We got the governing document, and you read 1.6.4.2. And it says no material litigation, and if suing your own member isn't material litigation on its face, 14 years of their media rights, Your Honor, I don't know what is. In any event, they have to comply with that. There's no way around it. And do you know how I know that what they did on January 12th was no ratification, Judge? And I'm not just going to tell you to look at what's in the language, what they actually said, which was we voted on an amended complaint. It's that Mr. Ryan from the great University of Virginia said we didn't ever need that kind of a vote for the original action. He said that in his affidavit on March 18th.
Yes, he did.
And if you want to see that, Your Honor.
Oh, I've read that.
Okay, you're familiar
several
with it.
times, yeah.
You're familiar with it.
Mm-hmm.
In any event, because the ACC management and Mr. Ryan never thought they needed a vote to initiate the action, they never took one. And you've been around long enough to know what ratification means. You have to know, the principal has to know what the other guy did wrong and be told what the other guy did wrong, what the Ultra-Virus Act was, and then they have to vote to ratify it. Now, Mr. Ryan said we didn't need to take any kind of vote. There is no way the action on January 12th was, the information was, Mr. Ryan's wrong, we actually needed to take a vote, and we need you to ratify an Ultra-Virus Act.
Well, trying to be the devil's advocate.
Sure.
Trying to be the devil's advocate. Trying to be the devil's advocate.
From the standpoint of the suit going forward in North Carolina,
sure,
wouldn't the act, I brought Black's Law Dictionary on material. I think it was material. Material is, it says Black's is known for being to the point. It says important and more or less necessary. So I do think it was material. However, it seems to me this is similar to what I pointed out is a condition precedent that I don't know that I can get into the does it relate back or not, but certainly from the point the vote was taken forward, the bylaw or the requirement had been met. Now, I'm not saying that that dilutes your argument on the first filing was ultra vires. I liken it more to I made myself a note in the corner of one of these memos. That if it was an ultra-virus act at that time.
Yes.
I'm not saying I agree or disagree with the judge because I don't know exactly what he said.
Sure.
But I can see a scenario where one might say the problem is cured, just like compliance with Chapter 76828 pre-suit notice is, quote, cured once you do it. But the suit, if not dismissed, is abated at the time, at that time, so that it can be cured. But my comment was, and I did this without the benefit of this argument, is even though no dismissal, in other words, not dismissing the North Carolina case because of not getting the vote, it calls into doubt which action was first filed under equitable principles.
Your Honor.
So that was just a thought I had. I'm not saying I'm ruling that way. I just want to toss it out for comments.
You couldn't be more on point, Your Honor. And what the case law calls that is an intervening right. So
Well, I didn't know that when I wrote it, but
well, I'm going to give you a Florida. They said there was no Florida law on this. There is.
yeah.
There is. So I will give you that in a moment. But here's the two questions, Your Honor. It's very important, the words of the governing document, the contract. It says the initiation of litigation. Filing an amended complaint is not the initiation of litigation. And Your Honor, I'm going to take you one better. That when the decision is to initiate a lawsuit of one of your own, it really requires a notice and a hearing and a vote.
And a vote.
So when you bring them in after you've already committed the Ultra-Virus Act, and you tell them, we're just going to amend this a little, we're going to tweak it a little, you okay with that?
So,
Sure. So, but I'm differing with you on that.
okay, did the affidavit admit or state, not admit's not the right word, did the affidavit state that the purpose of the meeting was to authorize an amendment or to retroactively cure without admitting there was a problem, but retroactively curing the initial failure to get the vote?
Both affidavits, and they're inconsistent in this regard, and they pointed it out to the Ryan affidavit, page 10 and paragraph 10 and 11, and the Hostetter affidavit, paragraph 5, said the vote was to approve the filing of the amended complaint. And if that's not a verbatim quote, there's not one word, there's not more than one word that's off.
Yeah, I'm reading
That's what the
Hostetter.
vote was.
He said directors in attendance unanimously approved the filing of the amended complaint. And the other one was Dr. Ryan, Mr.
Dr.
Ryan.
Paragraphs 10 and 11.
I've got Mr. Ryan here. Presided over a meeting to approve the filing of the amended complaint.
That is not the initiation of an action against a member. It's to tweak something that's already been started. And the reason,
Well,
Your Honor,
certainly it authorized from that point forward that amended complaint, doesn't it?
if you're going to interpret the contract according to its term, the vote had to be, we want to approve the initiation of an action against our own member. That's what we're asking you to vote on. To get a principal's authorization for ratification, you have to tell them what you want them to authorize.
Well, I think ratification and agreeing to file an amended complaint could be two different things.
Agreed. Agreed.
And I haven't completely wrapped my head around it because I want to hear what the other side has to say on that point too.
The judge is agreeing with
But
the lawyer here.
I see what you're saying.
There's no ratification of the
And
initiation of the
Again, it
lawsuit
seems to me
on December 21st. No
that the
ratification
Siegel
of it.
case, I think it's the Siegel case, that's the 91 Florida Supreme Court. The Siegel case and the other cases I've read from around the country and North Carolina, and a couple in Florida. There's not a lot of these cases in Florida that I found, at least. Has a pretty broad take on what other circumstances are, but they are fact-driven. And I think that's why the Supreme Court can't say it's this, 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 and this, because it depends on what the facts are before I think an appellate court is going to say that's sufficient.
Again, I can tell you one thing that's for certain. There was never a case in which the second court, sovereign immunity was at stake, and they stood down on comedy grounds. They haven't cited a case like that, and I welcome them to spend the weekend looking for it. But it's not out there. No court stands down to watch the members of its state get taken for $700 million in somebody else's court.
So you, I think, contend, and I want to try to set your position up so, as I understand it, so defense can respond to it. You say there are several distinct areas, and your memo probably can state it better than me, several distinct areas of unique state of Florida interest. Taking a property which is property owned by a Florida entity, the university.
Welcome, ultra vires,
Termination of
to the
sovereignty
PATC
issues,
community.
if there are any. 2, 3, interpretation of the public records laws and maybe public meetings laws. And that's all I can think of off the top of my head now. Are there more that you think are key?
Yes, there are more. And the fact of the matter is, the Florida State University Board of Trustees never ratified and approved the grant of rights, which is that one paragraph 127 I'm giving you. And I'll add one to that, Judge. The commissioner of the ACC flew down here to Leon County.
Here we go.
I remember, I think I read that. Was it in your amended complaint?
Here we go.
And he came with Dean Jordan.
Woo!
And they were told to their face that this document, this grant of rights document, would not be brought in front of the Florida State University Board of Trustees. That's something they knew in 2013. So that's an additional question.
Is ACC going to argue that FSU ratified it by receiving money after that?
They will, yeah, of course, yes, I wouldn't hazard to guess what they won't argue, but they would certainly argue that, I would expect. But what I would say in response to that is look at paragraphs 5 of their amended complaint. So I will take issue with one word that you use, ratified.
Okay.
Paragraph 5 of their amended complaint. The Board of Trustees ratified and approved FSU's membership in the ACC in 1991, 15 years before the UNAA. Now contrast that with paragraph 67 and paragraphs 100. And why? Because this is what the Florida State Board of Trustees told the commissioner of the ACC in 2013. Florida State's president was authorized to agree to execute the grant of rights on April 19, 2013, on behalf of Florida State. Paragraph 5, they distinguish between the FSU board. Paragraph 67, they're talking about Florida State, and Florida State's the only one that signed that grant of rights. Paragraph 100, Florida State's president was authorized to enter into and accept the amended grant of rights on behalf of Florida State. That language is not an accident. The word you focused on, ratified, appears 1 out of 3 times. And it only happened in 1991. So yes, there is an issue whether as a matter of law the state agency, the state sovereign unit that owns the property that's proposed to be taken ever transferred it or any right to it legally, anywhere, anytime. That's an additional issue. On top of the anticipatory filing, on top of the ultra-virus actions, on top of the waiver of sovereign immunity, beyond all that, this is another one. And Siegel says additional circumstances. Now, we don't think we need to get there because they lost the priority race. Now, how do I know that? They said there was no law on this. But there actually is. I would point Your Honor to, in these cases you do not have in your binder.
Okay.
It's the First Telebank Corp versus First Union Corp case, which is a Florida federal district court. The citation to it is 2007 Westlaw 970-25557. And the pages I would point you to are pages 9 and 10. And I'm going to read you a quote from those pages.
Who's the judge?
I don't know. I can find that out.
Okay.
It's the Middle District of Florida, 2000.
Middle District?
Middle District of Florida.
Okay, that could be any number of judges there.
Quote, and I'm giving them ratification on this, Your Honor, giving it to them, even though I know they didn't ratify it. While ratification of an unauthorized act may relate back to the original act, such ratification will only relate back if the rights of third parties have not been affected in the interim. The right of the third party here whose right was affected was the Florida State Board of Trustees. And because they filed suit before the ratification. And that's exactly what that court says. And that court wasn't just relying on its own law. It was relying on Supreme Court authority, United States Supreme Court.
So let me find out who the first two parties are. FSU is the third party. The Board of Trustees is the third party. ACC is one party. FSU through the president is the second party.
Technically, the way they look at the three parties in these cases is principal, agent, affected party. In this instance, on our facts, the principal is the ACC.
Okay.
The principal is these governance provision. The principal did not authorize this suit. So the principal has a problem. Who authorized it? An agent. Okay? Agent's action was unauthorized. The third party is, did somebody's ox get gored by the relation back of the ratification? The answer is yes, Florida State. Why? This is a security interest that you're perfecting, Judge. You can't say, oh, you know what, my agent forgot to perfect it the right way. I was supposed to have the first lien on this house. Why don't we just ratify it after some other banks come in and bought the mortgage? Not a chance. And this isn't just a Middle District case from Florida, although that's its Florida law controlling. It cites the FEC versus NRA Political Victory Fund case, another case you don't have, 513 U.S. 88, 98 from 1994.
U.S. 88,
98, 1994.
Is that the U.S. Supreme Court?
It is, Your Honor.
Okay.
Quote, the intervening rights of third persons cannot be defeated by ratification. once Florida State perfected its security interest on December 28th, the priority door closed.
December 28th when FSU served.
22nd.
When they finally made themselves available to be served, exactly.
Okay.
I'd like to offer the court a third case. This one is from another Supreme Court from the state of Arizona. It's known as Wagner versus City of Globe. It's 722 Pacific 2nd, 250, and it's at page 255. In that case, the agent of a governmental body fired a police officer. He lacked the authority to do that. The police officer then filed a lawsuit saying his firing was improper and illegal as against the governing document. The municipality then came in and said, let's just ratify this. Why don't we just ratify what that rogue agent did? Just ratify it. Court said no. Third-party policeman filed the suit. You'd be usurping his intervening rights. He wins. Priority. You can't relate back and rob a third party of their rights. Now, the rights we're talking about here, Your Honor, is a doctrine we spent hours talking about. It's just priority. All we're talking about is priority of filing. And the answer is, Florida State perfected its security interest first. And all the affidavits, everything says that. Give them the benefit of the doubt, say that they had a full ratification. They brought everybody in, say, are you guys all okay suing each other? Are you all okay with me just firing a lawful lawsuit against you? Without a hearing, without notice, based on my opinion? You okay with that? That's what they did. Let's see those minutes.
So if FSU is still a member of the conference, where does FSU fit in the meeting?
That's, Your Honor, if we ever got to it, I was going to go through the multiple breaches of contract.
Oh, okay. Well,
but no, I won't do that now.
Let's don't jump into that.
What I won't do now is, according to the Constitution, we are still a member. According to the Constitution, we're entitled to notice of all the meetings. According to the Constitution, we're to be invited to them. But they don't want to talk about the Constitution because we're not being included. Do you know when they decided to sue Clemson? They didn't tell us.
When they decided to sue?
Clemson, right.
Oh, Clemson. Oh,
Clemson.
I don't know.
We didn't get invited. Now,
wow.
I would like to read you, bear your patience. They're treating us as if we've withdrawn.
And they haven't. Florida State has
but the
not
problem
withdrawn.
is,
you say you haven't withdrawn.
We have not withdrawn, Your Honor.
At some point, I want you to respond to their argument that deprives you of standing to seek the DEC action.
Okay, well, first off, Your Honor, our claims involve restraint of trade.
Mm-hmm.
That doesn't have anything to do with it. They involve breaches of contract, breaches of fiduciary duty, being excluded from the CFP. Those are all concrete events. They've all happened in the past, and they're all causes of action under the contract.
Would have helped, though, if you addressed that in part of your memo. I couldn't find, maybe it's there, I just couldn't find it.
Yeah, we did.
I missed
There's
it.
a section talking about the breach of contract claims. We go through our memo and we get to breach of contract and we identify.
That's where you discuss it.
We identify the meeting approving the vote. That's a violation of 1.6.4.2. We identify the improper failure to get approval to amend the media rights agreement by Jim Phillips without a vote. That's a violation of, I think, 1.5.1.2. These are all contractual violations, and we pinpoint where in the contract they were violated.
Mm-hmm.
So those are concrete claims, and the reason we're bringing them is under Florida law, when you have a material violation of the contract, the other party is relieved of all their obligation, including the ones that are in here about withdrawal.
Okay, let's finish this argument, because I know ACC's lawyers want answers as soon as you're finished. I know we took up a lot of time this morning, so I'm not going to cut you short on it.
Oh, you don't want to say that, Judge.
Oh, okay.
So you probably do want to cut him short.
Sorry.
I'm kidding. I'm kidding. So the problem we have is in part what they've spent a lot of time talking about, the ruling of the Mecklenburg Business Court, and it is an honorable court, but it said in paragraph 4 that it would not make findings of fact. Yet it spent 12 pages reaching a finding of fact that the ACC's evidence of ratification is unrebutted, dispositive, and uncontroverted evidence, pages 44 through 50. It did admit that this action of ratification in paragraph 51 occurred 3 weeks too late, which means under all the cases I cited, you can't undermine Florida State's priority. For a known waiver, the principal has to be told of all the material facts, and you know this, knowingly waive it. You can't just say, here's an amended complaint. Now again, going back to the Ryan affidavit, and it's a subtle point, Your Honor, the Ryan affidavit says, I didn't think I needed any vote to initiate the claim. So on January 12th, when he presides over that meeting, he's not looking to ratify that decision. He's just getting approval to go forward. So I would add the restatement second agency of section 90 comment A. Again, you can't use ratification to cut off the rights of an intervening party. You can't go back and change it. With regard to the additional factors and circumstances, we've been over those. I think you've covered them. This is a taking. Now, with regard to the sovereign immunity, they're relying on this act. This is literally a published decision that says because you knew of this act when you joined in 1991, you waived sovereign immunity. State of Florida waived sovereign immunity for $750 million. It would have helped if the statute existed in 91 or perhaps 2001, but its first effective date was January 1st, 2007. Now, that's just the beginning. Several times, the opinion announces as a finding of fact that the FSU board is a member of the ACC.
The university's the member, not the board?
The Florida State FSU board is a member. Okay. And I can assure you their football team isn't nearly as good as Florida State's football team. Florida State board is not a member. That's the sovereign entity. They're not a member of the ACC.
Who's the member?
Florida State University.
Okay.
So Florida State University is the member, not the Florida State University Board of Trustees, the one with the duty to have the meetings and to do everything in the open and to have votes.
But the board is what authorizes the university to take an act?
To join this not-for-profit, unincorporated association. They're the ones that said, go join the club. Go join it. You must have, the Supreme Court has been saying it, you must have an express, explicit waiver of sovereign immunity. And the only waiver of sovereign immunity in Florida, which is interpreted by the federal courts sitting in Florida, they say Florida hasn't even waived sovereign immunity for them. But North Carolina is saying it's waived it for us. And that's the Maynard case, Your Honor. Now, they want to say this is all about the 11th Amendment, but if we've learned anything in the last 4 years, the only thing that regulates the whole country is the Constitution and the federal government. And if you allow states to start enacting statutes and then interpreting them in their own courts about waivers of sovereign immunity, you imagine what's going to happen with New York and Texas and California and Florida? What's the end of it? Now, they also said that the Florida State Board, they say the Florida State Board is the only named defendant in North Carolina. And they're saying it came to meetings in North Carolina. It did not. It's saying it involved in the management of the ACC. It did not. It didn't register to do business. It didn't open an office. It didn't do anything there. It wasn't even there. And it waived its sovereign immunity. That's how scary it is. So when you have a situation in which one state's trying to waive another's sovereign immunity, comedy goes way out the window. Because this is Florida's money. This is Florida State's team. This is Florida State's media rights. And it's for the next 12 years. I have a lot of things on statement of claim, venue, personal jurisdiction, but
Well,
I should stop there.
Let's get the stay issue resolved first. Mr. Lawson, I'll hear from you, and then maybe we can take like a 10-minute break.
It just the last point would be
okay.
The last point would be that they just want to keep our media rights away from us and hold them hostage so that we have to pay them to get them back. They can't use them. ESPN isn't going to pay for them. The only value to them is that Florida is deprived of them. That has a monetary value.
All right.
But when you hold somebody hostage and ask for money, that's not an election of remedies.
All right, Mr. Lawson, if anyone, I asked the court reporter if she needed a break. She said she was good for a while. So if you want to conclude your argument, then we'll take a short break.
What we're going to do, Your Honor, I'm going to very briefly just touch on the principal priority on Florida law and then all the specifics regarding the issues that are, I would suggest, under Florida principle of priority law, the exclusive jurisdiction of the North Carolina court at this point.
Mm-hmm.
Cooney is going to address. And that really is the point. Florida principle priority law does not adopt Article 9 of the Uniform Commercial Code and security interests. The only analogous case regarding amendments says that the date of amendments and what happens after doesn't matter. The question of whether the North Carolina court properly exercised its jurisdiction is a question for the North Carolina court. And you've heard it was argued and it was decided against FSU. And then the specifics of those arguments, I'm going to turn it over to Mr. Cooney, but under the priority principle, the law is clear that those are matters, those are questions or issues arising from the case that are within the exclusive jurisdiction of the North Carolina.
All right. Thank you, Mr. Lawson.
Your Honor, I'm going to be brief and try to be to the point because I don't want to try the court's patience.
Oh, you're not. I think your arguments have been very good. So,
well, I appreciate that. So let me kind of take the daisy chain the way Mr. Rush laid it out. So he posits this world where Florida State leaves the ACC. The ACC keeps the media rights, and then there's a broadcast of Florida State's game for which they're paid no money by ESPN. The problem is ESPN doesn't have the right to broadcast anything. Once Florida State leaves the conference holds those rights.
So the conference could broadcast it?
Conference could broadcast it. Conference could go with Florida State. They could hire somebody to broadcast it.
Right.
They could sell those rights. They could sell them game by game. They could sell them back to Florida State. But ESPN's got no right whatsoever to broadcast that game once Florida State leaves. The conference still holds the rights. And if ESPN does broadcast that game, by God, they're going to pay for it. And then the money will be shared as it's always been shared.
Wait. The
If
money ain't
FSU's
going to
out
Florida
for the
State, though.
conference, ACC continues to hold the rights until
Nah.
2036 or
Florida
so.
State won't get the money based on the
When a
withdrawal
game's
part of
broadcast,
the
is there
ACC
revenue sharing
bylaws.
between
That's incorrect.
ACC and the other members, or just ACC and FSU?
Well,
Or
I think,
is there any revenue sharing?
well, the contracts are silent on that, but there has to be revenue sharing because there's not a forfeiture. I mean, the grant of rights doesn't say anything about a forfeiture.
No.
And the law is not going to imply a forfeiture. So
Another portion of the contract you did not draft.
that's correct, Your Honor.
Okay.
That's incorrect. The
but
ACC
there has been a
bylaws-
course of conduct between the parties on,
All right, so we know how that's been handled in the past?
that's correct, Your Honor. So, you know, the ACC gets paid X amount. They roughly 2 to 3% goes to the ACC budget, referees, that kind of thing. Everything else gets distributed to the members. And, you know, that world does change simply because the rights have reverted from ESPN to the ACC because Florida State has left. Unless ESPN wants to continue to pay for the rights, then the world doesn't change there either.
I keep hearing about Maryland, and I'm not sure I even was aware that that went on when it was going on at the time. Does Maryland still, did it get its game right?
The withdrawing member.
Yes.
ACC still.
I'm sorry.
No, there was a
This
resolution.
is incorrect. This is incorrect. This is incorrect. This is the ACC bylaws. The withdrawing member shall have no claim on the assets, accounts, or income of the conference. It's in the ACC bylaws. So Florida State leaves the conference. This lawyer, this ACC lawyer is claiming, revenue share will be shared among evenly, even to Florida State. That is not true. That is not true. The lawyer is mistaken. They're not looking at their own ACC constitution. This lawyer is incorrect. And I got a feeling that the Florida State lawyer is going to point it out by holding up that ACC bylaw book once again. We'll get back to what we're watching here. I just wanted to point that out.
I think the response would be if we say either you pay us triple or your home games will never be showed again.
Mm-hmm.
They would have a very persuasive argument that might very well qualify as a taking. But we're now really into the hypothetical world because, as he just told you, they hadn't even withdrawn.
Well, he says they're fixing to at some point.
Well,
That'd be my guess.
But when you read the complaint, that's not what they say. What they say is, if you'll give them an opinion, at some point in the future, they might have a meeting. That board, whenever they have the meeting, might vote to withdraw.
So if FSU withdraws, they pay whatever they pay, but they can't pay, they don't have, whatever you seek to charge, they don't pay or they can't.
They don't want to pay.
They don't want to pay. And let's say someone says these are worth $1 million and you say you have to pay $20 million to get them. Is that a taking or not?
No, I don't believe that's taken because the way it's going to work, this is intellectual property. Conferences, they'll say 20 million, Florida State say no, they're not worth 20 million. Then the conference would go out and they'd market those rights. Who wants to pay? Because the rights are worth nothing unless somebody pays for them.
Right.
It's either going to be Florida State or it's going to be a broadcaster someplace.
Mm-hmm.
I imagine, there are plenty of broadcasters in Florida who would love to have the exclusive rights to broadcast Florida State's home games. And they would pay for that. And then that would be split in the way the course of conduct has always been. So there's no world where you either pay what we demand or nobody ever sees your game again, because that brings no value to the ACC.
Okay.
All right.
All right, thanks.
So, so when The second point he made is, well, this was never properly ratified by the Florida State Board. And other than them saying it, we've not seen an affidavit or a declaration or anything else. There's only one legal entity. Florida State University is not a legal entity under Florida law. The legal entity is the Board of Trustees of Florida State University. That's the entity that holds the property, that does all these things. Now, Florida State University is a member of the conference through the Board of Trustees. And so when we go back to the grant of rights, this is in paragraph 6. There was a representation made in subsection B.
Right here.
Yes, sir.
That execution, delivery, and performance of this agreement and the discharge of all duties contemplated hereby have been duly and validly authorized by all necessary action on the part of such member institution. I got to be honest with you, I'm not sure what that means.
But what that means is it was a promise by the president of Florida State University, who was also an officer of the Board of Trustees.
Okay, this is a document signed by Florida State's president at some point?
Yes, president.
And is he saying there that he's done everything he needs to do to get authority?
Yes, and to authorize and ratify, he's making a warranty for that.
Now you,
on behalf of Florida State University.
Now you're going to stretch me on corporate law because these are some corporate law issues. Let's say he's not telling the truth.
Yep.
Or, more likely, he just didn't read it. And he signed it, but it wasn't true.
Well, he's represented by good lawyers, so I know his lawyers read it. But
well, okay.
But I'll take that and run with it. And if
so, what's the legal effect if it in fact wasn't true?
Well, Your Honor already identified it.
Ultra vires?
Waiver and estoppel, because for 13 years they've accepted payments under this contract.
Right. Okay.
And so they can't now, 13 years later, say, just kidding. We really didn't sign that. You've just been giving us money for 13 years. We have no idea why, but we're happy to take it. That's effectively what he's arguing.
Which would be a good argument if you were trying to get the money back. I don't know. I'm not sure what I was about to say makes much sense, so I'll just not say it. So go ahead.
No, I think, because when I read that argument, I said, well, should we sue them for the
money back?
Yeah, for the money back. And of course not.
I think, I don't know how that would work out.
But they are. And again, Judge Bledsoe addresses this in his opinion. He talks about estoppel and waiver. Mm-hmm. And that this is classic estoppel and waiver. You can't send somebody out to sign a contract and pretend it's not your contract while you accept the benefits under it until you decide you don't want to accept those benefits anymore. And it's to get into corporate law. That's where we would go in corporate law.
There is a concept of waiver. For example, if you have a contract that says this contract can only be modified by a written agreement, there's a case, I know because I handled it as a lawyer, that says you can orally waive that requirement of written waiver. That was 40 some odd years ago. I don't think it's been changed.
I don't believe that law has changed either. It sounds like what I learned in contract class.
I think that's general contract law. Now, whether that helps or hurts anyone here, I don't know. But I know that case exists in Florida. It's actually a Fifth Circuit case, but it's interpreting Florida law.
So while Mr. Rush can very dramatically talk about taking, there is no taking. I mean, there is a contractual arrangement where Florida State for 11 years has known its intellectual property resides here, and they'll get it back at the end of the term. And they're being paid monies. They want more monies than they're being paid for it. And they've made claims for breach of contract on it, and I get that. But there's no taking because the documents don't provide for that.
Well, what about this argument? Florida State is a state of Florida entity. And at issue is rights which it contends have a value, I'm assuming less than what ACC contends the value is worth. And to charge FSU more than their value would be in the nature, they're asserting that is a form of taking. I wanted to say regulatory taking, but I don't think that really is the apt comparison.
No, this is really an example of, let's say, Florida State University owns a piece of property. And they lease it for 20 years to an entity. And halfway through, they say, you know, we made a bad deal. We need more money. And the entity says, I've got a lease. You don't get it back for 10 more years. They can't say, well, it's worth 10 times more than you're paying right now, so that's a taking. It's the same thing.
Okay, if that property is in the state of Florida, do you go to Tennessee to decide whether or not that lease is going to be broken?
You might if it's a Tennessee entity and a Tennessee contract.
I don't think so.
Well, but when we're talking about intellectual property, obviously it's not situated in a place because it's a little more ephemeral.
But aren't we talking about home games? Isn't that the essence of the quote property?
Yeah, games in which they're designated as the home team. Your Honor got that exactly right. So they could be playing, well, for example, they could do the kickoff in Atlanta and be designated as the home team. And that would be
well, let's exclude those.
Yeah, but most of them are in Florida.
Yeah.
Your Honor,
assuming they're in Florida, and I mean, it could theoretically be in Orlando, and they could not be designated the home team. But assume they're, let's say they're in Florida, they're at the university facilities, which there would be no doubt they'd be a home game. Isn't that the essence? We're not talking about a game in Atlanta when they're not designated, or Orlando, or in Ireland. I don't know who's designated the home
somebody's
team
a home team
there, or whatever.
Yeah, and if Your Honor's point isn't Florida an appropriate place? Sure it is. And nobody's arguing Florida's not an appropriate place. But that doesn't mean North Carolina is not an appropriate place, in which case you then apply the priority principle.
Well, does that get to the cases I cited to say that, hold on, it'll come through me, that anticipatory suits in forum shopping are so strongly disfavored that one should not get the benefit of doing that?
Right, but what we discussed this morning is the fact there's nothing wrong with an anticipatory suit unless it's brought for the purpose of avoiding law or avoiding something. Our courts are very clear on that. What they call anticipatory suit, I call forum selection. In the same way they got to select Florida or wanted to select Florida before the ACC could file an action, the ACC had a right to.
I think what's different there is by statute and rule of procedure, plaintiffs in Florida are given the right to select a forum so long as it meets the requirements of the statute or the rule of procedure. And that, as a matter of, I want to say law, is not deemed to be forum shopping. So if I were...
Carolina is given that same right too.
Well, that's what we'll have to work through. If I were a plaintiff's lawyer and I had an automobile accident with serious damages, and it occurred in a rural county, which was known to be conservative on judgments, I don't think it gives me the right to take it down to Dade County and file it down there. That's forum shopping.
if the injured person was from Dade County initially.
Let's assume we don't have these other functions. We're not selecting based upon Florida law and Florida procedure. If I just file it in Dade County, that's forum selection. I think most of the Florida cases that refer to we don't like forum selection are dealing with that sort of scenario. It doesn't mean forum selection in other forum is okay, but I think they're dealing about, oh, well, we want to go to Dade County or Broward County or some other more urbanized county where the verdicts are supposed to be higher. Because that is forum selection. And just like I guess it's forum selection where you try to manipulate the system whereby you can pick a certain judge. And I can't tell you that I know how to do that, but that's looked on with disfavor too, because it's a form, I think, of forum.
That's forum shopping.
Forum shopping.
Yeah.
It's not selection, it's forum shopping.
Precisely, Your Honor.
So, and these rules have been decided, and I have to tell you, the cases I've read some of them seem to come pretty close factually to this case. That's what I've been struggling with all day.
And I appreciate that, and I appreciate the searching questions you've been asking based on that. But when you get down to it, the issue, and this goes to one of the sovereign immunity points. So they kind of folded sovereign immunity, two different concepts into the same thing. There's the sovereign immunity on whether or not you can sue the state of Florida or one of its agencies on a contract.
Right.
I'll call that substantive sovereign immunity.
Okay.
That's not the issue here. We've got a contract. We can be sued here, it can be sued in North Carolina. The second issue, the Hyatt issue he talked about, is whether you can sue, even if the sovereign has waived its immunity, can you sue the sovereign in another state? That I call that sovereign jurisdiction. And that's been decided by the North Carolina Business Court, can be appealed to our North Carolina Supreme Court. They'll go ahead and decide it up there. The case that he relied on, the United States Supreme Court denied certiorari. Similar set of facts involving the state of Alabama, that North Carolina said we've imposed express consent by statute. The U.S. Supreme Court denied cert on that. But they'll have a chance to do it. But what you do here on the priority principle, and the point Mr. Lawson was making, is that's not going to change that decision in North Carolina. They're still being sued in North Carolina. That litigation is going forward. So whether you stay this or not, that's got no impact whatsoever on what North Carolina eventually decides to do on appeal, say, with whether or not Florida.
I think I agree with you on that.
Yeah. Well, then my day has not been wasted.
No, you all have done a very good job on what I think are some issues that aren't as simple as they might appear on the surface.
And then on the ratification point, I did want to point out that in both Mr. Hostetter's declaration and President Ryan's declaration, they said we're approving the filing the amended complaint inclusive of the original claims. Now the board was meeting to approve this the filing of an amended complaint. You know, it was in all the papers. Everybody knew Florida State had sued the ACC and the ACC had sued us, and the board got together and said and looked at this amended complaint, which everybody agreed was material because now you're making affirmative claims and changing the status quo, and said we approve that, and we're also approving the claims that were filed initially. And it says inclusive of that. And that's what Judge Bledsoe said, because they had an opportunity before Judge Bledsoe to present any evidence they wanted that somehow was not an effective ratification. And he found that evidence of ratification under North Carolina law, which governs this unincorporated association, to be unrebutted. And respectfully, we talked earlier, Judge Bledsoe cannot bind this court on your priority decision. That is your decision under Florida law. But I respectfully submit when he makes a decision that has been fully briefed and argued on a point in North Carolina law, that Your Honor should, I think, and Your Honor probably will hesitate to wade into that and come to a different conclusion, because then we do have chaos, because now we have Florida courts deciding differently from North Carolina courts about what North Carolina law means, and North Carolina courts potentially deciding differently from Florida courts about what Florida law means. I think when we talk about deference, I think that's where the deference comes in, Your Honor. And that is my suggestion to the court. No one doubts that the priority stay is a matter of Florida law, but some of these issues that they fully briefed and argued before Judge Bledsoe and lost as a matter of North Carolina law, I respectfully suggest that the Florida courts would defer to that judgment. And that may or may not dictate the priority principle, but the priority principle is plainly a matter of Florida law. I'd be happy to answer any other questions.
All right. Thank you very much.
Thank you for your patience.
Everybody's done a good job. Let's take a break until 10 after 3. I'm going to come back and rule on the priority issue. So let me suggest y'all think about this. No, I'm not going to suggest you think about anything until I rule on the priority issue. But hold on a minute. I'm going to say to the court reporter, we're not going to start without you. So if you need longer, you take longer, okay? All right.
Wow. Holy smokes. Holy smokes. Breaking news, breaking news. When the judge gets back, I don't know, 10, 15 minutes, he's going to rule. He's going to rule on priority, the venue. Holy smokes. Let's get to the super chats. I want to thank everybody for joining us. Bill G, thank you so much for the 5 gifted membership you've given the PATC community. Thank you so very much. Once again, you are hereby Cloak and Dagger knighted, and the people who received your gift memberships. Thank you, Bill G. Thank you for your incredible generosity. Jimmy, thank you again for your generosity. Gifted a membership to somebody in the chat room, one of the people in our community. Thank you, Jimmy, for your generosity. When you become a member, when you become a member, you can watch Cloak and Dagger YouTube membership only episodes. We're dropping one tomorrow morning. I think it's going to be quite interesting on the UNC Board of Governors, and a little bit of information, maybe important information on Conference USA. And Expedition Greg, thank you for your gifted membership to the community. Thank you for your continued generosity to the channel. Big Dog Daddy, holy smokes. Once again, thank you for your generosity. Super chat. This is for the Dog and Pony show that I am watching. Man, holy moly. Well, we're going to get a ruling. We're going to get a ruling when the judge comes back. We're going to open up the phone lines here. We're going to open up the phone lines. What do you think's going to happen? 763-260-1333. 763-260-1333. The judge is going to make a ruling on priority. And then I don't know what's going to happen after that. Is this going to be the end for today? I have no idea. The phone lines are open. They're not going to be open for very long because Judge Cooper is coming back. Patrick says stay denied. Call-in number should be working. There we go.
Call from
Russ Buchanan.
Russell Buchanan, thanks for calling, sir. Let me know what you're thinking here.
Sure. How are you doing?
Good,
Very interesting hearing. Surprised so many people are excited about form shopping. But anyway, basically, I can't see Judge Cooper agreeing to stay this. He's going to deny the stay.
Yeah.
He'll probably tell the parties, he almost did right before the break, that they should think about getting together and resolving it themselves rather than having
Do you think
multiple
that's
courts.
what he was about to say?
I'd be pretty confident that that's what he wanted to say.
Do you think he'll come back and say that after the break here?
He may. I think he was just being a little bit cautious, knowing everybody's watching or listening to what he's saying. But I thought the biggest bombshell to get away from the procedural jockeying was that the ACC lawyer essentially appeared to concede that ESPN does not have any rights to any future games once FSU leaves the conference, which, and I am not the ultimate expert on the grant of rights and everything, but my understanding of it was essentially that FSU and the other member schools gave whatever rights were necessary to effectuate the ESPN agreements. They did not agree, technically speaking, at least in my read of it, to give away all of their media rights to the ACC, regardless of whether they were necessary. Now, necessary is sometimes a legal term, which means something other than necessary. But essentially, the point of that document was to say, we'll let you shop our rights and pledge them whatever you need to do in order to effectuate the ESPN contract. If those rights, and now the FSU lawyer did say, which I thought was interesting as well, that in the ESPN document, it basically says once the school leaves, ESPN does not have future rights. So they seem to be in agreement on that point, which, if that's the case, that to me changes the target number from this $700 million number to simply we're fighting about whether or not the buyout is a penalty, whether it's enforceable, and what that number is between 0 and 130 million.
You know, very interesting, because I took that as the lawyer being wrong. I thought maybe the lawyer, when he said that ESPN doesn't have, they wouldn't necessarily be showing Florida State's home games, I'm sitting here going, yeah, they would still have distribution rights. They would still have distribution rights to Florida State home games. The money would get paid to the ACC. None of that money would transfer and go to the Florida State based upon the ACC bylaws. But the lawyer did say that a couple times. He said, no, it might not be ESPN. It might be somebody else. I don't know if he's mistaken, or I don't know if he told the truth. And if he did tell the truth, if he is accurate, like what you point out, then that kind of shifts the situation, doesn't it?
It does, and this goes back to the whole problem with this from the way it was constructed, which is to say that no one can see this agreement. I think going back however many years when this first started to percolate, as a lawyer, it's very difficult to try to understand what the contractual rights and remedies of the parties are if you don't have access to the actual document. So this idea that this document will be kept secret forever seems to be fading pretty quickly, particularly when both parties now have basically discussed what really is apparently in a 160-page document, according to the FSU lawyer. There's a couple of sentences in there that, in my mind, might be dispositive of whether or not, the hypothetical high end of the exit fee is $700 million, or whether it's simply whatever appropriate liquidated damages or would be for leaving the conference.
Now, Mr.
So that to me is the takeaway of this whole hearing.
Yep.
I don't, from a procedural perspective, there's too much going on with sovereign immunity in particular, and also the circumstances of, hey, we filed a day early because we took advantage of the public records notification we got because FSU followed state law and followed their own bylaws, whereas we didn't. We circumvented that in order to try to shop our form. So there's more than enough in the case law that Judge Cooper has come back to repeatedly, the Siegel case and others, for him to say, I know what the rule says. I know it's supposed to be an exception that I don't defer in this case, but there's exceptional circumstances, so I'm not going to stay this case.
Yeah.
And frankly, it comports with everything that I've seen from Judge Cooper, which would be he thinks that the parties should always get together on a commercial case, probably, and if there's room to argue to resolve it. And staying this case and basically allowing this to proceed solely in North Carolina wouldn't work to that end goal. So
yeah.
I think we'll see that in short order. I don't know what else he might rule on or not rule on from the bench, the motion to dismiss or whatever, but regardless, he'll have to write up some sort of opinion because either way, whoever loses will obviously appeal.
Yeah. So, I was going to ask you what is your take on anything else that Judge Cooper may do after he rules, after we come back from break? Could that be it for today then?
Yeah. I don't know that he'll go too much deeper into it. I thought that this hearing was more supposed to be about the motion to dismiss, but then obviously when the North Carolina Business Court issued their ruling, the ACC smartly tried to take the hearing in that direction and make it about, whether or not he should just stay the case, because as probably most people listening understand, winning a motion to dismiss is incredibly difficult to do.
Yep.
Like there basically has to be no universe in which the claims could be true and all that. So it's very unlikely to win on a motion to dismiss. FSU didn't win on its motion to dismiss, obviously, in North Carolina.
Yeah.
And I wouldn't expect them to win on that either. So the stay rightly is probably a bigger issue than the ruling on the motion to dismiss, but he may rule on both from the bench. It's difficult to say.
Got it. All right. I do appreciate your call. Please call again if something shocking happens here. I don't think, well, we'll see what happens.
I will say this. I've been wrong plenty of times about what I think Judge Cooper and other judges might do. So it's not a certainty.
Yeah.
But I'd say it looks good for FSU, at least right now.
Yeah. All right. I appreciate the call, man. I really do. I appreciate your time. Thank you, sir.
Take care.
Yep, you bet. Excellent. Kerry Gold knows, holy smokes, another 5 gifted memberships to the community. Kerry Gold knows, thank you so much for your continued generosity to this channel. You are hereby Cloak and Dagger knighted once again. For all the new people who received a membership, the Architect, Scott Schrader, Dave Miter, Larry M., Josh Peters, other ones, Clemson Cobra, Richard Brookins, Bob's Reality, Soap, Mick Stevens, Mr. Hornfrog, and everybody else that I potentially missed. You all are hereby officially knighted Cloak and Dagger. You can go to our YouTube channel, watch the membership-only episodes. We're going to be dropping a new one tomorrow morning. We dropped episode 31 and 30. Very interesting articles. This...
Call from
BJ.
BJ, the floor is yours. I think you got a couple of minutes because I think the judge is coming back in a couple of minutes. Go ahead, sir. The floor is yours.
It'll be quick. Thank you again for having me on. The overall kind of vibe I got this morning is the ACC needs to get to the negotiating table super quickly. The most important thing is that I think the FSU lawyer used some federal case law as it pertains to this disagreement, which kind of sets the table for if the case proceeds to federal law, the federal judges, there's some guidelines to kind of solve the disagreement. It was a beautiful case of litigation by the FSU lawyer this morning. It was like watching the '93 team.
Yeah. Go ahead.
But yeah, that's it. That's all I had to say. I'm gonna hop back in the comment section and patiently wait for the third session.
Yep, I do appreciate it, sir.
All right.
Thanks for the call. Thank you, BJ. BJ, another person who thinks Florida State lawyers did a very good job. I think they're gonna get. I think they're gonna get the ruling. Don't think it's gonna get stayed. Definitely not dismissed. And it sounds like the judge may come back and give everybody a little bit of a suggestion that maybe, just maybe, that you should start some mediation. Yeah, the judge is gonna come back and rule on the priority issue. I believe he's coming back any minute now. It was only supposed to be a 15-minute break. So we're going to take off the phone line here. Keep your head on a swivel. Let me know if you see a stream coming up live. I've got both streams up. Okay. Nothing yet. We're waiting for the judge to get back. He's going to make a ruling, ladies and gentlemen. He's going to make a ruling on priority. We're waiting for Judge Cooper. Waiting on Judge Cooper. Yeah, please smash that like button. Thank you for the reminder, Dad Mac. Please, if you're new to the channel, or if you haven't done so, please hit the subscribe button. This is College Football's Peek Around the Corner. We talk everything college football. Everything college football, and we can come on live at any time in the morning, noon, late night. So make sure you have your notifications on. The College Football's Peek Around the Corner. We're covering the Leon County court case here. Florida State versus ACC on the motion to dismiss or stay. The Judge Cooper has a ruling, and I think he may give the parties a suggestion. And some people in the chat thinks it's probably could be about maybe the parties should get together and start talking, negotiations, mediations. It sounds like we don't have the official ruling yet, but it sounds like, much like in Mecklenburg County, this is going to go on in Leon County. This will go on in Leon County. The case will go on. You're going to have discovery. They're going to have case management. And And I don't know what happens then. I don't know if it gets bumped to a federal court. What federal court? Both counties are in separate federal court districts. I don't know. But we're looking for a ruling here soon. Daniel Montcastle says Florida State leads for $72 million. Holy smokes. We are waiting. We are waiting for the judge ruling. Doug Rohan, a friend of the program, says the judge says he will rule on priority issue. Who filed first after we return from the break at 3:10 p.m. But he allows the court reporter to take longer if she needs it. She is in charge of the restart time, light moment that reflects the reality of the power dynamic. The judge is in charge, but he better be nice to the court personnel. He definitely can't start without going back on the record. The judge seemed annoyed. Any idea which way he's leaning? I don't think, this is Rohan, I don't think he was annoyed at all. He was speaking glowingly about the ACC attorneys and the presentation. I think he's absolutely going to side with Florida State and would be shocked if there was a different result. Immaculate, our own PATC Immaculate, said he sounded like he was going to try to push them to work out a settlement too. And Rohan said, I disagree. I think he was about to lay out the roadmap for the afternoon. But things are still a little too sloppy. Once Judge Cooper rules for Florida State, the ACC may request a certificate of immediate review to appeal to the Florida Court of Appeals, which will put the rest of the proceedings potentially on hold for now. We're waiting for the ruling for Judge Cooper and what other information he's going to give to us. The court reporter, it ain't going to start without the court reporter. We're waiting. We are waiting. I've got both live streams in my browser. Whatever pops up first, we're going to go with it. Hopefully they pop up at the same time. Again, I want to thank you all for joining us for PATC breakfast that has gone into PATC lunch that might just go into PATC dinner. We're keeping an eye on everything, ladies and gentlemen. We want to see what the judge says. Everything, who knows? This might close up after he comes back and makes a ruling. Or maybe not. Maybe not. If he makes a ruling here, if we talk about it, and then other things are going on, I think I may have to leave the studio for just a little bit. I'm going to keep everything going and I'll come back. But if it gets, if that's it for today in Leon County, then we'll probably shut the live stream down until, well, maybe later in the day. We'll see what happens here. Let's just hear from Judge Cooper first. But I do appreciate you all coming in. Again, it hasn't started yet. Florida State Knowles 247 is reporting they are in the courthouse. They are reporting that they're still waiting. So this is not a situation in which the live stream is not working. Nothing is happening yet. No ruling. We expect the ruling to happen when Judge Cooper comes back in and we think he's going to rule against stay. This, for all practical purposes, this case is going to continue in Leon County, much like it is in Mecklenburg County. But we don't have the official ruling yet. We are waiting. We are waiting. Any minute. It should be any minute. I don't know what I'm going to do, P-Lit. I do not know what I'm going to do. Keep your head on a swivel. Make sure you subscribe to our channel and have your notifications on. Because when all this is over, I'm going to be on the phone talking to people and gather up some notes. And of course, I'll report it to you all. But we'll see what happens. I can't... right now, I don't know what our schedule is going to be. We've been on since 8:30 this morning. If there is something interesting to talk about, we'll come back on. We will come back on. No question about it. If you're just arriving, it hasn't been a good day for the ACC. And I think Judge Cooper is going to rule in favor of Florida State. No dismissal in Leon County. It's not being stayed in Leon County. But, again, we need to hear it from the judge. Matt Baker, Tampa Bay Times. What happens if Florida State ACC cases keep going forward in North Carolina and Florida? Then we have chaos. And now we have a recess. Judge will make a ruling on priority when we return. That was 27 minutes ago. So, ladies and gentlemen, do not go anywhere. We're going to get a ruling here soon. Still waiting for a ruling. Both live streams are showing nothing. According to people in the courtroom, we are still waiting. We are still waiting. So it's not an issue with the live stream. Not an issue with the live stream. Replica does not expect any ESPN lawyers in Pickens County either. Again, if you haven't done so, please hit the subscribe button, and even more importantly, hit the notification. Get it open, because we can come on live anytime. I usually only can give a little bit of a heads up when we come on live. So you got to have your notifications on. Susan says they're trying to find the bailiff. They're trying to wake him up. He was falling asleep over there. As Judge Cooper said, the court reporter is going to be the one who... She needs the break. She's going to dictate when they all come back. Again, The live streams are showing us nothing. And nothing from people inside the courthouse. We're still waiting. We are still waiting, ladies and gentlemen. We expect a ruling when it comes to priority, the question of priority from Judge Cooper. Matt Baker of the Tampa Bay Times. University North Carolina just responded to my open records request for the minutes of that January 12th special ACC meeting. UNC says it has no existing or responsive university records subject to disclosure under North Carolina Public Records Act. Not the first school to tell me that. Now, according to the lawyer, during this pleadings back and forth here in Leon County, the lawyer of the ACC said there was 12 schools, 12 members of the ACC that voted on the extended complaint against Florida State. 12. No, excuse me. That's wrong. That's wrong. He said there were 12 members who were there to vote on the question on the extended complaint. When the judge asked who were the 12 members that were there, the lawyer did not answer. He said, we can get you that information. And the judge said something that should be in the memo here that I got in front of me. When we also learned that when the ACC decided to file suit against Clemson in Mecklenburg County, they did not tell Florida State. They did not tell Florida State that they were about to do this to Clemson. Even though Florida State is a standing member of the ACC, Florida State is not getting notified, not getting invited to these votes. Okay, we are still waiting. I'll be right back. I'm going to have this up and ready to go if I don't come back in time. Hold on. Okay. When Greg comes back, tell him judge ruled and adjourned for the day. I just had to make arrangements for my wife, so all right, come on now. Come on, court reporter. I know you've been busy. I know you've been working hard. I get it. I understand it. We're waiting for the ruling from Judge Cooper. You know, it's the ACC did not have a vote when it filed this suit against Florida State on December 21st. The ACC did not have a vote. On January 12th, they had a meeting and they did have a vote. But nobody knows. Nobody knows. At least it hasn't been made in public. Not in any of these court filings, not in these affidavits, not in these exhibits, nothing. Nobody knows who exactly was at the meeting, who voted, how they voted. So, December 21st, they did not vote. January 12th, they did vote. 3/4 voted, but we don't know who was there. And there's no minutes to the meeting. There's nothing. Nothing. VC, no one knows specifically. Not even when the judge asked directly. Nope. They said, I can get you that information. We just don't want to talk about it We're
going to go to 5. I'm starting to get doubts we're going to finish by 5. But I just got a message that the week of April 22nd, both jury trials I had set that week have settled. So if we need to, we can set a hearing that week. You all don't have to tell me now, but if we need another hearing, we can do that. I don't usually set hearings during a trial week. However, we're in one of my trial weeks now, so I do make exceptions. And the issues in this case need to be decided as quickly as possible, and my schedule otherwise would be months away, and you don't want to wait for that. So that's what we'll do if we don't finish today. So that would be, I think the 22nd is Monday. So the best days of the 22nd, probably Monday through Thursday. I'll have to check and see. I don't think I have anything else. I'm going to try real hard not to set anything else because I have lots of other things I need to do. But if you want to give me a call tomorrow or something, or we can do a Zoom call, or I can speak to a couple of the lawyers on both sides, and you can check your calendars and let me know. So let's do this. Let me go ahead and decide the issue of staying the trial. I sort of think staying discovery is the same issue, except I have not yet decided anything on the motion to dismiss. So it's possible it might be premature to rule on the motion to stay discovery until I've ruled on the motion to dismiss. So I'll leave that up to y'all, but I think I should rule on the motion to stay. And I want to give you a little bit of information. And I don't really have an outline. I try to make little notes as I'm going, and I try to give it to you as succinctly as I can. But I find that if I make outlines in advance, I don't want to do anything that like holds me down to a certain ruling in advance. And my mediation experience, usually I felt that if you had someone in mediation say they would or wouldn't do something, then it was very hard to get them to do something different because they had said it out loud. And so that's why I don't make a lot of notes. However, I do have some thoughts. So the first thing I want to do is, I don't know that I'm going to read every case to you, but I want to give you citations on these priority cases that I found that are not in the briefings. There might be one or two that found their way into my file that you did cite, but so I'm going to give you the location. I told you a lot of these were patent law cases. So the source of a lot of these cases are in 5 annotated patent digest, section 37.101. It's chapter 37, declaratory judgments, first to file rule, cases on first to file rule. I came across this because I took a case that was cited by someone on one side or the other in the case. I shepherdized it. I like to look at both the cases and the secondary sources, and this popped up as a secondary source, so I'm not as obscure as it sounds. I did get to it from a regular case. So let me give you some case cites. This may be a repeat. I think I gave you Amperex Technology Limited, 2022 Westlaw 135431, Federal Circuit 2022. I'm pretty sure I may have read that one to you this morning. So, without reading that to you again, I will say in that case, and this is at, I think this means page 2 on the way this Westlaw citation works. It's either page 2 or footnote 2. So, in the same case, this source summarized the case. It says, in cases cited by ATL, which is the case I just cited itself, this is a new case, Electric 4 Imaging Inc. versus Coil, 394 Fed 3rd 1341 at 1347 to 48, Fed Circuit 2005. I believe this to be a quote from that case. It says, in cases cited by ATL itself, we have recognized that the first to file rule is not absolute, that a declaratory judgment action in particular may even be dismissed. I'm not contemplating dismissal. May even be dismissed, though filed first, and that a court may consider whether a party intended to preempt another's infringement suit when ruling on the dismissal of a declaratory action. And then there's a citation, EEOC versus University of Pennsylvania. I did cite this case to you. The court there, that's EEOC versus University of Pennsylvania, 850 Fed 2nd 961.
Yeah, I got that too.
The court did not abuse its discretion by declining to dismiss the second filed suit.
He said it real quick.
When the timing of the first suit indicated an attempt to preempt the imminent second suit. Here the district court found that the ATL suit was anticipatory given the sequence of communications, etc. So let me skip over to the next case is Communications Test Design Inc. versus Contech, 952 Fed 3rd, 1356, Fed Circuit 2020. Approved dismissal of the a first filed declaratory action suit in favor of the second filed suit, where the first case was filed as an anticipatory suit, where during negotiations the plaintiff told the other party that they were going to make a counterproposal, but instead filed this suit. I read that to you, so I'll skip past that. Another one, PPS Data versus Diebold, D-I-E-B-O-L-D, 2012, Westlaw 1884655 at *1-*2, Utah 2012, refusing to apply the first to file rule to patentee's infringement action and instead dismissing that action for forum shopping. Next case, National Broom Company versus Brookstone, 2009, Westlaw 2365677, Northern District, California, 2009. An action is anticipatory when the plaintiff files upon receipt of specific concrete indications that a suit by the defendant is imminent. Such anticipatory suits are disfavored because they are examples of forum shopping. Moreover, the declaratory judgment act should not be used to deprive the plaintiff of his traditional choice of forum and timing, provoking a disorderly race to the courthouse. Application of the first to file rule in such situations would thwart settlement negotiations, encouraging intellectual property holders to file suit rather than communicate with an alleged infringer. Then we have EEOC versus University of Pennsylvania. I believe I read that to you and given you the site. So I'll skip to Triangle Conduit. Oh, wait a second. That's the EEOC case. I won't read that to you. I believe I read that portion, but it is. I'll give you a non-Westlaw site, 850 Fed 2nd 969. 1988, Third Circuit. That's a federal case. The Sanchez case, 306 Southern 3rd, 1098, 2020, that we talked about, 3rd District. It's at page 1112. I'm just citing this to you for the statement in Sanchez stating, quote, "We have stated that Florida courts, including this one, regard forum shopping with displeasure." Mission Insurance Company versus Puritan Fashions Corporation, 706 Fed 2nd 599, 5th Circuit, 1983. Anticipatory suits are, let me try to give you a page number. No, that's footnote 3. That's a footnote 3. Anticipatory suits are disfavored because they are an aspect of forum shopping. And then they quote a case reference in the footnote. The wholesome purposes of declaratory acts would be aborted by its use as an instrument of procedural fencing, either to delay or choose a forum. I think I read that to you earlier.
Yes, ESPN lawyers were not present in Leon County courtroom today.
A few more. I think most of these you have already, but let me just make sure that you do. Centennial Life Insurance Company versus Poston. I think most of these are cited, but 88 Fed 3rd, 255, 4th Circuit, 1996. And the point that was interesting to me is on head note 2. Although the federal action was filed first, we declined to place undue significance on the race to the courthouse door, particularly in this instance where Centennial had constructive notice of the Poston's intent to sue. Wachovia Bank versus Harbinger, 2008. This is North Carolina, Mecklenburg County, cited by the plaintiff in their memo. 2008 Westlaw 684926. 2008. Again, a North Carolina case. Plaintiff's choice of forum. I think the plaintiff was the first filed case, is not entitled to substantial weight, and they cite another Coca-Cola case, which I think is also a North Carolina case. In situations in which two suits involving overlapping issues are pending in separate jurisdictions, priority should not necessarily be given to a declaratory suit simply because it was filed earlier. Rather, if the plaintiff in the declaratory suit was on notice at the time of filing that the defendant was planning to file suit, a court should look beyond the filing dates to determine whether the declaratory suit is merely a strategic maneuver to achieve a preferable forum. All right, there may be more. These are just to give you some example of what other jurisdictions, including North Carolina, has held on this issue. This exception to the first file rule or the priority rule is not that uncommon from what I can tell from fairly quick research on my part. I've given you where I found these cases. If you find some that diverge from that or support that,
there's an exception.
These were a quick selection by me, almost at random, to find out what other courts have said. I think the affidavits to the FSU response to the ACC motion to stay discovery, and I think particularly that of George Ryan, I think it was perhaps his second affidavit.
Jim Ryan?
Let's see, I believe. It's his affidavit dated March of 24. I believe that affidavit shows that this filing was, let me find, that the filing in this case in North Carolina was an anticipatory suit in the nature of forum shopping. It is very similar to some of the factual scenarios that are set forth in these other cases, not the least of which one or two of the North Carolina cases. As National and Broom said, anticipatory filing is in effect forum shopping or a form of forum shopping, and many other cases have talked about that. So I find that based upon the information I have in the record, and there's been a lot of information that's not of record, and I'm trying to limit myself to what's actually in the record. So the complaint, the matters that are now judicially noticed, support a finding of forum shopping by ACC in the North Carolina suit. What that means is the presumption of priority or the presumption of jurisdiction or the presumption of a stay is, these are my words, there are probably better words to describe it, are extinguished. we look at other factors in the case, and this is where counsel's argument from FSU this afternoon come into play, as well as the memorandum of law filed by FSU on March 12, 2024, FSU Board's response to ACC's motion to dismiss or stay, and FSU's response to ACC's motion to stay discovery. The motion to stay discovery, which was filed 3/27, I think is a pretty succinct statement of FSU's arguments, perhaps supplemented today by other arguments that give the basic reasons why, even if you look at factors other than the priority rule, that the motion to stay must be denied. The 10 points of the judge in North Carolina, it may be that he cited a case to support that, but I studied the 10 points as argued by counsel, and I'm more persuaded by the argument of FSU on that point. There are issues of, I'm going to put in quotes, the taking of the media rights, whether or not it constitutes a taking or not. I would want to look at the order to see how FSU wants to draft it, to see if I agree with it. I tend to agree with FSU's arguments asserted in its memorandum on these points. I think there are issues of sovereign immunity as it relates to whether or not FSU can be sued for breach of contract in another state, and whether the sovereign immunity can be deemed waived under that state's laws. I think there's a significant state interest in those issues for Florida. There's a significant state issue for the interest in Florida of whether or not the subject matter of this case constitutes property and whether it can be taken. And there's a significant interest in the state of Florida on the issue of what documents are public record and what are not. And I still think, looking at what I've read, the arguments are helpful and instructive, but I still think there is an issue, particularly with regard to the ESPN contracts with ACC, as I understand it. The issue is whether or not those are public records under Florida law, not under North Carolina law. There's a notable difference, I believe, between, I've not seen anything argued today or in the memoranda, which was very well done by all parties, including ACC, who did a very good job. I've not seen anything to indicate or point out any public records of sunshine law equivalent in North Carolina to what is available in Florida. I don't think this is I don't agree that the issues in this case are of local concern. I think these issues are of concern clearly in the state of Florida, probably in all the other states where ACC has member institutions. I don't think it would be limited to Florida or North Carolina. There are other states let's see, Louisville, trying to think, Buffalo, Boston College. I'm going to be embarrassed if I try to name them all, so I'm going to stop right there. But there are other ACC schools throughout the Northeast. Although there are about 4 members in North Carolina, and that's probably the greatest concentration of members in a state, if you look at other metrics of impact on the conference, based upon the allegations and the plaintiff's amended complaint, you might find that they don't rise to the level of the metrics of impact on the conference as FSU, or certainly FSU and Miami combined, or for that matter, Clemson in its program. So I don't think that factor carries. The fact that I've not heard anybody from the plaintiff side dispute that North Carolina law governs, except as to public records law, public meetings law, sovereign immunity law. I don't think the fact that North Carolina law may apply here is any reason that militates in favor of North Carolina being the venue. There's no reason why, if there's a need for a uniform results, there's 3 states right now. And I don't think it being in North Carolina necessarily means it's going to be a uniform result, whether it's in South Carolina or FSU. And we just don't know what's going to happen in the South Carolina context. I think there are witnesses likely in multiple states. There are in Florida. I'm sure there are in North Carolina. And there are likely witnesses in other states also, where there are ACC schools. I don't think the location of electronic documents or emails in today's technology that's available are a reason for keeping a case in any one particular state, because frankly, as I understand the way servers work, we probably all get our emails from some server in Nebraska or someplace else. The location of the server is almost not relevant because of the lightning speed of electronic communication. We have the fact that Florida State's located here, the disputes between Florida State and ACC. I'm not saying Florida's allegations. I'm not finding that they win. I want to make sure everybody understands this is no indication that I think Florida State's got the better argument on the merits or not. I'm just saying that I think the motion for stay should be denied. I think in light of the fact that the way this suit was filed, that it was classic anticipatory litigation, which reasonably lends itself to a conclusion of forum shopping. There's only one reason one would engage in forum shopping. That's because you think the forum you just shopped is better than the other place. That's why forum shopping is condemned in all these cases I cited to you, including cases from Florida. And I think at least one of those is North Carolina, but I'd have to look and double check. I know there are Florida cases I cited to you. So the fact that there's forum shopping means that the person who shopped that forum thought they had found a better place to try their case, and that's why they filed the way they did. Now, it doesn't mean that everybody involved in the process had that thought. It just means that
Motion
That's what
to
it
stay
was.
has been
I've seen no
denied
other explanation given
by Judge Cooper.
for that, and the
Big victory
affidavit
today for Florida
practically
State
admits
University.
that's what was done. Clearly admits it was anticipatory. And
Case will
I've given you
continue in
cases
Leon
that show
County,
that
just like it will
anticipatory equals
in
forum
Mecklenburg
shopping
County.
in many instances. The issue of the vote of the members. There's no definition of material in the bylaws section I was given to look at. I looked at Westlaw, 4th edition. I'm going to tell you that's around the 70s sometime. No, 1968. But I don't think the term material has changed since 1968. But it's a significant case. It involves significant sums of money as we parse through the issues in this case. And I find, based upon what I have in front of me that's of record, that it was material. We have to be careful that I don't, or we all don't go off and start bringing in a bunch of things that are not of record. Someone from defense, I think, from ACC correctly raised, I think it was ACC, correctly raised that point. Just because we all say it in here doesn't make it of record. So I would admonish plaintiff's counsel, when you're writing an order, be very careful that what you're putting down is facts, or facts that are of record, not some fact that you saw on CNN or something like that. While that might be accurate, it's not a record and it's not been tested. There are enough facts in the complaints, in the motions, in the judicial notice documents to ferret out information. I've not seen a case that says that failing to get the requisite number of consents to file this suit has been labeled by an appellate court an ultra vires act. I believe that is an accurate label for it, because ultra vires means an unauthorized act. I recognize it's usually used in the corporate arena, but if you're required in the corporate world, if you're going to sell or buy something, a corporate asset or purchase an asset, you need.
Oh, no. I think Judge Cooper was just about to explain that
I think it's an apt analogy. I'm not sure that I want to say absolutely under no circumstances that's the correct term for it. So I'm using that as a descriptive term because I've not seen a case that actually used that term for such conduct. Let's put it this way. Whether you call it ultra vires or not, there is some question as to whether the filing of the lawsuit on December 21 was properly authorized under the ACC bylaws. Therefore, I think the better way to state it is, as I indicated before, that brings to mind another circumstance, perhaps on an equitable basis, to not grant the ACC a priority, a first to file priority. That doesn't answer all the other questions, but I'm not ready to go as far as plaintiff's counsel went, and that he's probably a lot smarter than me, but I'm not yet ready to say it in fact is ultra vires, and therefore it's not the first filed. I think it's a factor to consider with other circumstances such as preemptive litigation, forum shopping, etc., to consider, at least on an equitable basis. Or even better than that, it's better considered. As you can tell, I do not have notes, so forgive me if I am not totally articulate. I think it's better conceived as evidence of preemptive litigation and forum shopping than it is any other factor that's been mentioned. So instead of, one might call it ultra vires, it is in the nature of an ultra vires act, but the reality is it's more evidence of an ultra vires, of a premature action, an action that's not yet authorized. It's a rush to the courthouse action. Apparently, if one accepts the affidavit, it was a rush job, because although they were following FSU's action since August, I take from it that they found out about the meeting, and they said, they in essence says, quick, you gotta draft this suit. Because I didn't get the impression the suit had already been drafted from the affidavit. I don't know what discovery may show or not. So I'll leave it that way, counsel, instead of, I'm not as confident to be as precise as you were in your excellent argument on that point. So I'm glad we have a court reporter here who will remember all of this. The issue of whether the grant of rights were ratified by the board and whether they were, and then whether that argument has been waived by the university accepting money. I find that both sides make good arguments on that point. But I find that the scales tip slightly in FSU's favor on that point.
Holy smokes!
Because we're dealing with a state of Florida entity. In Florida, Florida obviously is a sovereign state.
Holy!
And these issues directly affect Florida really more than they do the state of North Carolina, because this is not North Carolina's money that's at issue. This is ACC money that's at issue. Yes, I agree, it does affect North Carolina, other state entities who are members of the ACC, but not as directly as it does FSU, which is a Florida state entity and is directly funded by Florida state. I think I can take judicial notice of the fact that the Florida legislature gives money to state universities in Florida. So I tip that in FSU's favor, not to say that definitely you win that argument or that defense loses that argument, because there's something to be said in defense's waiver argument. I understand your argument. I think the defense's waiver argument is something worth hearing about also. That to me is probably more likely a summary judgment argument than I would consider it a motion to dismiss argument. But we're not there yet. So I do think it's another one of the factors that tips in favor of denying the motion.
I think what Cooper just said is the grant of rights not being signed by the Florida Board of Trustees that has some
the ratification
value to the argument of
by
Florida
FSU's
State. I believe
argument.
that what he indicated there. Let me know in the chat if
gotta
I
be
got
honest
that
with you.
wrong.
For some reason, I'm trouble in putting my signature on that one. So I'm not going to adopt that, counsel. You have made it. And if there is an appellate action, if you want to bring that up as a point of an appeal, certainly you can. But I think the failure to grant a stay is sufficiently based on the function, the statements I've made, and I don't think by adding this ratification argument to it, and you might well be right. I'm just saying that I'm not there yet on the intervening rights of the third person can't be affected by ratification argument. That, Mr. Lawson, that's the ratification part I was referring to. So, but I do in general agree with FSU's written positions, because there are two really. There's a piece of one in the defending the motion to dismiss, in one in more detail, filed 32724, response to ACC's motion to stay discovery. So I would like counsel for plaintiff to draft an order along the terms and the intent of what I've said. I'm going to ask that when you do draft it, to send it to ACC counsel, and their function is to determine, does your order state what I ruled? If they do not agree that it states what I ruled, then I'll give them, Mr. Lawson, usually it's 3 to 5 days, but if you need more because of this, just let me know, and I'll give you more. But what I usually do, if you can't agree within a few days after you've written it, then email it to me, to my judicial assistant, email it to all the defense counsel at the same time. So what I get, they get, and they'll know to start writing if that's what they wish to do. I'll hold it until either I get something for them or they tell me they're not sending me anything. And if you email it to me instead of using the portal, I can better, I'll get it faster because I don't get anything through the portal for some reason. I don't really know why, but I get it email fast. And I can make edits to email, so try not to use the PDF form. I know you can make edits in the PDF form, but I'm not so sure I can make edits in the PDF form. So Word's fine. I know no one uses Word perfect other than me anymore, so you can send it to me in Word and I can edit in Word. So that's where I am on that, unless I've not ruled on something that you want me to address on this point. So either side. I will say this, I want to say to the lawyers that we often overlook. Lawyers are representing clients. You both have done an excellent job, all the lawyers, in representing your client.
Ladies and gentlemen, I'm going to have to take a 3-minute break.
You sending me,
and then when I come back, we're going to take your phone calls.
Time enough for me to read it. I've not heard anybody say anything to each other, which I got a little tinge of in the briefs. We could probably do without what I call the oral argument or the closing argument hyperbole. So please don't put that in the order. I don't want to have anything in an order that I sign where I'm making an argument for somebody or I'm finding something that I don't absolutely have to find. Because I've had to change orders, not from you all, but I've had to change orders before where people would have me find this fact, that fact, that fact, that fact. And I said, all I'm finding was the facts this would be summary judgment, are in dispute. I haven't decided any facts. So remember, it's a court order. It's not an argument. So we'll do that. Now, according to me, it's like 423 or 424. We have other arguments. I kind of think, Mr. Lawson, on the discovery issue, that I should leave that unruled on until the motion to dismiss has been ruled on, because that could, I know the legal issues are the same if not similar, but there could be some difference on discovery depending upon what happens on the motion to dismiss. So we have motion to dismiss, we have the issue on whether there's, would you call it a standing issue, on that they haven't yet removed themselves from the ACC argument, that they intend to remove themselves?
The rightness, yes.
Yeah, the rightness. Okay, the rightness argument and the other issues I don't think will take nearly as long as this one has. I've read everything, so it will take me a lot less time to prepare. I don't have hearings like this unless, I think if you take the time to write it, I should take the time to read it. So I read everything you sent, both sides. And so that's why I know you did a good job. Sometimes I had to read it twice to understand what one side or the other was saying, but I did. So you want to, do you want to continue on? We can till 5, or we can grab our calendars and see what you want to do.
I don't see how we could do anything except get started on our motion to dismiss without leaving any time for any response. And so I think we schedule.
Okay, if you don't mind, I can get my calendar and look to see if there's any days that are absolutely out for me on that week of the 22nd. I'll bring that right.
Okay. All right. Okay. Okay. All right. Time out. Time out. Time out. Time out. Time out. We're not done. We're not done because I need clarification on one big major point, and then we're going to open up the phone lines. Then we're going to open up the phone lines. Rock and Rant, thank you so much for your super chat. Race to judgment scenario about to begin. North Carolina, Florida. Carrie Gold Nose, holy smokes. Thank you for your huge super chat. I do appreciate it. I do appreciate your continued incredible generosity to this channel, keeping the lights on. Thanks for the good work put in today, Greg. I appreciate it. Thank you so much. You're very kind, Carrie Gold Nose. But we're not done. I know everybody wants us to be done, but we cannot be done. I need a 3-minute break, possibly 4. I'm going to come back. But I might have misheard the judge on something. I don't think I did. And if I did mishear the judge, if I did not mishear the judge, and I believe the weakest of the weakest of the weakest Florida State arguments, he's siding with Florida State on this one as well. I'm going to get back to it. No, he's not siding with them. He's leaning in their direction right now. We're going to get back to that. I need a 4-minute break. And then I'm going to say what I got to say. And then we're going to open up the phone lines and hear what you have to say. So please, just a 4-minute break. and we'll get back. It's a major one. I'll be right back, guys. Okay, let's open up the phone lines. Before I do so, I don't know, I might have misheard it, and it seemed like people in the chat heard the same thing I did. But the judge made a little bit of a comment on Florida State in the argument that, he said the grant of rights. He said the term grant of rights. No ruling was made. He said the grant of rights, and he talked about the Florida State just briefly, and I'm paraphrasing, that, they didn't, the Board of Trustees didn't really sign for the grant of rights. And he talked about how it's a public university, and he said he sided with Florida State. Did I mishear? If the judge said that, now he's not making a ruling on it. You're going to have discovery, you're going to have more conversations. If that actually happened, if I heard that right, if I heard that correctly, then if this is the judge that's going to preside over this continued case in Leon County, I don't know. That is really bad news. there's no judgment on the grant of rights. That's not what today was about. But the judge talked about other things, and when he brought that up at the very end, Jay Chauncey says he's persuaded on the point of not granting the motion to stay and hinted at the motion to dismiss. Ultimately, this all likely goes to a jury. Holy smokes. He said he slightly favored the argument. That's how he put it. But not enough to use it as the basis for his order. True. That's going to be a hotly brief point. I won't read too much into it. When is the next hearing? Is it April 22nd? Is it April 22nd? Court resumes April 22nd, 9:30 a.m. And you better believe that PATC will be live April 22nd at 9:30 Eastern. Anyways, we're going to open up to the phone lines. The rest of this show, however long we go, is giving you all the opportunity to speak your mind on what you just saw today in Leon County. I think it was a very good day for Florida State. Let me know if you agree, disagree. The phone lines are now open. 763-260-1333. 763-260-1333. Give us a call. Give us a call. In the meantime, I'll just go through these comments. King Spleen, great. We Florida State fans and citizens keep trying to tell you guys that the Florida State Board of Trustees signature versus the president's signature is a real thing in legal terms here in Florida.
Call from
JD.
JD, Mr. Seminole, the floor is yours. A very good day for Florida State.
Do you think the judge was fair?
Hey, I don't know. Sure. I don't know. Yeah. I thought Bledsoe was fair. Yes, that's my answer.
I thought he was fair, and I just want to make sure I'm not coming off as biased. That conversation that you and I had about a week ago, and we insisted that FSU was a party to the contract. They're not a party to the ESPN contract. So in essence, eventually we're going to find out, and this is my opinion, but there's been people that have been saying this. Eventually we're going to find out that once you leave the conference, you're no longer bound to the grant of rights. It's going to take a judge ruling on that. But how can you be if the grant of rights are the rights granted from a contract? It's just an assignment of rights and it is backed by a media contract or some type of a contract. So anyway, I thought that was the most important thing coming out of this whole hearing, was just an admission that ESPN, that the ACC teams aren't in a contract with ESPN. They admitted it. They're not in a contract with ESPN. They have assigned the ACC their media rights, and in return, they are to receive benefits from the ACC ESPN contract. And the fact that the ACC lawyers admitted that in court, to me, their case is it's dying a slow death. Now, does that mean that they can't drag this out for even a longer term and still collect 100 and something million? I mean, maybe they can. I don't know. You see courts not rule in your favor all the time, but I just don't see it. I just don't see it. And the rumor the other day that was going around that ESPN has already denied or turned down the ACC
to re-up on the contract. I mean, those whispers aren't really whispers anymore. There's more people insinuating that the ACC, when the lawsuit started, asked ESPN just to go ahead and re-up the contract, and ESPN declined. So we'll see. I mean, I've seen that in 3 different places right now. But it just makes sense that would be the case, because, again, like we talked about the other day, why would you leave everybody twisting in the wind like this when you could just re-up the contract? You know, the ACC doesn't have any backing right now. They just don't. But anyway.
Yeah.
That's my little rant there.
Yeah, it's very, 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 very interesting.
But, you know, the judge seemed initially a little disheveled, but not really disheveled. I think the proper characterization is he was prepared, and he had a lot of case law. I mean, he had everything he needed right there.
Yes, he did.
And I thought his arguments were very, I don't know. It just, and I'm being biased here. By all means, I'm being biased. It seemed like the Carolina court to me had to find a way and kind of went a little out of the way to try to bring all the cases in to their court. And I thought the Florida judge, you know, Judge Cooper, was just very matter of fact. It's just, this is what Florida law says. It is what it is. And one of the things that I think the strongest argument that was made, I think it was made by the FSU lawyer, but it was also reiterated by him. Yes, the ACC is located in North Carolina, but the disputed property is in Tallahassee, Florida.
Mm-hmm. Yeah.
The disputed property is FSU home events, football games, basketball games.
Yeah.
Is secondary sports. That's the location of the disputed property. So, to me, that might be the second biggest revelation today, or at least the thing that was brought up in court to help explain how we're at where we are. But anyway, I got more to say. If you're on later on tonight, I might chime in, but I've got to go now. But I just wanted to. I just want to pop in and say hello. I appreciate you covering this all day.
You got it.
And always a great job. Thank you, sir.
Yeah, appreciate it, JD. Thank you.
All right, bye-bye.
Beautiful. Like Russell Buchanan says here, it's important to be precise. Florida State did not assign their media rights to the ACC. They assigned their media rights, according to what Florida State is saying, they assigned their media rights to the ACC necessary for the conference to perform the contractual obligations expressly set forth in the ESPN agreement, which hopefully we'll see all of that agreement in public.
Call from
BJ.
BJ, the floor is yours.
Hey, thanks for having me on again, Greg.
You got it, buddy.
A few things. I think the previous caller was spot on with a lot of things. A couple of things that I think, in hindsight, that just came to mind. It came across to me that the judge thought, the form shopping is just a sign of kind of dishonesty, or it's not a very good method. That I think he described it as displeasurable. But in my eyes, I think that the ACC would have fared better in court if they would have argued on the merit and not on this, first serve stance that they took. Because it was clear to me that the judge was really against the form shopping, but the other aspects of it, he wasn't completely against it. He just leaned towards FSU's kind of argument. Does that make sense?
Yeah.
So that was one, and secondly and lastly, the judge said something to the effect of, this is, even though schools are in North Carolina, every member state, every state that is a part of the ACC, it is a state issue and not just a local issue. And that in itself, in my opinion, opens the ACC up to litigation in 6, 7 different states. Because if it's deemed a state issue, and from a public school standpoint, that'd be hard to overcome from the ACC standpoint.
Yes. Yep.
Did you get the same?
Yep,
how did you read
point.
that?
That's what he said at the very end there. Yep.
But for lack of a better term, it was enjoyable. Thanks for kind of hosting the live party.
You got it.
I greatly appreciate it. I'm curious to see what other folks think. And the last question is, how quickly will the ACC go to the bargaining table?
I think that may be happening pretty soon here. Maybe I'm being gullible, but I'm naive. But I think they better start talking if they haven't already.
I mean, it's quite obvious because Florida State just has to win in one case.
Yeah.
They don't even have to win, be honest with you.
Yeah.
They just have to crack the armor, for lack of a better term.
Yeah.
And if Florida State gets out, there's only about 4 or 5 teams that can afford to leave or have a place to go. So I think, getting to the bargaining table would be shooting for would be my pathway. And I got one more thing to say before I go. Let's say this hypothetical, right? Let's say 4 teams leave the ACC. That's on average $150-200 million, right?
Yeah.
So the ACC has $1 billion. I'm thinking, could they use that $1 billion to then attract Big 12 teams or other Power 4 teams instead of just handpicking G5 teams? Because you have $1 billion to work with, you can buy teams out of their contract for pennies on the dollar.
Boy.
What happens to that? Let's say hypothetically that $1 billion. What happens to it?
Big 12 schools are under a grant of rights, and they're going to have to pay. I don't think that's a possibility, but I could be wrong. I think the schools that are remaining are going to keep that money because they're going to lose media money in the contract. I don't think. Boy, I don't know.
And this is just hypothetical because you're going to have a shit ton of money.
Yeah.
And you're in a position of you have $1 billion. You don't have to just take any team. You can be more strategic and be patient, and maybe wait 2 or 3 years until the Big 12 contract is has 2 or 3 years left on it, and then you can pick up the UCF, you can pick up West Virginia, you can pick up Cincinnati, which is more in your footprint. And I think that'll look long term. It'll be better for your conference than picking up, another Texas team or East Carolina or somebody like that.
Interesting question. I appreciate it.
But let me get out of here.
We got more calls coming in.
Adios.
I appreciate it. Great call. Here we've got Matt Baker. Tallahassee judge is denying ACC's motion to stay Florida State's Leon County suit against the conference. Tallahassee Judge C. Cooper is denying ACC's motion to stay. We also have some breaking news. I'll get to it in a second.
Call from
Tristan Fibes.
Tristan, can you just hold for one moment, please?
Yes.
We do have some breaking news.
Okay.
Pete Thamel, ESPN, the great running back, Damian Martinez, Oregon State, has informed Oregon State's coaches he intends to enter the portal. He was set to make more than $400,000 to play at Oregon State this year. The tough Great running back, Oregon State, Damian Martinez. Holy smokes. He is entering the portal. April 16th, it opens up. It's going to be wild. It's going to be chaotic. Tristan, thank you for your patience. The floor is yours.
Hey, Greg, listen, I just wanted to chime in and mention that if you look at the history of universities exiting when they're under a grant of rights, now, understandably, we're talking about short-term movement, right? Like there was only a year or two left in the contract.
Yep.
People, universities are not cutting checks. Okay. What's happening, and this actually started with the Maryland case, if you remember, it's withheld revenue. Right? So what I think is going to happen here is that the ACC is going to withhold revenue from Florida State, probably. And then that'll become the excuse, I'm thinking, for Florida State to say, we're out of here, you're not getting any more money from us. And they're going to end up leaving for the cost of withheld revenue, 1 year's worth of withheld revenue.
Mm-hmm.
And I'm not a lawyer. I'm not pretending to have any legal expertise. But if you remember to the agreement for Oklahoma and Texas to leave, people were saying, well, it cost them this and it cost them that. No, they had that revenue withheld. Okay?
Mm-hmm.
That's the magic phrase, withheld revenue, right? So if you only give them 1 year's worth of opportunity to withhold the revenue, then that's the amount that you're leaving for.
Mm-hmm.
And I think that, I don't know how this is going to go, and I don't want to pretend like I have any insight because this is a legal matter. But if push comes to shove and they just can't come to an agreement and the ACC says, fine, we're going to withhold your revenue, that's the go signal.
Yeah.
That's all it's going to cost Florida State is 1 year's worth of withheld revenue.
Interesting take.
Yeah, and again, I have to stress, I do not have legal understanding.
Yeah, well, not much of us do, so we're doing the best we can.
Yeah, but I just wanted to remind you and the listeners, it was Maryland. They litigated for a year and a half, couldn't come to an agreement, and ended up being, let's just agree to the withheld revenue.
Yeah, but that was just the exit fee. That was not the grant of rights.
Right, that was not under a grant of rights, correct.
Yeah.
But Oklahoma and Texas were under a grant of rights, and that same template was used for them, 1 year's worth of withheld revenue.
Yeah.
So, I think that might be where we're headed with all this.
Okay.
So I just wanted to throw that out there for everyone.
You got it. I appreciate it.
All right, thanks a lot, Greg.
Sir. Thank you so much.
Bye-bye.
Bye-bye. Great call by Tristan. Okay, so this is what we're going to do. We're going to close it down for now. I got to make some dinner for the little general. Going to make some pork ribs. So I'm starving. I know the little general is starving. The fat guy from Minnesota is going to be cooking and eating. If we need to go on live again later tonight to take more phone calls and to let this marinate, we're going to probably get some reporting from National College Football writers, whatever. What you need to do is you need to subscribe to our channel and have your notifications open because we can come on live at any time. So you need to do that first. Subscribe, get yourself notified, smash the like button if you liked our content today. I want to thank everybody for the incredible generosity you have given me to help us keep the lights on, to help us keep this operation going. The Rebel Outpost College Football YouTube channel, the only college football YouTube channel out there, national college football YouTube channel that would have a watch party, North Carolina State Wolfpack spring football game on Saturday, and then have a court case in Leon County that we're covering. We cover everything, so please, in college football. So please subscribe, get yourself notified, smash the like button. I want to thank the great comment in the comments section. PATC community, let it rip today. I appreciate it. And of course, the great phone calls once again. So keep your head on a swivel. We could be coming on live later tonight. If not, we're going to be coming on live tomorrow. We've got so much to cover. Plus, we're going to be dropping an early peak Cloak and Dagger episode for our members. It's going to be an important one. I want you to listen to it. Go to the description box. Hit the link. And then hit the join button and become a member of our Rebel Outpost College Football YouTube channel. Thank you all so very, very much for being with us for, I don't even know how many hours we've been on, but 7.5 hours. I do appreciate you all coming in. You guys are what makes it special. You ladies and gentlemen are what makes this college football YouTube channel so very special. I appreciate it. Until next time, which could be very soon from now, after I eat some pork ribs. Until next time, from all of us at PATC, to all of you, please, you all take great care of each other. Thank you so very much.